has peaked and has been lower than we have ever predicted, putting our energy security at risk. Also, let's be clear, if we don't use gas until we have renewable energy, we will have to rely on coal. The other side of the House seems to be happy with this, or maybe they're trying to mask it with their virtual signalling, but the reality is we need thermal generation until we can get our renewable energy on track. When we're looking at emissions, and we've heard cries of flooding in Spain and the effects of climate change, when we burn coal, it emits up to 75% more carbon dioxide than if we do gas. That means if we look, 93 to 103 kilograms of carbon dioxide per thermal unit if we use coal, and that is 53 kilograms if we use gas. Some might argue that this bill is a step backwards in our climate change efforts, but let me reiterate, if we burn coal, we are producing 75% more carbon dioxide per unit of energy produced. Natural gas does produce carbon dioxide, but it's a vital transition fuel that will help us achieve our ambitious goals of a net zero emissions by 2050. We need to work to double our renewable energy, and I think nobody is disagreeing with that, but that is why we need the fast-track legislation, because we've seen this winter, when the lake levels are low, the sun isn't shining, the wind isn't blowing, that we actually need a backup source. Gas provides a reliable source of energy to supplement those renewable energy. Without gas, we risk the increased reliance on coal, which is a more polluting fossil fuel, or we face switching off our power altogether.
Well done, Hamish. Oh, great contribution.
Ruben Davidson.
Thank you, Speaker. It's not a pleasure to stand to take a call on the Crown Minerals Amendment Bill, and I think there's some irony in the fact that it says on the wall that it is the 5th of November 2024, when the rest of the country is ahead of us, being the 6th of November 2024. It's very, very appropriate because this is absolutely an act from the past. This is literally time travelling back in this bill, a giant step backwards for good governance. And the fact that the other side of the House are comfortable with that isn't lost on anyone. So let's start by looking at the process taken by the Economic Development, Science and Innovation Select Committee to consider the Crown Minerals Amendment Bill. 2 words, rushed and rammed, because that's the way it was put through that Select Committee. It was rushed and it was rammed. Select Committee had the opportunity to extend the submission window, to allow people to have adequate time, people who live in the areas most affected by this legislation. And the Economic Development, Science and Innovation Select Committee said no. They had the opportunity to form subcommittees to be able to hear more submissions, and the Select Committee said no. That is not an open-minded Select Committee. That is not a Select Committee decision that respects democracy. However, there are great people who, given the 4 days, the 4 very limited days available to make submissions, made submissions in the thousands. And I think it's really important that as this legislation is rammed through the House, that we take the time to actually revisit some of those submissions here. And as we get into those submissions, let's not lose sight of the fact that 96% of those submissions were opposed. I'll share a submission here, or extracts from a submission from Te Kotahi Tangamarai, that expressed full and unwavering opposition. that stated that the duty of care to protect and advocate for our marae and rural coastal community, which faces the direct impacts of climate change, including rapidly rising sea level, that threatens the very land we live on and the future of our people. The exploitation of Papatūānuku cannot be allowed to continue. By allowing further fossil fuel extraction, this bill directly undermines our role as kaitiaki and threatens the sacred connection we maintain with our environment. The submitter from Te Kotahitanga Marae called on the Economic Development, Science and Innovation Select Committee and on members in this House to listen to the voices of our environment, of our community and our tūpuna. We were listening. I'm reading a submission because so many of these submissions were not heard, but I'm pleased to hear there is a member listening this time. And I'll read a whakatauki because I think it's incredibly appropriate in the context of this submission. Mā te rongo ka mohio, mā te mohio ka marama, mā te marama ka mātou, mā te mātou ka ora. Listening equals knowledge, knowledge equals understanding, understanding equals wisdom, wisdom equals well-being. I am reading that, but you are listening, and it's an important message that you should hear. There's another submission here from the Worldwide Fund for Nature New Zealand that states very clearly, international scientific consensus is that the use of fossil fuels for energy consumption is the leading cause of climate change, responsible for more than 3/4 of global greenhouse gas emissions. A 2023 report from the United Nations Intergovernmental Panel on Climate Change makes plain that the world is unlikely to meet global targets unless urgent action is taken, with both the UN Secretary-General and the IPCC calling for the world to phase out coal, oil and gas. Phase it out, not start promoting the exploration for it again. And I'll finish on a submission that was light when it was submitted, but that had high impact when it was delivered to the Select Committee. And this was a submission from Benjamin Neville from Dunedin. And he said, I cannot accept that different people, he actually said, lucky I'm reading, I can accept that different people can hold different views on what is best for the country. But to ignore the wealth of scientific evidence about the huge risks to all of us that further fossil fuel extraction and CO2 emissions will cause is just negligent. Now, this was a succinct submission from Benjamin Neville, but it was delivered in a powerful context. He was knee-deep in floodwater in a Dunedin street as he delivered his submission to the Select Committee. And the fact that events like those recent floods in Dunedin are a direct result of the climate change that the scientific evidence is telling us is because of the exploration activities that this government is ramming back through should not be lost on members. If you want to have his message reiterated, I'd suggest you tune in to the song that he chose to play at the end of his submission, and it was a very appropriate piece of music to round off an excellent submission from Benjamin. Now, there are 3 things that I want to finish by focusing on. 3 very, very good reasons to object to this giant step backwards. Firstly, starting the re-exploration and the promotion of exploration will slow down our transition to renewable energy. And whilst this may be refuted by members on the other side of the House, it should not be lost on anybody that Blue Float, on news of this exploration being back on the table, removed their wind generation development plans from New Zealand's shores. And they stated it was because of the allocation of seabed. So offshore wind power generation off the table because of the actions of this government. Secondly, trade agreements and our international reputation are at risk. This giant step backwards is damaging our brand internationally, damaging our environment, and undoing the excellent work that Labour in government did with international trade agreements. Why would you put all of that at risk for this bill? Hard to understand. And the other, I think, which should not be lost on anybody, is the huge burden of clean-up costs on taxpayers. This bill weakens the mechanisms to hold the large companies liable for the damage they could cause and for the huge collateral damage that could be caused to our environment as a result. The trailing liabilities removals and the changes to those clauses make it very, very easy for big business to step away from their obligations to responsibly manage environmental impacts and damage from this very, very risky practice that the rest of the world is rightly walking away from. So I'll finish off by expressing the strongest possible opposition, because the Crown Minerals Amendment Bill disrespects proper process. It disrespects mana whenua. It disrespects those who submitted to the Select Committee, 96% of whom were opposed. And it disrespects our environment to take such a backward step, to be so reckless, to be so short-sighted, and to not have the future of New Zealand as your focus.
Katie Nimmin.
Speaker, let me tell you a couple of things I think that are really important to not leave out in this argument. We, as a government, are very ambitious about a couple of things, and I'm going to share those two things with you today. One of them is doubling renewable energy sources, and the other one is doubling the value of our export market in the next 10 years. Now, we can't achieve the second one without doing a few things. The first aspect is making our economy more productive. Now, we're working on that, we're building roads, and it's all very exciting. We're going to get people places faster. The other thing we can do is reduce the cost of producing. Now, a big impact of the cost of producing is energy sources for manufacturing. Now, in my electorate, we have PAMPAC, and we know that when the energy prices were at their peak, it was about $400 a megawatt. And then a couple of weeks later, down to $9.38. Businesses can't cope with that, and in fact they can't, because that's why WPI closed. And so we want to have high value incomes for our people. We need to have sustainable energy to do it. Now, the member opposite said the international advice is that we phase out. Well, the government former did not phase out, they just stopped. And now we are dealing with the perverse outcomes. We have to make sure we are making smart decisions, and we cannot double our renewable energy sources overnight. So we have got to work with what we've got so we don't have the perverse outcomes. So it is very, very important that we work with what we've got and we make sure that we have a productive economy and we can contribute to the global economy and grow our GDP, and this is all part of the sustainable plan. Thank you.
The question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. No. The ayes have it. The party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Party Māori.
E ono ngā pōti whakahi.
The ayes are 68, the noes are 55. The motion is agreed to.
Crown Minerals Amendment Bill, second reading.
This bill is set down for committee stage next sitting day. I call on Government Order of the Day number 6.
Contracts of Insurance Bill committee stage continued.
I declare the House in committee for further consideration of that bill.
Raring to go.
Right, good morning members. The House is in committee for further consideration of the Contracts of Insurance Bill. When we were last considering the bill, we were debating part 2. This is the debate on clauses 10 to 69, disclosure duties and schedule 2. Once again, the question is that part 2 stand part.
Madam Chair.
Aruna Williams.
Good morning, Madam Chair, and thank you for the opportunity to take a call in this debate. Since last the House was debating this part in part 2, and my questions will be particularly around clause 7 and clause 11, which there are some unanswered questions still remaining. We were considering that the Labour members of the Select Committee had been supporting this piece of legislation because we believe in a consolidated piece of insurance law in New Zealand. It's well overdue and it's something that is much needed in this area. But there were some major issues which we felt needed to be addressed at this stage and haven't been amended. And that is why we now will go part by part to consider the meaning of particularly those things which were changed not only by the committee at the Select Committee's consideration in response to submitters, but also by the Minister in his changes from the previous government's work on a prior iteration of the bill. Now I'll bring the Minister first to the unanswered questions around the conflict of laws points. Before the House rose, we were in consideration of the impact of Clause 7's changes on small businesses, particularly the meaning of the change to 7 subsection 2.
So can the member explain, so clause 7 is in part 1.
I am sorry, Madam Chair. I was intending to speak to clause 11 and I will do so now. Okay. Thank you.
Thank you.
Very good.
Clause 11, thank you for your indulgence, Madam Chair.
That's okay.
Clause 11 has been deleted, which walks back an important provision in this bill, which was a consumer protection, and it related to setting out what the meaning of consumer insurance contracts are here. And the reason I was mistakenly bringing the Minister back to our discussions previously in the House about that section is because it has an impact not only on consumers but also on small businesses and anyone who's not included in the definition of the contracts of insurance as they are now. The Minister needs to give the House a better understanding of how this will impact on not only consumers but on small businesses, particularly if now under the new definition of what a consumer insurance contract is, if we're not then carving out the way that these contracts will impact on businesses, but also those businesses that rely on insurance contracts to then pass on the benefit of an indemnity to their customers or clients, say if they're a lawyer or an accountant, then how will that impact on consumers downstream? And the effect of removing that clause 11, though there are other provisions in the bill, it never takes it back up to that protection that was allowed by clause 11 in part 2. We'll start there.
Honourable Dr Duncan Webb.
Oh, thank you, Madam Chair, and it's good to be here again. And I note, just for the House, that eminent scholar Robert Merkin King's Counsel from the UK is following this debate very closely, Minister. He expresses some disappointment in some of your decisions, but is gratified that some of the suggestions that he made, and I understand he's been in touch with the MB, have been adopted. But he has been in touch and is very interested in the progress of the debate. I did have to explain to him that the Minister hasn't yet adopted any of the amendment papers on the table, but there is still time. I did want to talk to clause 30, which has an amendment paper in respect of it, and that is the clause relating to burden of proof. And it notes there that in the bill itself that the insurer has the burden of proof that a qualifying misrepresentation was deliberate or reckless. And that's normal. That's actually just the civil standard of proof. Anyone who wants to assert something naturally has the job of showing that it is that is the case. It's not for an insured policyholder simply in response to you told fibs to prove that they didn't. So that's well and good. But my amendment paper just goes and really reflects, which is in some of the common law, and that is that the standard of proof takes into account the seriousness of the allegations and essentially the likelihood of it occurring. So my amendment paper suggests that an additional subclause 3 is inserted, which would state that where the insurer claims there is a deliberate or reckless misrepresentation, the standard of proof is that the court must be satisfied on the balance of probabilities, taking into account the seriousness of the allegation and the gravity of the consequences. So, essentially, if what's being asserted is a fraudulent lie, then that's a very serious allegation. And there's a strong presumption against that happening. It's not a criminal presumption. It's really important to note. This isn't some kind of beyond reasonable doubt, but it's saying it's balance of probabilities, but in determining how likely it is that that would happen, you have to kind of take cognizance of the fact that people don't lie in their insurance policies as a matter of course. The reason for that is there's very serious consequences. So when balancing the scales of evidence, you need to recognise that tipping on the scales against that being the case are the fact that people don't lie, and then look at the evidence presented by the insurer that there may have been a lie and weigh it accordingly. Now, burden of proof and onus is always a little tricky, particularly because it's also important to recognize it's not some kind of sliding scale. It is still just balance of probabilities, but it's really clear in the cases that you need to be alert to the fact that this is an unlikely thing to happen. And my concern is this, that if you're going to codify burden of proof by putting it in the legislation here, then you need to also codify the kind of common law gloss on that, because it's going to look like that's it, there is no more. And it's clearly not the case, and there's been plenty of decisions both overseas and in New Zealand that do that. So I won't go on. I got told off by one of the former chairs for just trying to fill 5 minutes, and I'll wait for the Minister to respond.
Questions are really good. Thank you.
Madam
Honourable
Chair.
Andrew Bailey.
Thank you, Madam Chair. Just first of all, just responding to Ms Williams's question. She was a very active participant in our last round, but I think without trying to highlight it, she wasn't here for the discussion around Clause 11. So we traversed that.
Might be better to
extensively.
say that she may not have.
She may not have been available to hear it.
Yes, thank you.
But I know she was a very active participant. With regard to that new clause raised by Honourable Dr Webb, I think the first driving clause is the first section, 30(1). The insurer has the burden of proving that a qualifying misrepresentation was deliberate or reckless. That's a pretty important statement. So that's one of the clear things that this bill seeks to do, is to be clear about the obligation of the insurer, not only to make sure that documentation is clear, that the insurer has to ask the right question. It's not up to the policyholder to determine what was right or wrong. That's a key part of the change. And this is the sort of the third leg to that. And quite simply, in response to your SOP, it's simply not needed. And I note that the member has proposed in a number of his SOPs that he seeks to define the role of how the court should approach this different pieces of litigation, should it get to that. We are not proposing to do that. It's very clear what the principles are, and it's common practice and the approach of the bill to leave it to the courts to decide. There is a normal civil burden of proof, and that's why the bill has operated at that level and is consistent throughout in adopting that. Leave the courts to make their own decision. The framework is there for be very clear about what is the operating framework for that decision making, but that's been the approach of the bill.
Lan Farm. Thank you, Madam Chair. Good morning. I really take the Minister's comments about, wanting clarity with this bill. And I would love to hear from the Minister whether he would consider the adoption of this amendment to Clause 14. Now, this is Clause 14(2)(a), which seeks to replace the word dishonestly from 2A. So this is a misrepresentation made dishonestly must always be taken as showing lack of reasonable care. Now, the Green Party proposed to replace this word with fraudulently. Now, we're doing this because the word fraudulently, if I can get that out properly, sets a more appropriate, clear and specific standard for policyholders to actually show reasonable care. Now, these policyholders, we know that they have this duty of reasonable care not to make a misrepresentation when actually entering into these insurance contracts. And an honest mistake really, I don't think, should be grounds to deny insurance cover. Now, the bill actually previously stated that misrepresentation made fraudulently must be taken as a lack of reasonable care. However, we really disagree with the Select Committee's change to this to replace fraudulently with the weaker and vaguer term of dishonestly. So what we're really clear about when it came to submissions that came before Select Committee was the submission from the Insurance Council of New Zealand, and they argued that fraud and dishonesty are really different concepts. They stated that, and this is a quote from their submission, dishonesty and fraud are related but distinct concepts. Dishonesty is a broad term that refers to actions that are not honest or lack integrity and can manifest in many ways, including lying, omitting important information, or otherwise misleading someone. Whereas they say dishonesty does not necessarily involve a deliberate attempt to deceive for personal gain. Now, this is really kind of serious definition content, and I think it's really important that we take the advice of the experts in this field in actually clarifying these definitions. So I'd love to hear from the Minister whether he would consider the adoption of this amendment to improve the clarity.
Madam Chair.
Honourable Andrew Bailey.
Yeah, thank you. Again, we've actually traversed this statement. I've discussed it before, but just to reiterate what I covered previously, it is an important definition, and the member's right to raise it, but there are different tests, and they're quite distinct, and one has a criminal implication, one has a civil implication. So fraud is used in civil compared to criminal cases, so the meaning is much less clear. The criminal standard of fraud describes crimes for personal gain or deprive someone of something by deceit. This implies criminal behaviour proved to a criminal standard of proof, which is different from civil, by the way. which would not be appropriate here. The civil law standard of fraud, which we are focused on, wider is in civil law. So it's been quite deliberate why we've used this definition, because the test is different and it's actually much more appropriate, because we're not talking about criminal stuff, we're talking about civil thing. And actually, like the bill, the UK legislation uses dishonestly to discourage deliberate wrongdoing. So again, it's, I'll just reiterate, we have covered it, but it is quite a deliberate approach.
Aruna Williams.
I want to take the Minister to Schedule 2. The empowering provisions in the underlying Act sections 27 and 52 for Schedule 2, so it is in this Part 2 that we would be debating Schedule 2. In Schedule 2, the first part that I want to ask him about is Clause 2. It does relate to the question that Land Farm has posed in one of the amendments that Labour members indicated was a priority amendment for us, which is the question of fraudulent or dishonesty and what is the appropriate standard. We disagree with the Minister very strongly that dishonesty is the appropriate standard when in fact fraudulently was used in a prior iteration of the legislation. But the question I want to ask him is about now, if we're speaking about insurers' remedies for qualifying misrepresentations or breach, how the change from fraudulent or that standard to one of dishonesty then plays into what the appropriate remedies are as described in Clause 2. Because Clause 2, Madam Chair, at A, gives the insurer the ability to avoid the contract and refuse all claims. But the question that I want to pose to the Minister, if the original standard for what is a qualifying breach required a standard of fraud, so in a fraudulent situation you have a consumer, say, or someone making a claim under a contract for insurance, using a document to deceive another party in order to gain something of benefit to them, that is the fraud standard, then that standard that's described for insurers' remedies at 2A in Schedule 2 would have meant that a refusal of claims and the avoidance of the contract would have been related to that fraud in some way. So, for example, the example that I'll pose for the Minister to engage with, and I'm interested in his views on this, is if someone like me who has a contract for insurance for my car, my home and contents, and my home's value with one particular insurer, if I was to make a mistake on one of, say, my disclosures to do with my car, whether the dishonesty standard would apply to my other contracts of insurance, whether that would apply to, say, a claim for the roof of my home in a weather and storm event. Because in the case where the primary legislation sets out a fraudulent standard, in that situation I have committed absolutely no fraud because I have not intended to deceive an insurer and get a benefit for myself by making a mistake with my car insurance on a benefit to me related to my home insurance. But in the context of now a double a standard of dishonesty on both counts of the disclosure, and then in Schedule 2 a dishonesty standard related to the insurer's remedies, do we now have a situation where any dishonesty in an insurance relationship voids the entire relationship? Because the initial legislation surely was not drafted when the intention of the legislation as it was drafted was to protect consumers, to create a situation where disclosures in one kind of insurance or disclosures on a particular thing might impact your entire cover. And, you know, this might happen not just in that context of cover in one situation for another kind of contracts with the same insurer. It might be that you've made a disclosure, even in your health insurance, about your health that had no intention to get cover for yourself in some way. You know, it might be, say, a health insurance contract for me and my husband, where my husband is the insurance holder. This is a real situation for me because he is the primary insurance holder, and I tried to claim on it the other day and the insurance company only wanted to deal with him. What's that about? In the situation where the person who has made the disclosures is giving the most honest and most factual information that they possibly can, but they are under the wrong impression, or there is some dishonesty there because they have come to the situation with clean hands, but they have given the wrong information with absolutely no intention to receive a benefit that they were not entitled to. Can it possibly be the case that this Part 2 in Schedule 2 creates the wrong standards? Madam Chair.
Honourable Dr Duncan Webb.
Thank you, Madam Chair, and just good to move on. And I'm just obviously this is a very complex piece of legislation, and the Minister's done a great job in picking up my good work and coming up with many hundreds of clauses which deserve careful examination given the importance to the commercial sector and everyday New Zealanders. So I'm very glad to be here and to talk to Clause 35 in terms of what must be disclosed. Now, most of that clause is pretty straightforward, but there's one which I think deserves further elucidation, and that's in Clause 35(2)(c). And my amendment paper identifies that, and that's that the insurer, what the insured or, let me go back a step. Clause 1A, what the insured ought to know. Now, there's a real question in these ought to know propositions because the question is this: is it what that policyholder, to use the modern word, ought to know, or is it what a reasonable and objective policyholder ought to know? And that's two quite different standards, because if you think of your reasonable and objective policyholder or the reasonable person test, or if you want to take the Fair Trading Act framing, the slightly dim consumer, but the fact of the matter is that there are some policyholders who the insurer should know are less adept than others. And they may be people with English as a second language, or who have very modest educational achievements and present in a quite different manner. So my proposal is, rather than just saying that the policyholder ought to know, to replace that to reflect the fact that it's not a objective, reasonable policyholder test, which is essentially a gendered and race-based test, because you're like, okay, let's take a white bloke and what they ought to know. It's that's actually where the common laws come from on that. The man on the Clapham omnibus is the reasonable test. I think that's right, Aotearoa Williams. And rather replace it to recognise that it's what that policyholder ought to know, and introduce a subjective element. So my proposed amendment is to change or ought to know and insert or that a policyholder of the kind and in the position of the policyholder would reasonably be expected to know. So that's actually a much fairer test, because it then means if someone makes a mistake and they don't know it, but a reasonable policyholder would know that you're expected to provide this information, or that a car of that kind has this defect, or whatever it might be. Then the question isn't whether I, a reasonable policyholder, it's whether that particular person in their instances. And it cuts the other way, because if you're and this is the problem with sophisticated people taking advantage of consumer law. If you're a very clever business person and you know all about insurance, thank you, you're expected to know more. So it's a much fairer test, and actually it isn't anti-insurer in any way. It simply says it's contextual, and that's a much more modern and appropriate approach to take to that question. Kia ora.
Mr. Chair.
Honourable Andrew Bailey.
Thank you, Madam Chair. Just deal with perhaps that one, which is an SOP from Reuben Davidson. I think that's the one you're referring to. Look, this has had a lot of consideration about whether the use of the term ought to know, and there's obviously a proposal in the SOP. But look, ought to know is an important term that is actually defined in clause 44, as no doubt the member knows. This requires policyholders to conduct a reasonable search of available information, which is a key element of fair presentation duty. Now, that's a really important part, and what we've adopted here is in line with the UK model, so I think we're in good space adopting both the UK approach, but also making sure that we've got clear definition in clause 44. I just want to return to Ms Williams's question, which again I've actually dealt with quite on a number of occasions, but just briefly to deal with this, a civil law standard of fraud is wide. In civil law, fraud is knowing a statement is false or recklessly not caring whether it's correct or not. We've adopted, obviously, the dishonest approach is a high threshold. It would require intent and not capture consumers simply being careless or made an honest mistake. And I think one of the things about this bill, and I think just moving right back up, what we've sought to do in this bill is be very clear that the obligation on the insurers, first of all, to present policies in an easy to understand presentation, so you don't have to look through lots of terms and conditions. The second key issue is it is up to the insurer to ask the right questions. It's not for the policyholder, whether it's you or a husband, to determine what is the right answer. Did I have my tonsils out? Do I have to disclose that in a health application? Is it relevant or not? That's not the obligation of the consumer or policyholder. This is the most important shift of this bill, to move it, the obligation to the insurer. But thirdly, the third major part of this bill is being clear that in the event that there is someone has filled out a form and it's unclear what the position, we have been clear about the scale of the remedies and how that should be done. So if there's gross negligence on behalf of the policyholder or recklessness or whatever, then the insurer has no obligation to pay the claim. If there was a honest mistake made, but it wouldn't have had any direct bearing on whether the insurer accepted the policy or not, then the policy amount will be paid out in whole. If there was an element that if the insurer knew about it, and it may have had a different, it might have resulted in a different premium, then obviously that premium adjustment will be made and deducted from the due amount. But ultimately, there will be a payment made. So being absolutely clear about the three areas where when the insurer has to pay out and when they do not is a third important part of this bill. So I think we've struck a good balance with this bill.
Madam Chair.
Ryan Hamilton. The question is that debate on this question now close. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. A party vote has been called for. Please, Clerk, conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
ACT, New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E ono ngā pōti e whakahi.
The ayes are 68, the noes are 55. The motion is agreed. The question is that Honourable Dr Duncan Webb's tabled amendment inserting new clause 11 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote is being called for. Please, Clerk, conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT, New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōti e whakai.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to inserting new paragraphs C and D in clause 12(1) be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. A party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
E ono ngā pōti whakai.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Ricardo Menendez March's amendment to clause 14 set out on AP number 107 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. A party vote has been called. Please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōti whakai.
The ayes are 55, the noes are 68. The motion is not agreed. Aruna Williams's amendment to clause 14 set out on AP number 109 is ruled out of order as being the same as an amendment previously not agreed to. The question is that Honourable Duncan Webb's 3 tabled amendments inserting new subclauses 4 to 6 in clause 14 be agreed. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. A party vote has been called for. Please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New
15
Zealand.
votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōti whakai.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment inserting new subclause 3 in clause 30 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. A party vote has been called for. Please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in support.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
E ono ngā pōti whakai.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Reuben Davidson's tabled amendment to clause 35(1)A be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. A party vote has been called for. Please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
E ono ngā pōti whakai.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Reuben Davidson's tabled amendments to clause 36(1) be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. A party vote has been called for. Please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
E ono ngā pōtia whakae.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 37 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. A party vote's called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in support.
ACT, New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōtia whakae.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Reuben Davidson's tabled amendment to clause 38 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. A party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes are in support.
ACT, New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōtia whakae.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Reuben Davidson's tabled amendment to clause 42A, that is 402A, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. A party vote's been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes affirmative.
ACT, New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōtia whakae.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Reuben Davidson's tabled amendment inserting new paragraph C in clause 42, which is 42, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. The party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes are in support.
ACT, New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
E ono ngā pōtia whakae.
The ayes are 55, the noes are 68. The motion is not agreed. Helen White's tabled amendment to clause 43(2)C is ruled out of order as not being in the correct form of legislation. The question is that Helen White's tabled amendment inserting new subclause 3 in clause 46 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. A party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in support.
ACT, New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōtia whakae.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Helen White's tabled amendment inserting new paragraph C in clause 47 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. A party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
A Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT, New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōtia whakai.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment inserting new clause 50A be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. A party vote has been called for. Please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōtia whakai.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment amending clause 52(1)(b) be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. A party vote has been called for. Please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in support.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōtia whakai.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment amending clause 56 be agreed to. All those in favour say aye. To the contrary, no. No. The noes have it. Party vote call for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōtia whakai.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment inserting new subparagraph 3 in clause 57A be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. The party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōtia whakai.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment inserting new subparagraph 3 in clause 58(2)(b) be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. A party vote has been called for. Please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōtia whakai.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment inserting new paragraph 3 in clause 59(2)(b) be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. The party vote has been called for. Please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōtia whakai.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment replacing clause 60 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. A party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act, New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 61(1)(a) be agreed to. All of those in favour say aye. Aye. To the contrary, no. No. The noes have it. A party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act, New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōtia whakae.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 62(1) be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act, New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōtia whakae.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment inserting new clause 62(a) be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote is called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act, New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti
Ono ngā
Māori.
pōtia whakae.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Arena Williams's amendment set out on AP number 110 be agreed to. All those in favour say aye. To the contrary, no. No. The noes have it. A party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act, New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti
Ono
Māori.
ngā pōtia whakae.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment deleting clause 63(5) be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. A party vote has been called for. Please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act, New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti
Ono
Māori.
ngā pōtia whakae.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 68(3) be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. The party vote has been called for. Please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand
8
First.
votes opposed.
Te Pāti Māori.
Oro ngā pōti e whakai.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Part 2 stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. A party vote has been called for. Please, Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
ACT New Zealand.
11 votes in favour.
New Zealand
8
First.
votes in favour.
Te Pāti
E
Māori.
ono ngā pōti e whakahe.
The ayes are 68, the noes are 55. The motion is agreed. Members, we now come to Part 3, and Part 3 is the debate on clauses 70 to 99, contracts of insurance, and Schedule 3. The question is that Part 3 stand part. Point of order.
Oh, thank
Honourable
you.
Dr Duncan Webb.
Thank you, Madam Chair. I just would seek your guidance. On this side of the House, we're a little perplexed as to why the Chair considered the debate to be exhausted on Part 2. In particular, we were meticulous in not repeating, keeping our speeches to the point and progressing through the part in a very orderly fashion. While the Minister may have repeated some policy principles time and again, the questions put to him, and this is a detailed bill, and we consider it requires considerable scrutiny. And as we approach Part 3, we certainly want an opportunity to go through each and every clause that we consider is worthy of debate. And
Thank you for the point of order, Dr Webb. As I was here listening in the chair, yes, I could see from the amendment papers that there was a little bit of a structure, but the questions were becoming very competitive, and a lot of it was deemed to have been answered. And given that we'd actually had a session on this back in the last, I also had the boxes of things that had been discussed last time, and it seemed to me that we weren't covering any new material. But if the members are clear in terms of Part 3 and making it very clear that it's not repetitive and you are looking at clause by clause, then that is a process that we do look at. Yes, Ricardo Menendez-Mark speaking to the
Madam
point
Chair.
of order.
Thank you. Just to get further clarification, because I think there's a distinction here between the Minister giving repetitive answers and then the questions being repetitive.
I actually was finding some of the questions were overlaying some of the questions that had been previously answered. So we have a sheet up here of the previous debate as well, and I also accept that because we've had a break in parliamentary process between that, I was deeming that we were starting to get repetitive. So as we start Part 3, very happy for Dr Duncan Webb's suggestion of following a process.
Would it be helpful if we continue pointing out which clauses and subparts?
It would be very helpful. Thank you.
We can do that.
Thank you. Arana Williams.
Madam Chair, thank you for the opportunity to take the first call in this Part 3 of the debate, which I'm sure will be a lengthy debate as members on this side of the House want to traverse the issues that have been raised. My question is about Clause 70. It's particularly about subsection 2 of that part. But before I ask this question, I need to give some further context, because we've had the Minister answer time and time and time again about the rationale for a change between the previous standard of fraudulent to dishonesty, and has reiterated that it is the appropriate standard in his mind. Many of the questions in this part, including my question on this, will relate back to that change that was previous in the Act. And the change that the prior change has created in the Act other parts of the framework. And I'm not asking him whether that change was appropriate. He's answered that it was appropriate over and over again. I'm asking him whether it is still good for consumers, whether this law in fact advances the position of consumers under this Act, which is something that he has said to media, that he has said to this House, and he has assured parliamentarians in other statements. I'm asking whether the changes to these clauses under Part 3, when they interact with the other changes in the Act which have already been traversed, are now the right changes to make, given that change was made. Given that this Act was drafted around a standard of fraudulence required as the standard of mistake on the part of consumers, whether now the protections that are in place for consumers are strong enough, and whether the remedies available to insurers are too generous, given that the standard is now different in other places of the Act. So to Part 3, to subsection 2 of subclause 70. This is a question that genuinely had different understandings in the committee room around what the submitters were asking for here. So my first question is to the Minister, does he know what submission this change arose from? And what stakeholders were calling for this change, and is he satisfied that this is a good change for consumers? Then secondly, to actually understanding the point and clarifying for the committee the different understandings of what this meant, because it is surely a subject of litigation in future, does a reasonable time period for an insurer to settle a claim, a reasonable time that we might expect a homeowner to receive their payments in a situation like the Christchurch earthquakes, or a reasonable time for an Aucklander to get their roof fixed in the Auckland floods, does that reasonable time period as a whole get considered, and then the time to assess the information get included within that reasonable time frame? Or does his change mean that there is a reasonable time to assess the information, and then there is a reasonable time to make the decisions as the insurer? And this is material because what this bill should seek to do, if it is in the interests of consumers and actively advances the position that consumers are in, it should make the time frames condensed. It should give every New Zealander some confidence that their insurance claims will be dealt with in a timely manner. And so he should be able to stand up and give the House a simple assurance that this reasonable time frame does condense the time frame, and that the reasonable time frame also, that is to be assessed as a whole, and that getting the information doesn't step that out at all, and it should be included when the court considers what a reasonable time frame for consumers would be, that they should consider the whole time based on what kind of consumer we've got here. Are they vulnerable? Are they a little old lady? What would be the appropriate time frame we would expect her to have her claim solved in? And then carve out the time it took them to get the information. No. Doesn't matter if she didn't have her documents in order. Doesn't matter if it was difficult to contact her on the phone because her power was out. That there is a legitimate responsibility there for the insurers to make sure that they've got boots on the ground, that they have got people making the assessments on time, and that they are in there working with consumers no matter what the circumstances are, because that is what consumers should expect in New Zealand.
Ricardo Mendes-March.
So looking at subpart 1 implied term of about payment of claims, and then clause 70 implied term about payments of claims, and then subclause 1, 2, 4, particularly looking
at... Can you repeat those subclauses again?
Yeah, so looking at clause 70, subclause 1, 2, 3 particularly, I wanted to unpack and follow on Arena Williams' contribution to also ask about what considerations has the Minister given around the impact on claimants in relationship to what may be considered a reasonable time to assess and investigate claims, because obviously not all claims or types of insurance, when a claim is being investigated, will have such a strong flow-on effect in terms of someone's ability to, for example, make ends meet. And so I do note that as it's written, there seems to be, I guess, a lack of consideration around, for example, equity issues, around the the impact on the claimant, and I wanted to get assurances from the Minister whether he thinks that the way that it is written will adequately take that into account. And then following from Aotearoa Williams's comments, I'm also interested to understand the onus that is placed on those insurance companies to actually be adequately resourced to ensure that those claims can be investigated promptly and do not disadvantage consumers. Because so far the way that subclause 3 is written, it takes into account things like type of insurance, which you could make the, I'm interested to know whether that specifically could take into account my earlier question. And then there's other stuff around the size and complexity of the claim, the compliance with any relevant legislation, factors outside of the insurance control, and whether a sum due in respect of a part of the claim that is not in dispute has been paid, and then whether the insurer has reasonable grounds for disputing the claim, and particularly if, there is language that seems to be more on the side of the insurance company rather than the consumer, and I guess I'm just concerned about the reality that many consumers could be facing hardship while those claims are being investigated. If we look at the Auckland floods, that's a really good example of where people had to dip into the savings, had to get into debt while their claims were being resolved. And so, for example, the way that the language here is written, if I take the Auckland floods as an example, I simply cannot see how consumers' ability to literally sustain themselves will be factored in the language here. So clarification to reassure consumers that their ability to make ends meet, their ability, preventing people entering hardship will be factored here. So just to recap, this is very specifically on clause 70 and particularly subclause 3, but I guess 1 and 2 would also be factored into my questions.
Mr. Chair.
Dr. Duncan Webb.
I have a very short question in the spirit of the committee stage, and it relates to clause 70 and reasonable time. What is the remedy? If there's a breach, what's the remedy? And will the Minister adopt my amendment paper, which simply states once a breach has occurred, interest is payable on the insured or the insurance payable? It seems to be a very simple, fair remedy. It applies in life insurance. Why should it not apply in every other kind of insurance, particularly when the payment is clearly due? Will the Minister adopt my amendment paper so that insurance is payable on late payment of insurance?
Mr. Chair. Thank you. Look, the members raised very important points. And I think everyone in this House wants to make sure that policyholders get paid out in a timely manner. There is no debate about that. Everyone in this House will want to make sure that policyholders get paid out in reasonable time. The definition of reasonable time is a commonly understood and legal term. That's why we've done it. And the issue is, and I see there's a couple of other SOPs been put up as well. The issue we've tried to deal with is that what is reasonable time depends on the circumstance. So just to address Ms. Williams's question specifically, yes, taking into account time to collect information is all part of that, together with the assessment of the claim itself. So when a court will be assessing what is reasonable or have regard for both those items, it's not a separation between the two of them. Sometimes claims will be complex and they will require a lot of documentation. Others will be simple claims and they will not require a lot of time. And reasonable, that's why we don't want to adopt anything like a 12-month period, because in some cases that would be manifestly unfair to the policyholder. In other cases where it's a complex claim, that would be possibly a difficult task for any insurer to actually meet. So it's up to the courts to decide it. We're very clear about the principle. And just dealing with Honourable Dr. Webb's question around compensation, and there is under clause 70, policyholders have the right for late payment. They can apply for it. So if they deem that there is an issue about delay, unnecessary, undue delay, then there is clearly provided for in section or clause 70 that people can apply and get interest, late payment under the Interest on Money Claims Act 2016 to be specific. This bill does not interfere with that, but obviously references that and brings it into context. So that is the principle. I don't think there's any dispute in the House about making sure this happens promptly. I think we've struck a good balance about making sure that insurers do act promptly, but policyholders are also recompensed as quickly as possible.
Francisco Hernandez.
Mr. Chair. And I'm just seeking a short call just to elicit some, I guess, basic factual information from the Minister, just to enable this House to, I guess, get the information in context to help us judge reasonable time. Can the Minister please, through the officials, or if the Minister themselves knows, inform the House what the shortest time has been to pay a claim, what the longest time has been to pay a claim, and what the average time tends to be, because that will be, I guess, very helpful as we sort of explore this question around Part 3, subclause 17, subclauses 1 to 3. So, thank you.
I'm not sure we, Mr. Chair, I don't think we actually have a view on, I'm not sure, because that's a commercial view on it. But look, the point is it needs to be reasonable in the context. As you will see, the member will see on subsection 3 of 70, there are a whole list of items that will deal with the complexity and therefore what is deemed to be reasonable time, and namely the type of insurance, the size and complexity of the claim, the compliance with any relevant legislation or guidance, factors outside the insurer's control, because sometimes there are factors outside the insurer's control that will delay settlement of that claim, and also whether in fact some due in respect to the part of the claim that is not in dispute has been paid, so maybe been advance payment. So again, there's another one as well. So that is why we want to take a flexible approach, and the courts are the best people or best organisation to determine what is reasonable in the circumstance.
Helen White.
It's actually very timely that I speak at this time because of the discussion about remedies. Because my questions are around, I looked at the clause and I thought the first thing that I can see is that clause 70 subsection 1 talks about implied terms, and in fact that seems to be a superfluous word, because it does look to me like this is a term of every agreement, not an implied term. So I'm interested in the use of that word, because it does seem that what we're doing, and I'd like your opinion on this, is we're creating a couple of remedies which are later in the section, which are talking about what you can have, but everything else seems to be up to the parties to decide in the contract itself.
No, cool.
And so I'd be very keen to hear you talk about how you would see this play out if in fact when there is a contract here and this is seen as an implied term, what happens if there are express terms in the contract which go to remedies which say you won't be getting this or you will be getting that. This is your claim. So yes, there is an issue in the later in the clause from what I can see, where you've got the right to enforce the payment and you've got the right to the interest on the sums.
Yeah.
But there, what happens if in fact the rights beyond that are not there? Now, my understanding is you've got people who are still waiting in Christchurch to be paid. So if the contract denies other rights, is that as far as we're willing to go? I'm not sure it's necessarily up to the courts to decide that, if in fact in the contract you have express terms which limit the rights of the person beyond what we would consider reasonable in that circumstance. And I'm concerned about where we've made the line here for your average consumer, when it will be in the devil will be in the detail of the agreement, and people will get creative about what they knock out of the suite of remedies that we would expect to be here. There's a time when it just becomes simply unreasonable. Is it going to become reasonable because there's an express term? Is it going to become an unreasonable remedy because it is put outside of the ambit by an express term? And I'd also like your comment, Minister, on the issue about the use of the word implied when we're actually saying it is a term.
Yeah. Okay.
Thank you.
Mr. Chair, thank you. I'm a little bit surprised because I know the member is a lawyer. And she, of all people in the House, should know what the value of the word implied. That means every contract, every insurance contract has that as an express element of that contract. So it's fundamental to every contract. Now, obviously there will be examples where there may be contracting out on a specific insurance policy, but remember some of my earlier comments in Part 2 states that it's up to the insurer to make sure that those terms are written in an easy to understand manner, so it's not the reference to lots of detail and terms and conditions. That's the change. Part of the fundamental change of this bill is to make sure that policyholders are not surprised by express terms taking them out of that implication. But the implied term cuts across every contract, and by putting that in as section or clause 70 subsection 1, it means that policyholders can seek contractual damages for a breach. So it's actually the best way of dealing with it.
Helen White.
I'd just like to take you up on that. Yes, I'm very familiar with the law around implied terms. And the fact is that implied term is usually an unwritten term that's so obvious it goes without saying. Now, we're not actually dealing with that here. We're dealing with something that's deemed a term in every agreement. Yeah. And so this seems inappropriate wording for me. And in fact, I would ask the Minister consider a little supplementary order paper, if I write one up, which says that it is a deemed term. And then the issue that I have raised beyond that I would really love to look at is, what do we do about making sure it's a fair deal for the consumer beyond these terms? Because there are a couple of things here. Is that a fair enough deal? I would wonder about that given the calculation of delay, for example. Is it a fair term when somebody has still not paid out a claim in Christchurch now, that we actually look at penalties for punitive damages in that situation? And I do get that there is in this, there's a reference to damages, but it looks like that is a case of whether your contract says it or not. And I'm not sure about that. In many areas of the law, you'd have this capacity for the judge to say exemplary damages, punitive damages, or we'd write it into the law that there was a penalty. And I suspect we think there should be a penalty in this situation where you get calculated behaviour. Delay is probably the best friend of many lawyers, is you just put it off and wear people down and they die and they go bankrupt and it actually they suicide. So we really need to make sure we're signalling in a law, if we're talking about something that is a deemed term, if we're saying that's it, this, you have to have it in, you're not getting out of this, then that's an important thing to follow up with something that is really us directing the court what to do or giving the court power to do it, not letting one party weasel out of it in its terms and conditions, which can happen. I'm not suggesting anyone is not acting in good faith, by the way, sir. I'm saying that this is a situation where we are going to have to be careful because we are dealing with a range of vulnerable consumers at maybe a crisis in their life, which is they've lost all their property. Thank you, sir.
Mr. Chair, thank you. Hey, look, just responding to the member again. Look, the use of the term implied term is very consistent. It's consistent with the UK approach and it's given rise to no issue. I think it's pretty commonly understood, as I said before, what that means. It means it is a fundamental tenet of every contract that there needs to be a payment in reasonable time. And just because it does, by writing that, it gives, as I said before, it gives the policyholder the right to seek damages, and also Clause 70 does not seek to legislate how the courts approach damages, because, again, I get the intent, and I made this point earlier to Honourable Dr Webb. The members opposite seem to be trying to try and anticipate how the courts will interpret each occasion and be specific about it. The fundamental approach of the bill is to be clear about the principles that people need to be paid out in a timely phase or reasonable time, and it's up to the court to decide in that circumstance what is reasonable, and so that's why I think the approach is very appropriate for this bill.
Arena Williams.
take the Minister's point that the intention of this legislation is to set out the approach very clearly. So I'm asking him this in good faith. The Section 71 of Part 3 is the arbitration provision that has been included in this legislation since the Labor government first drafted it, and since the formulation of what is an insurance contract that applies to consumers, since that definition has now changed. My question to him is he satisfied that 71 is the right formation for the arbitration provision, which excludes arbitration provisions being binding on policyholders specifically, now that he has changed Clause 6, which is the meaning of a contract of insurance, and the conflict of law provisions, particularly 7.2, that now relates to only non-consumer contracts, to the broader section of non-consumer insurance contracts, and not just the highly negotiated and highly commercial contracts of insurance.
Dr. Duncan Webb.
Oh, thank you, Mr. Chair. Just wanted to move to Clause 72, which has always been a tricky area of insurance law, and that's those clauses which set out a condition in the insurance policy about how a claim is to be made. And, you know, historically those clauses could be used quite unfairly to deny cover. And the law generally has taken a substance over form approach, so that even if a contract of insurance, and I know claims made policies are a little different, we'll come to those, but I know, you know, contracts of insurance sometimes do say a claim for motor vehicle damage must be made within 30 days, for example. And the law has, for a long time, taken the approach that insurers can't rely on those clauses unless the breach of the clause has caused some loss to the insurer over and above the insurance claim. So, for example, they can no longer find the person who crashed into the car, and therefore they can't recover, and so on and so forth. Therefore, they can reduce the claim by the amount of detriment they've suffered. And this seems to be reflected in the Clause 72. That seems to have roughly captured what I think was one of the Insurance Law Reform Act provisions. The difficulty I have is that, you know, the clause itself needs to be reasonable. So you could conceivably have a clause which, this is in one of the amendment papers, I think it's in my name, but you could have a clause which says you must make a claim for damage to your house within 7 days. And you've got a situation where it was damaged by a third party who then absconds, so you meet the test. But the 7-day limit itself is unreasonable. So my proposal is that a new clause 3C, which says not only must the insurer be prejudiced and it would be inequitable, but also, and the additional words are, and the provision referred to in subsection 1 was in all of the circumstances reasonable given the nature of the insurance and the identity of the policyholder. So it would actually be a bar on unreasonably tight timeframes or methods. The other one, because this would also cover it where it says you must make a claim by turning up to the insurance company in a red jumper and making the claim in writing, right? Kind of silly rules like that would be ruled out simply because they're unreasonable. But equally, notification it should be able to be made in any way. So a telephone call, an email, or an in-person claim should all be legitimate and reasonable. So unreasonable clauses which unreasonably specify how the claim must be made and when would be ruled out simply by that small addition. So I'd be interested, again, won't take up too much more time, but be interested in the Minister's approach to that.
Mr. Chair. Andrew Bailey. Hey, thank you. Just in response to Mr. Williams's questions around Clause 71, look, hey, this is a very long-standing provision. that it applies only to consumers, not to non-consumer. It maintains a status quo that arbitration clauses in them are not binding. That's a very common approach. It's always been that. And so we're pretty comfortable with that approach. Just with your clause, Honourable Dr. Webb, 72, first thing is this is a long-standing provision, and we actually had no feedback, as I understand, during the Select Committee. Everyone seems to be comfortable. Insurers already prevented from relying on a time limit unless it can show it has been prejudiced or this is inequitable. An additional reasonableness test is not required. And I must note, I think you must have had an epiphany because in your original bill you had this wording, but now you're seeking to change it to an SAP. So obviously some epiphany in more recent times.
Anina Williams.
Clause 71, and we get ourselves into some trouble in this committee stage because we do need to refer back to previous changes that have changed I guess what you could call the net between where we are sort of creating consumer protections on one side and then creating surety for insurers to rely upon in order to arrive at a balance that is appropriate in New Zealand law to codify what we have and then step out for consumers their protections, which is what the Minister has told media and has told ordinary people in New Zealand. That is what is being done by this bill. So it's right to interrogate the entire net and not only the provision. And so what I'm asking is not whether Clause 71 is the same as what it was before. I'm asking whether Clause 71 is now both appropriate in the Minister's view and good for consumers in the Minister's view, given his changes to Clause 6 and Clause 7, because those change who can use a consumer insurance contract and who now, where there were provisions that were designed to only apply to contracts of reinsurance, which are big insurance contracts that are negotiated between insurers of consumers and insurers of insurers, and so there are lots of lawyers in the room, and we can design provisions around those which are really designed for two commercial parties with a meeting of the minds where they are equally powerful and well represented.
Yeah,
and then we've designed provisions which should only apply where there is apparent balance. We've changed that net in clauses 6, 7, 8. Is the new provision appropriate in his view? Is the old provision at 71 appropriate in his view, and is it good for consumers?
Dr. Duncan Webb.
I wonder if I might talk now about claims made policies, which is clause 73. And there's just a little conundrum in there because it does talk, claims made policies are generally considered to be broad liability policies, policies that builders, lawyers, architects would have about claims made against them. And claims made policies are one method to define that the insurance covers the insured for claims made within a defined period of time. And one of the difficulties is the interface between those policies and clause 72, which says you're not bound by when a clause is actually, a claim is actually made. And obviously the whole underlying way a claims made policy works, the finances of it are that it's time limited. So the interface with that is kind of sorted out by clause 73, which gives a grace period. And all that's well and good. But I'm just concerned because many contracts of general insurance have a liability element as well. So, for example, a home policy, classic general insurance, will also cover for liability. So if you, I don't know, have a house fire, you know, that's general damage, you're covered, but it leaps next door and burns the house next door down. Well, that next door house isn't part of the insured property, but you're covered under your liability part of that policy. So it actually becomes a policy, and my concern, it becomes a policy for liability. And there's a danger in there if it's got a clause relating to when a claim must be made, the period of insurance, that it's seen it falls within a claims made this clause 73. So all of a sudden, the clause 72 isn't going to work for a liability, the liability part of your general insurance. So my proposal is for the amendment paper to be adopted, which adds to that clause 73 at the end of subsection 2, and the cover for liability is not ancillary to other insurance, such as general insurance over property. So I'm wondering if, because I'm a bit worried there's a gap in there, and it'd really be good to tidy that up.
Mr. Chair, so in answer to Ms Williams's question, yes, it is appropriate. In answer to Dr Duncan Webb's comments around, or proposed SOP clause 73, I'm not keen to accept that, and recommendation we shouldn't, because the Law Commission actually proposed the change, and the members' SOP would actually reduce or narrow the scope of it, which actually would be a disadvantage to policyholders. So I think it's actually going to end up with a perverse outcome. That's why I don't think it's one that we'd like to recommend, because we'd like to have the wider definition that the Law Commission recommended.
Dr Duncan Webb.
Mr Chair, I'll just take a short call, if I may, and it's actually, it's a real irritant of mine that we get these fantastic consolidation bills, and yet we're still using terms that are 300 years old. So I'm looking at clause 76, and who in the world, other than some knobby lawyer, would know what a pro rata condition of average is? And all of our knobby lawyers are nodding. Yes, I know what a pro rata condition of average is. Now, it's a perfectly simple thing. Yeah, and yes, the chair's not going to know, Mr Bailey.
Can you repeat that again?
I'll tell you what it is. A pro rata condition of average is a clause that says if you insure half the value of an item, then if it's damaged not to its full value, you only get that proportion of the insurance proceeds. So if you insure your house for $1 million and it's damaged to the extent of 500,000, then a pro rata condition, and it's worth $2 million. The pro rata condition of average says you share the loss in the proportion that you insured it. So you get half of the proceeds. So you end up being underinsured. Now, and here I am explaining this, and that shouldn't be the case. You should be able to read a piece of legislation on a consumer policy and know what it means. So let's not use the words pro rata condition of average, and I'm going to do you a favour. I've got two amendment papers, clause 76 and 77 use this clause. It should say a condition under which cover is granted in the proportion that the sum insured bears to the value of the interest insured. That's what a condition of average is. They're prohibited in home insurance, as they should be, but in commercial insurance, they're quite widely used, which avoids the insurer taking the first bit of the loss and then the insured getting the benefit when it isn't the entire loss. So that is absolutely insane that we're using Latin, pro rata, in condition of average, which is about a technical term as you could possibly get. Can you tidy it up for us, Minister? Be a sport.
We can't amend as much.
All right. Mindful that we are jumping around on clauses, so I did want to, before I go to clause 74, I did want to jump back on previous clauses that we've contributed to, particularly because it hasn't been addressed. So one of the things that I wanted to touch on...
Which clause?
So particularly clause... issues that have been arisen from clause 70, particularly subclause 3 and 4. And then I'll go into clause 74. Because the Minister, when addressing some of these issues, talked about how some of the tensions that we've tried to unpack around reasonable time, if I recall correctly, his words were that this has been canvassed by the courts. And I know that a lot of this relies on case law, like across the legislation. But I guess to me, the question was about whether the Minister thinks that particularly when it comes to consumer protections, the weighing up, sort of relying on case law versus, for example, having more prescribed language in the bill that actually gives certainty to consumers is actually better for both parties, but particularly for consumers, because I think, to me, like for a consumer having to rely on understanding what case law has said to be able to understand what they should expect seems actually quite unreasonable, particularly when we think about the circumstances in which some of those claims could have been made, like say after a natural disaster or extreme weather event. Like, it just seems to me like expecting a consumer to then go into case law to get a sense of understanding of what reasonable has been previously determined by the courts just seems like actually quite a high barrier that we're setting. And so I go back to my question around the lack of consumer protections and the language of this bill in relationship to what is considered reasonable. And so my specific question, I do think it's a new point, is whether the minister thinks that case law in relationship to consumer protections and defining reasonable time is actually good enough, considering, for example, that we will be seeing likely more insurance claims in relationship to extreme weather events. Now, if I jump to Clause 74, in relationship to ensure not liable to pay greater cost, my concern would be that, again, it seems to me that there is little consideration in the context in which often consumers will be lodging these claims. And so it seems to me like Clause 74 is there to mostly end up protecting the companies rather than actually giving greater flexibility around the context in which consumers may be making those claims. So I wanted to get a sense of understanding around, like how can consumers have certainty that if they're facing sort of really strenuous circumstances, again, I use extreme weather events as an example, that Clause 74 won't actually just disadvantage them because, if there could be many reasons, particularly if we look at subclause 1b, and then subclause 3, that these seem to mostly side with the insurer. So I just want some clarity around how he thinks greater flexibility could be, if at all, given to consumers when strenuous circumstances arise.
I don't know anyone else.
4A, which is a new subpart that comes under Part 3 of this legislation. It is brand new to the House's consideration. It was not introduced at the first reading. It is an issue that arose from submissions, and the committee came to a reasonably bipartisan, cross-party consensus around including. And I want to explain for the Minister before I ask him a question about why this issue is significant. There is significant individual public health and scientific benefits associated with the use of genetic testing, whether undertaken for individual health reasons or medical research. However, as submitters made it clear to the committee, the individuals in New Zealand who are potentially foregoing life-saving clinical and relevant genetic testing or not participating in medical research involving genetic testing for fear that it will impact on their ability to get insurance, particularly life insurance and health insurance. So the reason for the inclusion here is to bring us not only in line with emerging international law on this issue, but to create an opportunity for the Minister to regulate in this area. This is an issue where Labour members want to see the adoption of law in New Zealand to regulate this. We are very concerned about this issue and agree with submitters from the community of people who suffer from these genetic conditions that the government should be regulating this area and should be allowing sufferers of these conditions to have protection in the law. However, my question to the Minister is that this was a consensus-based position at the time that the committee had based on submissions. Things have changed since the committee heard that evidence. Australia has now decided to impose a 5-year ban with a review provision at the end, since the committee was able to make those considerations. Has the Minister's thinking on this changed, given the position of Australia now?
Ricardo Mendes March.
Thank you, And so I am going to be jumping around because I will have to leave the chamber, but I trust that actually my Green Party colleagues and our Labour counterparts will canvass the stuff between the sandwich. So I'm just going to jump to subpart 4A on genetic testing and acknowledging that there's many other clauses that are yet to be touched on before that.
Can you repeat
subpart 4A on genetic testing?
All right.
So this has been a very contentious issue. I know that this will gather quite a lot of debate, and there's other clauses to be debated. But specifically on subpart 4A, I wanted to get the Minister's views on whether Australia's recent move to ban genetic testing when it comes to life insurance and actually having the companies cede ground and support the recent moves by Australia has actually played any factors into how he's laid out for subpart 4A. I think to me, like, this is an issue where New Zealand is actually falling behind the rest of the world when it comes to how we legislate to protect consumers, but actually to use the most ethical policy to also protect disabled people. And so I've got an amendment on this issue that would effectively prohibit country relating to genetic testing. And I think to me, like, we had a lot of passionate submitters on this issue, but at the same time, like, Australia was having a very, very fulsome debate on the matter, and where they have landed is that actually a prohibition approach is actually the best way to move forward. I'm really concerned that the way that subpart 4A is laid out won't keep up with the rest of the world that are now acknowledging that actually, like, even having regulations may not be fit for purpose in terms of protecting consumers. I'm also concerned around the minister, like, I know in the second reading the minister interjected and said to not worry when I talked about the resourcing of those regulations, but I would still like the minister to nonetheless actually properly unpack how he sees those regulations being adequately resourced, well, the people who will be in charge of regulating the stuff in subpart 4A to do its work adequately and to meet what the legislation prescribes. I also wanted to ask, so this is my big third question is, so what meetings has he had since taking on the role, and particularly since Australia has moved to prohibit genetic testing when it comes to life insurance, like what meetings he has had on the issue and or with Australian counterparts to ensure that what he has put in subpart 4A actually is fit for purpose. Because to me it just seems like we're just kind of steamrolling ahead with this process and not actually considering that other parts of the world are evaluating this type of policy. So to recap, on subpart 4A, I'm interested to know whether the minister has had any meetings or discussions around Australia's recent decision, whether he thinks how this regulatory powers will be adequately resourced to ensure that they comply with the legislation, and whether he's got any reflections about the state of this bill in relationship to how consumers will be protected and what consumers would expect if they see other parts of the world actually moving to a more prohibitionist approach to genetic testing.
Dr. Duncan Webb.
One very brief point coming from Mr. Mendes-March's contribution, and that is my suggestion is that regulations are required, because at the moment the legislation as drafted is permissive. And there's a real danger that a minister might get a little busy or might, I know minister, or might simply not think it's a great idea and therefore doesn't kind of thwarts the intention of Parliament by not implementing parliamentary intent, which is to have regulations here. So I've got a proposal there that says the Minister must make a recommendation under section 86B within 2 years of the commencement of this Act. The time is up for grabs, but it just has to be time bound and must do so. That's the guts of it. So that's the first thing. The second thing is actually really important, and it's about section 82. So different changes to this. It's about contracts for the sale of land. And there's always this tricky thing, and I remember over the earthquakes, when the earthquakes hit, the first thing the kind of law firms had to deal with was, what about all of those contracts? What about all of those contracts where someone had agreed to buy a house and now it's damaged? Now, it's solved largely by clause 82, which says, well, you still have to buy the house, but you get the benefit of the insurance. So you put in the same situation. It's not, people don't like it, but at the end of the day, you still got to buy the house and you get to be in the shoes of the insured party. There's a gap. And it's actually a really big one, Minister. It's one we need to address. And that's that it is silent on Natural Hazards Commission payments. So there is absolutely no legal requirement for the Natural Hazards Commission to pay an incoming purchaser of the house. Now, through the earthquakes, this was kind of the workaround with deeds of assignment of EQC entitlements. But those, sometimes they were forgotten, sometimes they were defective. And sometimes people would simply say, hard luck, I've decided not to, and it became a real problem. So we need to cover that off, because it's as night follows day. If you're entitled to the insurance, benefit of insurance, private insurance, you must be entitled to the benefit of natural hazards insurance. So we really need to address that, so you don't have this black hole of law where private insurance is dealt with one way and natural hazards insurance is dealt with another.
Yeah.
Honourable Andrew Bailey.
Thank you very much. Look, I'll just deal with that one quickly. I'm just comparing, and the issue around natural hazards, we've quite deliberately kept that separate from this Contracts of Insurance Bill. Natural Hazards Bill or Act has its own arrangement, and what we haven't done with this bill is tried to take parts of that and put it under here. So that the natural hazard operates under its own framework, and this one operates under its own framework. So it's very clear we haven't tried to mesh them and merge them and do all that sort of stuff. And that's quite a deliberate approach to the whole thing. And I think it's wrong to try and complicate it. I just want to return to this issue around genetic modification. And of course, as members will know, this was an issue that came up during the Select Committee. So it wasn't something that there'd been a lot of consultation on. It just came up during the Select Committee process. And I'll just call out Mr. Mendes March's comments. Australia has announced a policy to ban insurers from using adverse genetic test results, but they haven't actually passed the legislation. So it's an intent, but the details of that we do not know. So the presumption of what Mr. Mendes March was implying, I think we've just got to be a little bit careful with the language. So obviously we're very interested to see what Australia does on this issue. We are also very interested from New Zealand's perspective. We want to make sure that people are not unduly disadvantaged from insurers using this as a way to exclude minorities unnecessarily so. So that is why we've adopted a flexible approach, which means we'll do it through Order in Council. Mr. Mendes March asked the question a couple of times about resourcing. Look, we all understand this is a very important issue. It's a new emerging part of the insurance industry. I'm very mindful of it. There are large resources the government has to be able to undertake and investigate this further. But the reason we've gone down this route is there is a procedure laid out how we might put in place regulations to deal with this in a more flexible manner rather than predetermine an outcome at this point. We have to consult with various groups. We're going to take a measured approach. It is an important area. If the members opposite are suggesting it's not, it is. But the approach we're taking will mean that we can keep up to practice with what's happening around the world to make sure that New Zealanders are not disadvantaged by this practice. But it is an emerging trend and we need to be cognizant of it, and we're very aware of it.
Mr. Chair. Dr. Deborah Russell.
Thank you, Mr. Chair. I am particularly concerned with the section on genetic testing as well. It was an issue we tried to deal with in the Select Committee, and as I'm sure the Minister knows, it was brought to our attention and then dealt with there. Look, Dr. Webb has gone through the issue on 86B, or may, that the Minister may regulate. What I want to look at is in clause 86C D. All right, so most of this section on genetic testing, it's set up to ensure that consumers aren't adversely affected by being required to take genetic tests and so on. And the Minister is required to develop regulations that are going to sort of have that effect. But on 86C, it's looking at the procedural requirement and particularly who the Minister needs to consult, the FMA, people who are affected, has to ensure that the regulations are desirable or necessary. But it's 86C1D, where the Minister has to be satisfied that the regulations are not likely to unduly prevent insurers from considering information in relation to genetic tests. Now that's a little bit curious because the set of rules around the sorts of regulations that the Minister may make seem to have the effect of ruling out genetic testing, but 86C1D seems to allow it back in again. I wonder if the Minister could explain what sort of information insurers might be able to consider. It has to be highly significant to insurance underwriting, but it's a little hard to understand what that information might be, given that all the other rules in this section are going to ruling out genetic testing. So what sorts of genetic information or information in relation to genetic tests might insurers quite reasonably consider, so it wouldn't be ruled out by the Minister's regulations. It's a little bit complicated, but I am trying to see if that's kind of a little bit of a backdoor entry in for genetic testing, and to make sure that we aren't, in the process of setting up these regulations, then allowing a backdoor which would have the effect of nullifying them.
Arana Williams.
Thank you, Mr. Chair. And I appreciate the opportunity to ask a question of the Minister in relation to his answer on genetic testing. I think his answer was really, really helpful, especially given the context of a number of patient groups, of people in a community of sufferers of genetic conditions who will be following along this debate very closely because it deeply and personally affects them and their families, particularly their children. So I want to ask the Minister, when he says he will consult with, run a full consultation process when he is using the Ordering Council powers, what will the consultation process look like? And will those patient groups be consulted with? Because a number of submitters noted for the committee that it was the first time that they were able to engage with the issue when this bill was before Select Committee. And they were essentially really making the case for regulation at all. They weren't able to put their arguments about what good regulation would look like. They weren't able to put their arguments about where they would see genetic testing as a low risk and where they would see it as a high risk for certain patient groups and for certain conditions. And they made the point very strongly, I guess, that those the kinds of tests on one side and the kinds of conditions on the other have a material impact, and what's in and what's out in a regime is something that they really want to be consulted upon. So I'm asking him to elaborate for people who are watching along on this at home, and I know there are people watching this now. Can he just give an assurance about what the sort of consultation process would look like, who would run that, how long people might expect it to be open for, and how they might engage?
Mr. Chair.
Mr. Chair. Mr. Chair.
I move that debate
Mr. Chair.
now closed.
Dr. Webb. Sorry, Dr.
It's an honour to be
Dr. Russell.
my colleague. Look, I'm sorry to stand up and take the call again, but I really am hoping that the Minister will answer those questions. I think they're quite important. Thank you.
Yeah.
Thank you,
Mr.
Minister.
Chair. Thank you. Very good comments. The 86C1D that the member raises, the reality is genetic testing is happening and will continue to occur, and it's likely it will continue to escalate. What this is referring to, there are some conditions that if you have that gene, that is so significant in terms of insurance event that would have a material bearing on whether in fact you get insurance. So for instance, I had a good friend who had Huntington's disease. He was a good friend of mine. He planned his life, never had children, adopted children, and made sure in the event that when that disease occurred, his family was provided for. And unfortunately he died at a very young age, at 40. Very successful person in his career. Now, that was a situation that he planned for, and if an insurance company knew that he had that disease, because that was inevitable that he was going to suffer from that disease, it was not one like, for instance, the BRCA gene, which a person may not get, right? In that situation, that is a significant insurance piece of information, and it's only fair in those situations where you should be able to get insurance for certain aspects, but certainly I would think it'd be pretty unlikely to be able to do life insurance because the likelihood of what was going to happen was pretty almost inevitable. So this is what this is taking into account. It's obviously a very subtle issue and a difficult one. So it's not presupposing an outcome, but it's just trying to recognise that there are some conditions that are unfortunately terminal or have significant consequences. And so that's why that subsection D is included in this area.
Arana Williams.
Mr. Chair, given the Minister's answers, and I really appreciate his answers, and I didn't necessarily anticipate that answer, how does the subsection that Dr. Russell has raised interact with 86C3C, which is an important protection which was really essential to the committee's buy-in to the cross-partisan support for these regulations, which is that it's a protection which essentially requires the Minister, before making an order in Council to regulate the use of genetic testing by insurers, that the Minister must satisfy himself and have, it's not a standard of satisfaction, it's a standard of having a particular regard to the kind of genetic test. And that is an important distinction about whether the regulations are likely to avoid significant disadvantages for policyholders, and that's all policyholders, including those policyholders who are expected to ultimately have their lives shortened by the genetic conditions they suffer as a group. So for the examples there are important and should be read in the meaning of that part, and not simply as examples alone for the purpose of illustrating the meaning of that. And it's the words significantly less favourable terms which the Minister is, I guess, being asked to consider. Can he compare the meaning of 86C3C with the provision which then protects insurers that Dr. Russell has asked him about?
Mr. Chair.
Dr. Deborah Russell.
Thank you, Mr. Chair. I'd just like to thank the Minister for sharing that example, and to offer my sympathies for the loss of his friend, because it does bring home the nature of some of those genetic diseases. I just want to follow up on what the Minister told us a little. Huntington's disease is very distressing and has only one outcome. But the BRCA gene is interesting because it is so highly associated with a pretty, what's the word I was going to say, aggressive form of breast cancer. And I guess this becomes the point at which something is a certainty versus a very high possibility. So there's a little bit of a line drawing exercise to go on in there. And for example, until recently we would have said that cystic fibrosis was pretty much a certainty of an early death, but with the advent of some drugs, it's now, if people have access to Trikafta, then a fairly standard lifespan is expected. So there's a little bit of a judgment exercise involved in there. I'd just invite the Minister just to, if could speak a little bit more about the sorts of advice he is likely to take, or the things that the Minister who is handling us at the time ought to take, around trying to distinguish what really is a terminal condition, what is a likely condition, how that might affect how that particular clause might operate.
Yeah.
Oh, well, I'd like the
Honourable Minister.
Mr. Chair, look, obviously it's a very delicate issue. Probably the easiest way to explain it, there are some conditions that there is no possibility of a different outcome. They are terminal, maybe of terminal nature, and that's what That's what 86C1D deals with, right? People, the example that the member just raised, obviously there's many forms of cancer, not all of them are terminal. And so I'd be very concerned and certainly wouldn't be wanting to make changes through order in council to allow insurers to say anyone who had cancer wouldn't be able to get a life insurance policy, because that clearly is unfair. So the clause C that was put in by the committee, I think that's a good clause. There is a distinction, right? And of course, what we're talking about, and there are multiple insurance products, of course. Even my friend with Huntington's disease, he still wanted to insure his house, he still wanted to insure his car, he wanted to do other insurance, but the likelihood of him getting life insurance against an event that was inevitable, that's a distinction. So we certainly don't want people, the insurance companies, saying as a big band we're going to exclude you or charge a higher premium. And so I'm very clear on that point.
Look, I'll just indicate at this stage that we'll be looking for new material. Aaron Williams.
Yeah, in the spirit of the committee stage, my question is a straight question. Given Australia's change in position, should New Zealand be seeking to align itself with Australia? And will the Minister exercise his powers under the new regulatory making powers under this legislation with a view to lining New Zealand's insurance industry up with Australia's?
Mr. Chair, look, Australia, as I said before, has announced an intention. It has not passed legislation, and like all parliaments, and we're the same, it will go through a select committee process. It'll be interesting where they end up. Of course we will have regard to Australia's outcome, but as will we have regard to other jurisdictions around the world. What we'll make sure is we do best in class around the world to make sure that we deal with this, and it will be evolving. Even if we make a change in a year's time or whenever Parliament in Australia passes its legislation, there'll be further developments. So that's why adopting an order in council procedure with very clear procedural approach that has to be followed under 86C, then that gives us the flexibility to make sure we keep up to date and abreast of developments.
Celia Wade-Brown.
Thank you, Chair. I've got some questions around 86C Section 3 and the subparts within that. And I'm particularly interested if the Minister could tell me what another source of information might be. I mean, how do we stop insurers from, for example, requesting information from the heritage sites where people have voluntarily given DNA information to, which can be very useful. I mean, that's how I confirmed my Jewish heritage through that site. But can we prevent them from requiring us to disclose information? Can we also, looking at whether when viewed as a group, does that mean an ethnic group potentially? I mean, presumably African heritage people living in New Zealand are far more likely to have sickle cell anemia than the Minister or myself. Does that, at what stage does that constitute some sort of ethnic bias? Are there some genes that Maori or Pacifica hold that make them more vulnerable to particular illnesses or shorter life? There certainly is a far shorter life expectancy for a number of reasons, potentially some of them genetic, mostly socioeconomic, for Maori and Pacifica. How does that fit into us trying to make insurance fair in this country? And I just want to also reflect on a personal experience. I've just visited my sister who's got terminal bile duct cancer. And would I have to declare my relatives and their particular diseases in order to get insurance? And how does that, do I need to have a genetic test to see if we've got the same vulnerability, or would they just look at some medical likelihoods? I mean, it would just be interesting. I mean, these are very complex questions. It's difficult to answer in here, but this is a point at which we should be asking these questions. Thank you, Chair.
Mr. Chair.
Honourable Minister.
And I'm sorry to hear about your sister. Look, that's the examples you use are exactly what we don't want to happen. We don't want insurers to blandly classify people, ethnic groups, people with certain conditions, and might be a familial relationship or whatever. We don't want them doing that. That's the bit about this whole thing. And of course, it's an evolving thing. And so that's the general principle. I'm very keen, and I'm sure all parties in this House want to make sure that people should be able to get insurance. That's the general principle of it, right? So we need to deal with it delicately, but that is the general principle. We do not want that sort of classification that you're talking about.
Ryan Hamilton.
I move that debate on this question now close.
Arana Williams.
Thank you, Mr. Chair. My question is about Section 90, and it is about the insurer standing in for the policyholder's place for those claims that are made under this part, this subpart. That is a new subpart that we have not yet debated. It's relating to a supplementary order paper on the table for the Minister's consideration. There is a lack of clarity here about what documents the insurer, when standing in, should receive. An amendment here seems to be needed via a new subsection 3, where the claimant, whoever the claimant is in this kind of scenario, would be able to seek, and the insurer must provide all information and documents relevant to the claim, whether or not there had been proceedings. So in a situation where there were proceedings, where there were court proceedings, or in a provision where arbitration allowed and arbitration proceedings, but what's not clear here is prior to that, or in a negotiated scenario, which is the scenario that we envision in this Act anyway for consumer insurance contracts, whether it would be possible for the claimant to get those documents. It would also be helpful for, if the Minister's not going to accept the amendment that's being proposed here, would he enunciate his view on whether those documents should be provided to the claimants in this situation?
Mr. Chair, I know the member's talking on behalf of a clause put forward by Honourable Dr Webb. Look, it's already addressed. If Dr Webb looked at 7 clauses on, he would have seen that it's addressed in 97, clause 97, and also Schedule 3 of the bill, which already allows, it's already provided for in the bill that claimant can obtain information documents relevant to the claim from the insurer.
Arana Williams.
Chair, moving to Section 91, which is the defences which apply to this part, has the Minister considered the need for a new subsection 2D here, which would allow for the defences which are being relied on to be for the status of the policyholder, and making them specific to that policyholder? Because in this part, there's the policyholder and there's the claimant. It's helpful because there is a lack of clarity here for the Minister to give Parliament some clarity about whether an amendment is needed here, or whether it's his intention to ensure that the term saying that the insurance is voided on insolvency or anything like that would not deprive third parties who are making the claim.
Mr. Chair, look, clause 91.2 already prevents an insurer from relying on certain technical defences that it would only have because the policyholder has become insolvent. So it's already provided for, and I suppose the more general principle is that it's better to clearly identify the specific defences that an insurer cannot use to avoid uncertainty.
Ryan Hamilton.
That debate on this question now closed.
Francisco Hernandez.
Mr. Chair, and I just had a quick question, and I know we've been jumping around a lot, but I've got to go. On subpart 6, and I think it's 99, on application for shares in company not to be contained in proposal for insurance. I was wondering, is that quite a common phenomenon in the insurance industry? Are there is it quite a kind of common thing so that, when you're taking a call for insurance, is it quite common that that they're essentially asking you to buy shares in the company? I'm just wondering whether you can kind of quantify the extent of the problem as it exists today. Like, how often is it occurring? What the current kind of scale for penalty is. Thank you.
Aotearoa Williams.
I apologise for coming back to the subpart 4A on genetic testing, but I want to ask a specific question which I don't believe has been answered, and there is significant public interest in, which is how long interested groups in this, particularly patient groups, can expect consultation with them to occur for. The reason I would ask this is because before the Minister can exercise his powers, which he's required to in 2 years, so there is a time frame on the requirement for the Minister to make regulations in this area, is it his expectation that the consultation period would basically be the entire 2 years, or would that be a smaller part of the 2 years, because the patient groups for this are already engaged in it because of this bill's process, and they want to know how they can prepare because they want to make the best case possible for their access to continuing life insurance. This is not a question which affects a large number of people, Mr. Speaker, but it is a question which affects a small number of people very deeply, and is one that would be very helpful for the Minister to give some clarity on.
Mr. Chair.
Stuart Smith.
I move that debate on this question now close.
The question is that debate on this question now close. All those in favour say aye. To the contrary, no. The noes have it. A party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
The ayes are 68, the noes are 49. The question is agreed. The question is that the Minister's amendments to Part 3 set out on AP number 125 be agreed to. All those in favour say aye. To the contrary, no. The ayes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
The ayes are 68, the noes are 49. The question is agreed. The question is that Honourable Duncan Webb's tabled amendment to insert new subclause 5 in clause 70 be agreed to. All those in favour say aye. Aye. To the contrary, no. Noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour. Oh, sorry, opposed. My apologies.
Act New Zealand.
11 votes opposed. That really good. Okay.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Yes.
A vote? I'm not sure that I...
So you wish to change
I do.
the Green?
That's
We haven't
my
completed
fault.
voting yet, so you're able to do that. Yes.
Thank you.
So you are now voting. Green Party are
voting in favour.
in favour.
Thank you. Sorry.
The ayes are 49, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to insert new subclause 6 in clause 70 be agreed to. All those in favour say aye. To the contrary, no. Noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
The ayes are 49, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to insert new paragraph C in clause 72(3) be agreed to. All those in favour say aye. To the contrary, no. Noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
The ayes are 49, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 73(2) be agreed to. All those in favour say aye. To the contrary, no. Noes have it. Party vote is called for. Please conduct the party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
The ayes are 49, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to insert new clause 5 in clause 74 be agreed to. All those in favour say aye. To the contrary, no. Noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
The ayes are 49, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to delete clause 75(3)(b) be agreed to. All those in favour say aye. To the contrary, no. Noes have it. Party vote called for. Please conduct the party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
The ayes are 49, the noes are 68. The question is not agreed. The question is that the Honourable Dr Duncan Webb's tabled amendment to clause 76(1) be agreed to. All those in favour say aye. To the contrary, no. The noes have it. Please conduct the party votes.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
The ayes are 49, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 77(2) be agreed to. All those in favour say aye. To the contrary, no. The ayes have it. A party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment deleting clause 80 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to insert a definition of land in clause 81 be agreed to. All those in favour say aye. Aye. To the contrary, no. The ayes have it. A party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to insert new subclause 4 in clause 82 be agreed to. All those in favour say aye. Aye. To the contrary, no. The noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Ricardo Menendez March's amendment to replace subpart 4A of Part 3 set out on AP number 108 be agreed to. All those in favour say aye. Aye. To the contrary, no. The noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 86C1 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Party vote. Please conduct the party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to insert new paragraph 1 in clause 87.2 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. Honourable Dr Duncan Webb's tabled amendment to delete clause 89 is ruled out of order as being inconsistent with a previous decision of the committee. The question is that Honourable Dr Duncan Webb's tabled amendment to insert new subclause 3 in clause 90 be agreed to. All those in favour say aye. To the contrary, no. The noes have it. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to insert new paragraph D in clause 91(2) be agreed to. All those in favour say aye. To the contrary, no. The noes have it. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment inserting new clause 93A be agreed to. All those in favour say aye. To the contrary, no. The noes have it. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 votes in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Part 3 as amended stand part. All those in favour say aye. To the contrary, no. The ayes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
6 votes opposed.
The ayes are 68, the noes are 55. The question is agreed. Members, we come now to Part 4. This is a debate on clauses 100 to 121, intermediaries. The question is that Part 4 stand part. The Honourable
Mr.
Dr Duncan
Chair.
Webb.
Oh, thank you, Mr Chair. I have a number of suggestions as to how this part of the bill can be improved. And this is an important... was that Part 5 you said, Mr Chair?
Part 4.
Oh, look, I'll let my colleague take a call because I've actually prepared something on Part 5.
Chair.
Williams.
Mr Chair, speaking to Part 4 of the bill, I want to ask the Minister some questions about the role of intermediaries and brokers, particularly given the changes to the definition of brokers that was made at the Select Committee. Is there anything in this part which has been drafted given the old meaning of brokers under the previous definition that Cabinet has considered and that the previous Labor government was working on, which is essentially what's being proposed here by Part 4, that is materially affected by the change in the specified persons definition, which applies to brokers and intermediaries in this part.
Mr. Chair?
The Honourable Dr Duncan Webb.
I apologise for the earlier confusion. But I just really wanted to challenge the Minister on the inclusion of clauses 104 and 105, which provide default provisions for when and I've never understood why we trouble the legislature with these clauses, which provide essentially a default provision of, I think it's something like 50 days that a broker has to pay money received from an insured as premiums to the insurance company. And these parties, and the irony is, it isn't even a rule of law, it's just a default contractual provision, which they're free to contract out of. It does seem to be an absolute waste of kind of legislative paper to even print this clause, and the parties should just negotiate it between themselves as they do. Now, I know that brokers make a lot of money because they sit on premiums and put it in investments accounts, and half of this section of the bill deals with how they can invest it and how they can retain the profits on investment, which all seems entirely superfluous because it's a private relationship. And why are we even essentially giving brokers a favour by including a default position? Mr. Bailey.
Honourable Williams.
Thank you, Mr. Chair. I want to bring the Minister to the changes made to the new 2A in this part and the deletion of 4. The question that I have is similar to my questions in previous parts, which have not been answered by the Minister. Which submitters asked for the change which is being made here, and is he satisfied to a change in legislation which he is overseeing, which has only been submitted on by, I think it's one stakeholder who had an interest here, is a fair representation of a piece of legislation that should step forward the interests of consumers, where in fact very well organised parties who are able to contract for themselves and go into contractual negotiations, very well represented, have come along to a select committee and asked for a change, which has then been accepted by officials as a change which was suggested to the committee. Is he satisfied with that as a legislative process in this instance, and in the others I have asked him about, which he has not answered?
Mr. Chair.
The Honourable Andrew Bailey.
Thank you, Mr. Chair. I did discuss this with the insurers and also with the brokers. So I don't think anyone suggested to me that we should delete clause 104, which the Honourable Dr Webb has proposed, both 104 and consequently 105. And I think, first of all, the importance of this clause is that it sets a statutory backstop. And that is important. That's the main reason for retaining this clause. And I think it's wrong for the member to propose that we actually delete it in its entirety. Unless there's a duty for the broker to hand over money, the insurer could be left with no one required to pay them. And this is because clause 101 provides that a policyholder paying the intermediary discharges their liability when they do so. So there's a sort of a flow-on effect to this. So we think it's important that there is a regulatory backstop. Of course, as the member suggested, different insurers and the brokers can come to a different arrangement, but that is the main reason why these two clauses are important.
Mr. Chair.
Honourable Dr Duncan Webb.
There is a further point I want to ask, and I know the Minister holds some other portfolios which relate to small business, and this relates to 108, which is duties of brokers in relation to payments due to the policyholder. Yeah. So brokers often will in fact receive payments. So you might have a small business, for example, big flood, can't get to your premises, you get business interruption insurance. The question is, when does the broker have to pay the policyholder, the person who suffered the loss or damage? Now, there's this really weird division here, because if you're a consumer, it's 7 days, boom, pay it out. If you're a business, that's as soon as reasonably practicable after the broker receives the money in the case of a payment in connection with a non-consumer insurance contract. There's absolutely no sense in that division. There is no reason why a small business should be out of their money for longer. Unless the Minister thinks that as soon as reasonably practical is less than 7 days, but the fact of the matter is that if you are holding money under a business contract, it could be many millions of dollars. I have seen payouts of hundreds of millions of dollars. Holding that for 2 days is a good learner. Why should a broker be able to hold insurance monies on behalf of a small business, or indeed any business, longer than they can for a consumer? Can you answer that for me, please, Mr.
Yeah, thank you, Mr. Chair. I was just checking there, but so obviously in this bill we've made a clear differentiation between consumer insurance, which individuals primarily, and commercial contracts, because they're quite different. The different types of products, in many cases, are much more complex. So in the light of that, and that theme carries right through the bill, we've made it very explicit for personal consumer products that they have to be paid out within 7 days, as set out under 108A. And so that's important because in the main they're very simple insurance products. With regard to 108, there is still a requirement, and I just draw the attention to the member to 108B. It states as this right at the start, as soon as reasonably practicable, the money must be paid from the broker. So that is a key tenet of it, and obviously there can be agreements between brokers and insurers if they want to, but that reasonable test is a crucial test, and again we've talked about that and traversed that earlier in the discussions around the bill. That's a common understood term.
Arana Williams.
Mr. Chair, just for clarity, does the Minister expect reasonably practicable to mean less than 7 days or more than 7 days? That's the relevant question here. When the Minister says that the Act is drafted in a way to create consumer contracts for insurance and other contracts for insurance, that's not the case. For most of this Act's life, the legislation was drafted in a way which delineated, the big delineations were between contracts for insurance for policyholders who were not in a position to negotiate contract terms with an insurer because the insurer had an outsized sort of corporate interests and corporate power to negotiate, and contracts for reinsurance, which were large commercial arrangements between two large corporate entities that had sort of relative power. That was the distinction. And so these new distinctions which are created here around non-consumer insurance contracts are new and have a different kind of impact than they did before because of the previous changes to the definitions and to the way the contracts of insurance are defined. My question about these non-consumer insurance contracts that are created under 108 is whether, which is new from the Honourable Duncan Webb's, which need to be addressed, is in the situation for contracts of insurance for businesses like accountants and lawyers for indemnities where they pay on to consumers. So essentially you claim against your accountant because they have given you negligent advice and that has caused you real loss, which does insure a consumer. That insures the exact kind of vulnerable person here who Mr. Bailey is talking about needing to insure in this law. Does it apply to those or not?
Mr. Chair, look, I beg to differ. There has been a distinction between consumer and non-consumer throughout the bill. So that's fundamental sort of difference approach. And as we traverse, I think in part 2, extensively around the complexity and often of commercial arrangements, insurance arrangements dictate they have different arrangements. And this 108 takes that and recognises that point. Your specific question about what is reasonable, whether it's less than 7 days for a commercial contract, it is reasonable in the circumstance. And so in some cases it might be an earlier payment, as might occur within 7 days for a commercial insurance policy, but for other occasions it may not be. So again, we're just making sure that we recognise that there are different types of products, they're more complicated, and therefore in some cases it might be an earlier payment required, in other cases it might not.
Helen White.
I just want to add to the issue particularly with regard to the holding of the money for 50 days as a default, because we've had some really interesting research in terms of the withholding of monies owed to small businesses. Now, the latest research from Xero says that we have had an increase in the amount that's costing our small businesses and our firms to 827 million a year, compared to 456 million in 2021. So this is it's an exponential rise. We've got a growing problem, it seems, of people who are in the middle of these transactions calculating to hold on to money for as long as they possibly can because they're receiving the interest on it. So using our small businesses as banks. And it seems to me this particular scenario is one where that is almost being sanctioned by us, because we're saying 50 days is the default, and we're saying any reasonable time. And if it becomes a practice, and I was talking this week to someone senior in the Business Representation Committee, they said that some people are only being paid in 120 days. That's becoming a calculated decision, 120 days to pay a small business. That's a very long time. So while the average late payment might be about 8 days, which is, by the way, way more than it is in Australia or the UK, which is taking this issue very seriously and publishing the results of people who late pay calculated. Those kinds of issues are really of a concern here. So I'd like the Minister to address whether he is concerned that by putting in a payment term like 50 days here, we're almost creating a calculation of, we will keep this money for this long, we will make this amount in interest because we're gathering up all these amounts, and actually that will become part of the business model, and we're actually almost saying in this legislation that's okay, and that the reasonable term will become dictated by those outliers at 120 days or 90 days, which had become a habit in New Zealand, and that will be seen as reasonable when in fact it's really hurting our small businesses. Thank you.
Mr. Chair.
Honourable Minister.
Thank you. I'm not quite sure whether your numbers you're quoting there were a general credit or whether you're specifically talking about money held for insurance policies. I suspect
just generally.
Generally, yeah, that's a different issue. And you'll be aware that we made an announcement about that yesterday. But in terms of the 50 days, when I met with brokers and insurers, my recollection is that 50 is now the current norm. So we're not changing. There were some people who wanted to be brought forward, some people didn't. So they reflect the current practice of 50. Obviously, there's ability for insurers and brokers to negotiate a different, more quicker payment time. But I just want to be very clear with you that the 50-day test relates to money that the broker passes on to the insurer. It's not what I think the member was alluding to. It does not affect payment to a small business policyholder. So that's a clear differentiation, because we want to make sure that commercial small businesses get paid in a timely manner. This is merely relating to the arrangement between the insurance company and the broker.
Can I just
Helen
Thank
White.
you. I just want to make sure that I am speaking clearly about this. So yes, you're right. It was a general reflection of payments not made to businesses. It's research from Xero, which is of real concern. And it's not about government debt, it's about business to business debt, etc. So it's being withheld. I'm kind of concerned even more from what was said, because we're talking about two different things. One is premiums held. Very little reason to not pass on a premium as soon as possible. That's just taking money from people and using it for insurance. And the other is holding money that you're supposed to pass on to somebody who has actually been injured. They've had some event, which means that money's really vital, and holding that for a long time. So there are two things going on. One, we've prescribed a time of 50 days because it's the norm. Well, actually, it sounds like a worrying norm to me. Did we investigate whether that was in fact a sensible time, whether there's any reason to hold that money, or whether we're building it in to a business model that those groups, those brokers will hold, third parties will hold that money for that long and just simply claim they're investing it and claiming the interest, and whether the other is of concern too. Surely we need things to go through swiftly, and I'm concerned that if we've got that growing issue with an increased amount of time, we're actually sending a signal again that too bad about the little guy. It's going to take as long as it takes, and we'll decide if it's reasonable. And if you've got people with respect, judges earn lots of money, they're probably not under the pump the way a lot of small businesses are. They wouldn't necessarily see that sinks a business.
Mr. Chair, look, I obviously did a poor job of explaining it. There is a requirement for insurers to pay policyholders, commercial and non-commercial, and promptly, right? We've been traversing that in the previous part, and so that is an absolute requirement. What we're talking about here is something quite distinct from that. All we're talking about in this clause is the arrangement between the broker and the insurer. So that's the big differentiation. And there's always been a norm that, from my recollection, that there would be that brokers would have up to 50 days to pay the insurer. And so if you want to, if you're concerned about the broking industry going broke or the insurance industry going broke, let's have that discussion. But that's quite separate from what I think the member's trying to allege, that there's going to be a subsequent and consequential delay in making the payment between the insurer and the policyholder. And that's not the case. You need to put a knife between those two connections.
Arlene Williams.
Chair, just a brief question. How many submitters asked for this change? And is it a good enough to 108 and 104? And is it a good enough legislative process that the change has been made with minimal number of submissions and no submissions from consumers about it?
The question is that Honourable Dr Duncan Webb's tabled amendment to clause 101 1B be agreed to. All those in favour say aye. Aye. To the contrary, no. The noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
The ayes are 49, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to delete clause 104 be agreed to. All those in favour say aye. Aye. To the contrary, no. The noes have it. Please conduct a party vote.
New Zealand National,
49 votes opposed.
New Zealand Labour,
34 votes in favour.
Green Party of Aotearoa, New Zealand,
15 votes in favour.
Act New Zealand,
11 votes opposed.
New Zealand First,
8 votes opposed.
Te Pāti Māori,
The ayes are 49, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to delete clause 105 be agreed to. All those in favour say aye. To the contrary, no. The noes have it. Please conduct a party vote.
New Zealand National,
49 votes opposed.
New Zealand Labour,
34 votes in favour.
Green Party of Aotearoa, New Zealand,
15 votes in favour.
Act New Zealand,
11 votes opposed.
New Zealand First,
8 votes opposed.
Te Pāti Māori,
The ayes are 49, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 108 be agreed to. All those in favour say aye. To the contrary, no. The noes have it. Please conduct a party vote.
New Zealand National,
49 votes opposed.
New Zealand Labour,
34 votes in favour.
Green Party of Aotearoa, New Zealand,
15 votes in favour.
Act New Zealand,
11 votes opposed.
New Zealand First,
8 votes opposed.
Te Pāti Māori,
The ayes are 49, the noes are 68. The question is not agreed. The question is that part 4 stand part. All those in favour say aye. To the contrary, no. The ayes have it. Party vote is called for. Please conduct a party vote.
New Zealand National,
49 votes in favour.
New Zealand Labour,
34 votes opposed.
Green Party of Aotearoa, New Zealand,
15 votes opposed.
Act New Zealand,
11 votes in favour.
New Zealand First,
8 votes in favour.
Te Pāti Māori,
The ayes are 68, the noes are 49. The question is agreed. Members, we come now to part 5. This is the debate on clauses 123 to 164, contracts of life insurance. The question is that part 5 stand part. The Honourable Dr Duncan Webb.
Oh, goody, I've been looking forward to this bit. Now, obviously, contracts of life insurance are of critical importance and actually are really significant financial instruments. And I was just a little bit concerned, firstly, in terms of clause 125, which is, look, this is good. Interest rates must be paid. Interest must be paid on life insurance, pity about not other insurance, but life insurance, at the rate and calculated in the manner specified in the life policy. Okay, that's the default rate. The greater officers, or the interest rate and calculated in the manner prescribed in the regulations. Now, my concern is that neither will exist. What happens when neither exist? Because at the moment the regulations aren't there and the regulation-making powers are all discretionary. So my proposal is that it's that after B is inserted, provided that where there are no regulations under subclause B, that the interest rate under that clause is deemed to be the official cash rate plus 2%. Now, there are other interest rates that you could choose, the Judicatrack rate and so on, but just we need a placeholder, and it's probably a placeholder that needs to be a little higher than might otherwise be the case to incentivise regulations being made, because there is a real risk that it's just a lacuna, a gap, a void in respect of interest rates. So I'd be very interested in the Minister's view on how we address the issue there. And I'll go straight to a second point, because I can see the Minister's just wrestling with that issue. The other one, and this is one that really bugs me, man, Clause 131, life insurer may require reasonable evidence of matters affecting validity. That's okay. The life insurer may, before it registers an instrument under this part, require any reasonable evidence that it thinks fit about any matter that might, in its opinion. Now, insurers' opinion have no place in the law, and in fact they're nasty little things which give an outrageous degree of discretion to insurers, because if something affects the validity of the instrument, it's a yes-no question. Either it's relevant or it's not relevant. The opinion of the insurer is not an appropriate consideration. If the insurer has an entirely misplaced opinion that some document is relevant, the birth certificate, whatever it might be, and they can then ask for it, that's just putting unnecessary hurdles in the way. So let's just, there's an amendment paper there ready to go, so let's just strike out in its opinion, and that clause should never be found in the law of insurance in relation to the opinion of insurers anywhere. Don't you agree, Minister?
Arena Williams.
Yeah, a general question about Part 5 and then a specific question. Is there anything in Part 5, which is the life insurance provisions in this Act, that would give the Minister concern if they are in primary legislation, given that he has new powers to set regulations about insurance, the use of genetic testing in a life insurance context, because those will be secondary legislation and subordinate to the primary legislation. And I ask that because Part 5 was drafted in the context of nothing being off the table in a life insurance context, but the Minister is expected to make regulations which are very likely to place a number of questions for insurance insurers' purposes off the table. And then a specific question around 131. This is also particularly problematic given the Minister's new powers in setting regulations, because is it his intention to formulate the regulations in some way to get around 131, or will he need to be back in this House to amend 131 at the stage he's creating the regulations?
Oh, I hope not.
Because it doesn't seem to me to be possible, unless there's a very wide interpretation of reasonable evidence there, for 131 and new regulatory making powers to exist if they were to limit the insurer's ability to use genetic testing information, which is entirely the point of the regulations in the first place. Those regulations were introduced by the Select Committee to limit the ability of insurers to use them. The Minister has also agreed with limitations on use of those tests. And so if an insurer was to continue to ask for evidence before registering the instrument about matters pertaining to the use of testing, then that would be allowed at the primary level, but perhaps prohibited at a secondary legislative level, which would create some problems for us.
Mr Chair.
Honourable Andrew Bailey.
Thank you. Look, just in reference to your first question, Ms Williams, look, I don't have particular concerns, and I know you've asked that in the previous part. We're cognizant and mindful of that, but at this stage I don't have any concerns. But just dealing with the specific questions around, well, let's deal with 131, which both you and Honourable Dr Webb have raised. And the proposal is to delete the words "in its opinion." Look, first thing I'd say to you is the bill carries over a long-standing provision which is operated without issue. So I think raising this as a significant issue at this point sort of goes against the grain of what's been in place for a long time. Secondly, I'd make the point to Honourable Dr Webb, it's a strange argument he's putting forward, because the provision inherently turns on the life insurer's own assessment of what evidence to request. So the deletion would probably wouldn't make any practical difference at all.
No, it would.
And so the existing requirement for the required evidence to be reasonable already exists as a safeguard. So there is a reasonable test around that. The bill approach has been well consulted on, and no other person or group has raised concern. And I do note that you must have had an epiphany because your original bill didn't have it changed. Again, coming back to clause 125, I just draw your attention, 125 states at the preamble to it, the interest payable under section 123 or 124 must be paid at the greater of the following: A, which is the life insurance policy rate, or B, the interest at the rate calculated. So there is a backstop, which is the life insurance policy rate, and that's why it's been done. And the proposal, I know the member's been very helpful in proposing OCR plus 2%, but that's been plucked out of the air, I might suggest to the member, because already we've dealt with the issue in subpart A.
Honourable Dr. Duncan Webb.
I just want to talk to assignments of life policies, because that is an important question, and it recognises that life policies are essentially a kind of intangible personal property, and that the rights attached to them can be...
Which clause are you focusing on?
Oh, sorry, clause 126.
126.
Assignment of life policies by way of ordinary transfer, and just recognising that it's essentially a financial instrument, intangible personal property, which is a valuable bundle of rights. And my concern is with 126 is that it's set out as exhaustive, whereas there may be other dealings in life policies which, to use a kind of slightly arcane approach, are transfers at equity. So, for example, if money was to be lent and the life policy it was agreed would be assigned as security. So if I don't repay it, you can have my life policy. If that's a promise of something that will happen in the future, it's an incomplete transaction. The things that are here, it isn't an assignment at law, it's not by way of ordinary transfer, but there is an interest that passes sort of by way of mortgage or perhaps by way of equitable charge. Now those kind of transactions are actually quite important, and they're part of the kind of oil that keeps the wheels of commerce going. So those not fully formalised transfers, which are transfers at equity, need to be recognised, because at the moment with 126, which looks like it's codified how you transfer a policy, it actually leaves a gap in terms of transfers at equity. These kinds of transfers, which are a little akin to a trust, in the land law you'd recognise them by way of caveat, and in terms of where they sit in terms of priority, clearly a transfer, a legal transfer by way of documentation which is done without notice, honestly without notice, will gazump, will prevail over an equitable transfer, which might be a far less formal thing. However, if there are no other competing transfers, an equitable transfer should absolutely be recognised, because it's essentially a slightly inchoate transfer. So my suggestion in the amendment paper is that there's a new clause, subclause 3 to 126, which says, for the avoidance of doubt, nothing in this section prevents the transfer of an interest in a life policy at equity. So that's kind of a very much a catch-all phrase, just to say the common law and the law of equity still stands, and transfers of life policies or interest or part interest, whatever. I haven't sat down yet, Mr. Bailey.
Love the enthusiasm.
But I will now. I think you've got the gist. I'll be interested in your answer.
The Honourable Andrew Bailey.
Well, thank you very much. I know the member is very diligent, but I suspect he's been in Parliament too long. And I say that with all due respect, because we understand from industry that equity transfers, of what she was talking about, is no longer the normal practice. And that was, we did actually discuss that with industry, and that transfers are done by way of ordinary transfers no longer occur. So the concept, and the concept of what he was proposing, if you are seeking to provide security by way of some form of vested interest in another interest, then that would be captured by a contractual relationship. And so we think that this piece of legislation captures the current thinking on what happens in this area.
Alina Williams.
That's my question about 131 I asked about the Minister's concerns. He said he wasn't concerned. Yeah. Let me ask him whether this is good for people who suffer from genetic diseases, who expect him to make powers that restrict insurers from using their genetic testing information to prohibit them from getting insurance. Whether 131 is good for them, because they are expecting him to restrict insurers, to stop insurers from being able to stop them from getting life insurance policies that would be discriminatory to them and a group of people. And most jurisdictions around the world think that it is fair for legislatures like ours to make that call, to say, actually, you know, it's discriminatory. These people would be facing genetic discrimination if that were the case. So I'm asking him, is it good for those people if 131 stays as it's written, that an insurer can continue to ask for evidence which is reasonable in its opinion before it registers an instrument? Because even if it complies with the secondary legislation that he might introduce, they will still be able to rely on Section 131 as it is written to continue to ask for information that they deem relevant and reasonable before they register the instrument. I'm asking whether it's fair and good for patients.
Honourable Dr. Duncan Webb.
Thank you. I have a couple of short points. First is very short. It's 132, Section 132, or Clause 132, High Court may order registration. And that's kind of a default provision, you know, appointment of trustees and so on and so forth. But why the High Court? The High Court's slow and expensive. Why not the District Court? Those District Court judges know what they're doing. This is a real formality too. Essentially saying where there is an assignment by way of transfer and the insurer hasn't done their job, the court can simply say, do your job. It's a really good point. This is Clause 132. And, you know, I think there's a principle that any decision making should be undertaken at the lowest appropriate level in terms of achieving some efficiencies in the judicial system, which frankly is overwhelmed. So in terms of the question there, my question is, why have we defaulted to the High Court? The High Courts have always had a statutory power as a supervisor of trusts, and I can understand why, a common law power, inherent power to supervise trusts. I understand why the later provisions around appointment of trustees say High Court, but this is a really technical and rather boring provision. And so I'm very interested as to why you've taken that approach. The other point, I just turn to Clause 141, and that's around surrender values of policies, and that policies may have, life policies may have a surrender value, and that where there is a surrender value but you haven't kept up premiums, there is an ability to deduct premiums and interest on those premiums. And then it says this section, this is subclause 3. This section is subject to any more rules made by the life insurer or that affect the life insurer and the terms and conditions of the life policy. It's all very well, but if we're going to, life policies are basically consumer policies almost all of the time. And the danger is that the insurer arranges rules which are quite unfair or onerous, or change the kind of default settings in this section. So that's why I have suggested that added to that clause is a statement that says, provided that no rules or terms may leave a consumer policyholder in a worse position than they would be under the terms of this section. So that is to say, insurers can say, well, look, we'll pay you greater interest, we won't charge you interest on unpaid premiums, or we won't deduct unpaid premiums, but what they can't do is say you have to pay double premiums or some other absolutely onerous clause. So I'd be very interested in the Minister's view on that.
Dan Bidwell.
I move that debate on this question now close.
Mr. Chair, I'll take one call and hopefully they might get us to a point. I want to address Ms. Williams's question. She's drawing a bow between 131 and the discussion we had in the previous part around genetic disorders. The provisions in this bill at 131 only relate to Part 5. So they're not. She's wrong to try and confuse them and conflate them and reference them back to Part 4. It only deals with issues in Part 5 around transfers, etc. Just on that question that Honourable Duncan Webb spoke about with 141, he made a comment about insurers and implied insurers might be putting a whole lot of difficult terms and conditions. Again, as I said, one of the three guiding principles of this bill is to make sure that insurers are not putting in terms and conditions that policyholders cannot understand or are hidden in the terms and conditions. That's why it is a requirement on them to present their policies in a way that are easily understood. That guiding principle will address much of what he's concerned with. With regard to the specifics around 141, specifically, this is clause 3 that he referred to. We specifically consulted on surrender value provisions with this at the Select Committee stage, and I know the member wasn't a member of the Select Committee, but the feedback that the Select Committee heard on that was that there was no change required to this long-standing provision. In practice, insurers no longer issue these policies, they're legacy policies only, and again, I think he's obviously had an epiphany because this is a new change. It wasn't in his original bill that he proposed.
Williams.
Mr. Chair, I'm confused. Is the Minister saying that nothing in Part 5 contracts of life insurance applies to those?
In Part 5?
Yes, nothing in Part 5, the provisions that relate to contracts for life insurance apply to contracts of life insurance that will be affected by the new provisions given effect in subpart 4A of the previous section. So any life insurance policies which are affected by genetic testing would somehow be exempted from contracts of life insurance. And I asked this question directly relating to his answer where he said that 131 is not affected by the new provisions which he's expected to enact within the 2 years of the passing of this bill to do with genetic testing. And look, if so, can he just make that clear for...
I did.
Right, so the Minister says I did. So it's now on record that people who are sufferers of genetic conditions who may be affected by the genetic provision tests will not be subject to the provisions in Part 5 in total. So I guess they can expect that the secondary legislation enacted by the Minister will exempt them from Part 5.
Mr. Chair, look, I'm going to deal with this question once and for all, and I made my point clear before. I repeat it. Clause 131 is about instruments regarding the transfer of life insurance policies. Instruments, that is a differentiation. You're confusing, I could suggest to the member that she's confusing the issue in Part 4. This is about transfer of instruments.
Member?
Question now close.
The question is that the debate on this now closed. Those of that opinion will say aye. To the contrary, no. The ayes have it. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
At New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
6 opposed.
The ayes are 68, the noes are 55. The question is agreed to. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 125 be agreed to. All those in favour say aye. To the contrary, no. The noes have it. The party vote has been called for. The clerk will conduct the party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
At New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The motion is not agreed to. The question is that the Honourable Dr Duncan Webb's tabled amendment inserting new clause 125A be agreed to. All those in favour say aye. To the contrary, no. The noes have it. The ayes, has the party vote been called for? Clerk will conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
At New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The motion is not agreed to. The question is that Honourable Dr Duncan Webb's tabled amendment inserting new subclause 3 in clause 126 be agreed to. All those in favour say aye. To the contrary, no. The noes have it. A party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 in favour.
At New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The motion is not agreed to. The question is that the Honourable Dr Duncan Webb's tabled amendment to clause 131 be agreed to. All those in favour say aye. To the contrary, no. The noes have it. A party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 in favour.
At New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The motion is not agreed to. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 132 be agreed to. All those in favour say aye. To the contrary, no. The noes have it. The party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
At New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The motion is not agreed to. The question is that the Honourable Dr Duncan Webb's tabled amendment to clause 135 be agreed to. All those in favour say aye. To the contrary, no. The noes have it. Party vote has been called for. The clerk will conduct the party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The motion is not agreed to. The question is that the Honourable Dr Duncan Webb's tabled amendment to clause 141, subpart 1 be agreed to. All those in favour say aye. To the contrary, no. The noes have it. A party vote has been called for. The clerk will conduct the party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The motion is not agreed to. The question is that the Honourable Dr Duncan Webb's tabled amendment to clause 146 be agreed to. All those in favour say aye. To the contrary, no. The noes have it.
Mr Chairman.
I'm sorry, I think you've missed a question, sir. If you've just asked that one, 146, you've missed one, sir.
Could I go back up? Okay. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The motion is not agreed to. The question is that the Honourable Dr Duncan Webb's tabled amendment to clause 141, bar 3 be agreed to. All those in favour say aye. To the contrary, no. The noes have it. A party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The motion is not agreed to. The question is that the Honourable Dr Duncan Webb's tabled amendment to clause 149 be agreed to. All those in favour say aye. To the contrary, no. The noes have it. A party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55 and the noes are 68. The motion is not agreed to. The question is that the Honourable Dr Duncan Webb's tabled amendment inserting new paragraph E in clause 150 be agreed to. All those in favour say aye. To the contrary, no. The noes have it. A party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The motion is not agreed to. The question is that the Honourable Dr Duncan Webb's tabled amendment inserting new paragraph F in clause 150 be agreed to. All those in favour say aye. To the contrary, no. The noes have it. A party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The motion is not agreed to. The question is that part 5 stand part. All those in favour say aye. To the contrary, no. The ayes have it. A party vote has been called for. The clerk will conduct the party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
ACT New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
6 opposed.
The ayes are 68, the noes are 55. The motion is agreed to. Members, we now come to part 6. This is debate on clauses 165 to 168, regulations and miscellaneous provisions. The question is that part 6 stand part.
Mr Chair.
Aotearoa Williams.
Thank you, Mr Chair, for the opportunity to take a call on this part. I'm going to combine the questions into essentially one. It's a question of prioritisation of the regulatory making functions under this Act, which the Minister is empowered to make. The prioritisation exercise for making these provisions would have been entirely different before the new sub-part 4 was introduced. And the timing provisions are different too. Even though the regulatory making powers under part 4, which is related to brokers, is really important, and we asked the Minister a number of questions about the regulatory making powers in that part. They don't have a timing requirement on them. They are required to be made in the future, and there is a real importance for them to be made, but there's a longer time frame on them, whereas the other regulations in the Act are required to be made within 2 years. Can the Minister give some clarity on how he intends to prioritise his regulatory making powers and with what kind of time frame we can expect the exercise of those powers of secondary legislation making to be exercised by him in Ordering Council?
Honourable Dr Duncan Webb.
Just following on from Aotearoa Williams, I think one of the questions I have and one of the suggestions I have is that these regulations are absolutely the guts of the bill, if you like, and they impose the real workings of that where it hits the ground. And I'm looking in particular at regulation section 165(4), which talks about the interest. And I've raised before that if the Minister doesn't make these regulations, then there's real problems. And nowhere that I can see, unless I've missed it, nowhere that I can see is there any requirement that the regulations be made. And we talked about that in respect of genetic testing. I've talked about it in respect of interest rates. And I would very much like to see that. The other thing I'd say about regulations is I see that the Minister has obligations to consult under 165(3). My concern in this area is always that consultation is undertaken but it's not balanced, and I'm wondering if he could discuss whether he will be consulting with consumers or consumer organisations, or whether perhaps he'll be setting up some kind of reference group that can assist him to make sure that the consumer voice is properly and adequately heard when those regulations are made.
Mr. Chair, okay, well, we're really getting into the death knells of this, aren't we? Look, I'll just make a general point. 166, the clause there, that's to do with insurance intermediary arrangements. We've never used these arrangements before. They've just been carried over, so don't really see a need for that to be, for regulations to be made in respect of those. There are some very specific things that we will need to set through regulations, such as the interest rate on death in the event of death. So there are some very specific stuff, but it's actually very limited in nature. And so this is just giving the regulation making power, which obviously is better than putting the primary legislation, because things like interest rates you may want to change over time. So there's not a great requirement, not a great intent to go out and do a whole lot of regulations on it. Obviously, if we're going to do that, we will be talking to all relevant parties. And I do meet with consumer advocacy groups quite regularly, actually. I've met them over a number of bills. So it'll be horses for courses and what we're appropriate. So I don't think there's any big deal in this.
Suze Redmayne.
I move that debate on this question now close.
The question is that the question is that debate on this question now close. All those in favour say aye. To the contrary, no. The ayes have it. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
ACT New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
6 opposed.
The ayes are 68, the noes are 55. The motion is agreed to. The question is that Part 6 stand part. All those in favour say aye. To the contrary, no. The ayes have it. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
ACT New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
6 opposed.
The ayes are 68 and the noes are 55. The motion is agreed to. Members, we now come to Part 7. Part 7, this is a debate on clauses 169 to 193, repeals and amendments to other acts in Schedules 4 to 6. The question is that Part 7 stand apart.
Mr Chair.
Dr Duncan Webb.
I'm very happy to have an opportunity to speak on this part, but very unhappy about what is in this part. In particular, the insurance industry has got a free ride on unfair contracts to date. And this was our opportunity to pull that industry into line and bring them into the Fair Trading Act unfair contract terms regime. Now, I don't know how they do it, but once again, they've managed to persuade the Minister to let them off the hook. Because if you look at Clause 176, which inserts Clause 46KA into the Fair Trading Act, it, in a kind of limp-wristed, half-hearted way, brings the insurance industry into the unfair contracts regime. Now, that regime, just for those who aren't aware of it, is a regime where if there is a clause in a standard form contract which is seen as unfair and onerous in a consumer contract, then it can be referred to the Commerce Commission, who can declare it as unfair and essentially strike it out. It's not heavily used, but there's nevertheless a discipline that sits out there, particularly for large corporates like banks, insurance companies and so on, except insurers have been not effectively caught by it so far. And here we have a clause which is purporting to bring them into it, but it carves out a whole lot of aspects of an insurance contract which don't go into the regime. And Minister, I think you should think very carefully about this. Now, some of them you can kind of understand. The price, basically the premiums. So in banking contracts, you can't complain about your interest rate because it's basically the guts of the contract. It's the very nature of the contract. Similarly, in an insurance contract, the premiums are the premiums. You either accept them or you don't, but you can't really complain that they're unfair and get that struck out as some kind of unfair clause. But the one that's deeply offensive is exclusion clauses. So in the 46KA, the new section, subsection 2E, it says, for the purposes of this clause, a term of insurance defines the main subject matter of the contract and therefore can't be subject to the regime if it excludes or limits the liability of the insurer to indemnify the policyholder on the happening of certain events or the existence of certain circumstances. So let's just understand what it means. It means an insurer is allowed an unfair exclusion clause. So if they had an exclusion clause that says you're not insured if you're driving a red car, totally irrational and unfair, you couldn't say it's unfair. So it becomes really problematic. Now, there are exclusion clauses which are, some of them are reasonable, but they shouldn't worry about that. So if it's like, okay, if you're not a licensed driver, you're not insured. That's fine. That makes perfect sense. Or even some of the ones that push it a bit further. If you're driving a car on something which isn't a legal road, so you're off-roading, you're not insured. That's fine. They make sense. They're reasonable exclusion clauses. But exclusion clauses which are actually unfair, things which are irrational, which don't make sense in the context of insurance, can't be complained about. You can complain about your bank, you can complain about your electricity company, you can complain about all of these terms of a contract in every other sphere of commerce and business. But somehow there's a wee free pass, another free pass for the insurance industry. And this is a change. You know this. I'd like to hear you speak to this and say, when I got this bill in its draft form, I listened to who and decided to change it, and why? Because this is not the draft that I saw. And certainly in terms of unfair contract terms, insurers need to be brought into the regime, because as a matter of practice, insurers do rely on exclusion clauses, and they need to be held to account. So I think this is the most invidious clause in this entire bill, and I'd be interested in the Minister's views.
Mr. Chair.
Andrew Bailey.
Well, first of all, I reject the assertion that they're getting an easy ride. I think the former minister got lost in this issue. I think it's fair to say that the member has had an exposure to the industry and he has come to a predetermined view about reputation of insurance companies and whether they act in the best interest of their consumers or not, or customers or policy holders. And I think this reflects, the previous drafting reflected his personal view about insurance companies, which was basically a very negative view about that industry. When I saw this clause, I had quite significant conversations with the insurance sector and asked them to give me good reasons why they would want this bill changed, this part of the bill changed. And I listened to those arguments, and I also had officials arguing on the other side. And I'll tell you what, First of all, I think the Minister got lost because he lost the big picture. If we were to continue with the provision that the Minister had in the original bill, that ultimately would have meant that every New Zealander would have ended up paying a higher policy premium. And personally, I thought that was a bad thing. And here we are, we've got a member from the Labour Party saying that they're standing for ordinary New Zealanders. Ideally, if he had slavishly followed his personal objective around this would have meant that ordinary New Zealanders, to use that word quote unquote, would have ended up paying more in their premiums than they ought to. That was the first point. The second point is I don't think the member actually considered what the unintended consequence of what he had proposed in his former drafting. And the issue is that in New Zealand, we have what's called an all-risk approach to insurance, which means that when you do take on a policy, in the main, it covers all risks. Where if we adopted the approach that the Minister previously proposed, it would have pushed us towards the Australian model of being a defined policy or a defined perils policy. That would have been even worse for New Zealanders, because then we would have the example of, let's say, a house event trying to define what would happen, what type of cover you would have in the event of a peril, and requiring the obligation for every policyholder, all ordinary New Zealanders, quote unquote, to be able to clearly define what was the peril that they wanted insurance for. And of course, if they inadvertently miss one out, then they wouldn't have been covered by the type of policies that are currently available in New Zealand. So that's the second point. That would have been an absolute adverse implication for the New Zealand insurance industry and also, more importantly, for policyholders in New Zealand. And I think there is a recognition that these contracts are different from banking contracts and the other ones that he referred to. Insurance policies are quite specific and different and need to be. The final point is, he talks about the Fair Trading Act. Actually, insurers will be captured under the COFI, Conduct of Financial Institutions regime that comes into force 31 March 2025, i.e. in a few months' time, and therefore they are subject to making sure they are operating in the best interest of their consumers, which I've been very explicit to all industry players that is one of their primary objectives. And so it is wrong to assume that they won't be subject to oversight. They will be. Ultimately, the proposal the member put forward would have been bad for New Zealanders, and that's why it's been changed.
Aotearoa Williams.
This is an outrageous position for us to be in a committee stage, where we have a minister in the chair alleging that another member has a personal view which has coloured the way that he is engaged with this legislation, when that minister will not answer repeated questions from me about which submitters asked for certain changes, when I know there was only one stakeholder in some cases who asked for a certain change, and whether that is an appropriate legislative process for this House to conduct. Whether it is appropriate, Minister, I ask you very specifically this time, is it appropriate for the Insurance Council to be the only submitter to ask for a change, and for officials under your watch to make exactly the change they have asked for, to the detriment of consumers, and for you then, for the Minister then, to claim to the media and to this House that he has initiated a legislative reform package which is good for consumers, when we know that over and over and over again in this piece of legislation it has gone from a Labor piece of work which tried to balance the interests of consumers and insurers to then a piece of legislation which went to Cabinet and was approved, which removed many of those protections for consumers, but was something which was still a reasonably balanced package of legal reform that was still very much needed, to then at the Select Committee stage having only one or two submitters who asked for a certain change in certain areas, were then given that change, and then it was introduced into this House. Is that an appropriate way for legislation to be then signed off in this House? These are the questions. This is why we are asking these questions over and over again, and we have not got an answer to that. And for then the Minister to give a speech that alleges that a member in this House has a personal biased view of certain stakeholders is absolutely outrageous, and we are owed an answer to the questions about who is asking for these changes, whether they are widely supported. Are they still in the interest of consumers, like it is being claimed here and like it is being presented? And inevitably what will be said by the Minister in the third reading, that this is a piece of law which benefits consumers and fairly benefits them in regards to their interests being balanced with those of the insurers who have much more power in these situations than they do. My question is about the changes here. Which ones were changes which were in response to one or two stakeholders, and which ones were supported more widely? And I'm also going to ask him about the prioritisation. Which ones were the priority of the insurance industry, and which ones were only supported by a few but were seen as changes by him which were worthy of making?
Mr Chair.
Honourable Andrew Bailey.
Look, the member may feign enragement about the whole thing, but these changes were included in the draft bill that went before the Select Committee. There has been no surprise about it. There's been absolutely no surprise. It's been through a long Select Committee process. And interestingly, if the member should be aware, I hope she's aware, there were actually a lot of submitters on this point, on this issue that's been raised here. And in general, the support of the bill, there were very few opposed. Most of them were strongly in favour of this bill and the proposal around this specific issue. So, you know, this is what a parliamentary process is. They go through a Select Committee process, they have a good hearing, have people come and submit on it. We're obviously doing a committee of the whole today. So to be outraged about it and to try and say that some sort of blindsided event that's occurred is wrong. It's been through a full Select Committee process.
Members, the time has come for me to report progress.
Thank you, Mr Chairman.
The House is resumed.
Madam Speaker, the committee has further considered the contracts of insurance bill and reports that it has made progress on the bill.
For a motion? I move.
I move that the report be adopted.
Thank you. The question is that the motion be agreed to. Those of that opinion will say aye. To the contrary, no. The motion is agreed. The contracts of insurance bill is set down for further consideration in committee next sitting day. The House will adjourn until 2 p.m. this afternoon.
Mr. Speaker.
E te atua kaharawa, ka tuku whakamuimati atu mātou, mōna karakia ko waihotia mai ki runga i a mātou. Ka waihi o mātou pānga whaiaro katoa ki te taha, ka mihi mātou ki te kingi me te inoi atu, mō te arihitanga i roto i o mātou whakaaroarohanga. Kia mohio ai, kia whakaiti ai tā mātou whakahaere i ngā take o te wharenei. Mō te oranga, te maungarongo me te aroha o Aotearoa. Āmene.
Amen. Members, the Honourable Kira McAnulty asked me to rule on the criteria and processes for personal explanations. First, a personal explanation must be personal to the member making it. Standing Orders Speaker's Rulings 152/6 affirm that. Most commonly, they are used to correct misleading statements made by the member or used by a member to defend their honour or reputation. Second, a personal explanation may not be used to attack or criticise other members or persons outside the House. To do so is an abuse of the process. Speaker's Ruling 153/4. Misuse of personal explanations is particularly problematic because it makes it less likely that the House will grant leave for future personal explanations. Speaker's Ruling 152/7. Personal explanations are permitted by agreement of the House. It's my intention that from this point on, members seeking that indulgence from the House will need to give a succinct but clear explanation of why they are seeking the leave, so that the House can make a judgment on that request.
Point of order.
Point of order. The Honourable Kira McAnulty.
Thank you very much, Mr. Speaker. It's clear that that was a considered view, and I appreciate the effort and time that's gone into it. You used the term abuse of that privilege, and you've provided the House with some clear guidance as to how a member should approach seeking leave for a personal explanation in future. Can the House therefore deem from your response that the personal explanation made by the Right Honourable Winston Peters was indeed an abuse of that privilege?
What I would say is that it did not represent the intention of the Speaker's rulings in this matter, would be a better way to put it. And I think the test always has to be, if the House has given someone an opportunity to make a personal statement, and that personal statement doesn't contain anything that might not be said in general debate, then there is no further action required. But the real point is that it is the House's acquiescence that allows someone to make that personal statement, and therefore both not only me but everyone has to be fully understanding what it's about. And I think also this sets grounds for further consideration if there is ongoing abuse of that process. Petitions. A petition has been delivered to the Clerk for presentation.
Petition of New Zealand Nurses Organisation requesting that the House urge the Government to build the new Dunedin Hospital as planned.
Minister, that petition stands referred to the Petitions Committee. Ministers have delivered 3 papers for presentation.
2023-24 annual reports for the Electoral Commission and the Inspector General of Intelligence and Security, statement of performance expectations and statement of intent for Guardians of New Zealand superannuation.
Those papers are published under the authority of the House. A Select Committee paper has been delivered for presentation.
Report of the Business Committee on the recommended sitting programme for 2025.
The report is set down for consideration. No bills have been introduced. A select committee report has been delivered for presentation. Oh, we've got that. Sorry, repeating it again. No bills have been introduced. We come now to oral questions. A point of order.
Point of order, Mr Speaker.
Point of order, the Honourable Casey Costello.
Mr Speaker, I seek leave to make a personal explanation to correct a statement I made during question time yesterday.
Leave is sought for that purpose. Is there any objection? There appears to be none.
Mr Speaker, in response to supplementary questions from Dr Aotearoa during question number 6 on 5th of November 2024, I wish to correct the Hansard record which quotes me stating that the document in question was released unredacted. This is not the case. I was mistaken as an unredacted version was provided to the Speaker. I'm taking the first possible opportunity to correct this and apologise for any confusion to the House.
Come now to oral questions. First, in the name of Ryan Hamilton.
Thank you, Mr Speaker. My question is to the Minister of Finance and asks, what recent reports has she seen on the economy?
Mr Speaker, today's Statistics New Zealand released its labour market statistics for the September quarter. This release includes information from the Household Labour Force Survey, which looks at people's labour force status, and the Quarterly Employment Survey, which captures earnings, paid hours and jobs. The Household Labour Force Survey showed that the unemployment rate increased from 4.6 to 4.8% in the quarter. And the Quarterly Employment Survey showed that average hourly earnings increased 3.9% over the previous year.
Supplementary. Why is unemployment rising?
Mr Speaker, unemployment is rising and has been rising since 2001 because New Zealand has been in a prolonged recession with monetary tightening used to drive high inflation out of the economy. Sadly, recessions have a human cost, and my heart goes out to people who have lost their jobs or who are struggling to enter the labour market. Mr Speaker, rising unemployment is a reminder of how letting inflation get a grip on the economy is so damaging.
Supplementary.
Just wait till the House quiets itself down. Okay.
Was the increase in the unemployment rate as much as expected?
Mr Speaker, no. The increase from 4.6% to 4.8% was lower than forecasters had been predicting. In its August monetary policy statement, the Reserve Bank had forecast 5% unemployment, and the Treasury had forecast 5.2% in the budget update in May. To give some historical context, I would also point out to members that over the last 15 years, the average unemployment rate in New Zealand has been 5%.
Supplementary. What is the outlook for unemployment?
Mr Speaker, today's results reflect where we are in the economic cycle. Typically, when the economy starts underperforming, the unemployment rate is slow to rise. And then when the economy starts to pick up, it can be slow to fall. In other words, unemployment is a lagging indicator. Now, there are clear indications that the economy has turned upwards. But even so, I would expect the unemployment rate to rise a bit further before beginning to fall. In the August monetary policy statement, for example, the Reserve Bank was forecasting the unemployment rate to rise to a peak of 5.4% early next year, then steadily decline.
Question number 2, the Right Honourable Chris Hipkins.
Thank you, Mr Speaker. To the Prime Minister, does he stand by all of his government statements and actions?
The Prime Minister.
Yes, and especially our efforts to rebuild New Zealand's economy and to support Kiwis with the cost of living. In the last year, wage growth has outpaced the cost of living in the first year of our new government. Compared that to the 13 quarters in a row under Labour where wages grew slower than inflation. That wage growth comes on top of the cost of living support our government has delivered for Kiwis through tax relief, increases to working for families and family boosts to support Kiwis with the cost of childcare. There's still a lot more to do, which is why we're focused on unleashing investment and clearing away red tape and making sure that we can rebuild the economy and lift incomes for all New Zealanders.
Supplementary. Does he stand by his statement, quote, "The government has no plan and never has had plans to amend or revise the treaty or the treaty settlements we have all worked so very hard together to achieve," end quote? If so, how does he reconcile that with the introduction tomorrow of a government bill that completely rewrites the understanding of the treaty upon which those settlements have been based?
In answer to the first part of the question, yes, and as I have explained in this House before, it is government policy to support this bill to first reading. It is also government policy to give parties a free vote at the second reading. The National Party which I lead will not be supporting it, and the only way this bill will become law is if the opposition parties do support it.
Supplementary question, Mr Speaker. Has the government received any advice indicating that the Treaty Principles Bill could undermine the full and final nature of treaty settlements already concluded? If so, what was the nature of that advice?
I haven't seen that advice, but what I would say is that the treaty principles, the treaty is not changing and treaty settlements are not changing.
Supplementary. Why does the government believe the principle of active protection, which places upon the Crown a positive duty to protect Māori interests and taonga, should be extinguished by an Act of Parliament?
Well, again, I think I've been very consistent on this point. Our coalition government has a policy to support this bill at first reading, but the parties are then free to support it or not support it at the second reading. The National Party won't be supporting it, and the only way this bill becomes a law is if the parties on the opposition support it.
The point of order, the Honourable Chris Hipkins.
Mr Speaker, the government is introducing a government bill. I'm asking the Prime Minister about the government's policy intention, not what the government's parties may wish to do subsequent to that. By introducing a government piece of legislation, the government of which the member is still the Prime Minister, as far as I know, is responsible. To say that, oh, well, we're not going to support it later on down the track can't be an acceptable answer when he's being asked a question about a bill that the government is currently introducing.
There are a number of ways you can get into that. It's not for me to start making those sort of judgments. I would ask the Prime Minister to, if he wishes to have another look at it, or ask the question again, actually, so I can make a better assessment of where it's at.
Why does the government believe that the principle of active protection, which places upon the Crown a positive duty to protect Māori interests and taonga, should be extinguished by an Act of Parliament?
Well, it is government policy to support this bill to first reading. That's what we're doing. It is also government policy for the parties in the coalition government to be free to support it or not support it in the second reading.
Mr Speaker,
point of order.
The Prime Minister has confirmed that the government are supporting the bill as introduced. I am asking him a question about the provisions in the bill, which he has indicated the government is introducing and supporting. I don't think saying that the government supporting a bill that it introduces negates the fact that he should then answer questions on what the bill actually does.
Yeah, I'm just racking my head for a minute, trying to think of previous situations. I can think of one around superannuation way back at the beginning of MMP, where exactly that position was taken and accepted by the arrangements in the House. Point of order, the Honourable Shane Jones, if something new.
Highly likely.
Well, that's, yeah, but you've got to be absolutely certain.
Sir, the Prime Minister is clarifying, as other governments have done so, that policy is not static. Policy is dynamic. For the purposes of this bill, the policy will be agreed to the point of introduction. But to suggest that it represents the static form of policy is wrong, and you should have ruled accordingly.
That actually wasn't a point of order. You're giving us a lecture on how Parliament should work. Useful, but not exactly a point of order.
Mr Speaker, the fact remains that when the government introduces a bill to the House, even if they're indicating that they don't intend to progress it all the way through the process, they still have to answer questions on that bill. The Prime Minister and the Ministers concerned still have an accountability to the House to explain to the House and to answer questions in the House about the effect of the bill if it was passed. Otherwise, why would it be introduced as a government bill? My question to the Prime Minister is about the effect of the legislation. It's not about whether the government intends to support it further or not. It's about the effect of the legislation as being introduced by the government.
Yeah, and what you're highlighting here is, in my opinion, a collision between the MMP style of government that New Zealand now has in the Westminster style of government, which is the mechanism for how government is delivered. But I will ask the Prime Minister to make a further comment on that.
The only comment I'd add is that the bill hasn't been introduced to the Parliament.
Mr Speaker, when the Treaty Principles Bill states that the rights of Māori, quote, differ from the rights that everyone has a reasonable expectation to enjoy when they are specified in legislation, treaty settlements or other agreements, so only when they are specified in legislation, treaty settlements or other agreements with the Crown, end quote, is it the government's intention that the treaty itself fall within the definition of other agreement with the Crown?
The bill has not been lodged.
Point of order, Mr Speaker. That can't be a legitimate explanation. The government has made this decision. There's a cabinet minute of it, which has been publicly released. I've quoted directly from the cabinet minute. It's therefore legitimate for the Prime Minister to be asked and therefore answer the question.
Yeah, that would assume that the bill that's going to be introduced is the same bill. The Honourable Simeon Brown.
Was when the bill says X, the bill has not yet been lodged, and therefore the question was addressed adequately by the Prime Minister.
Yeah, it doesn't fully obfuscate ministerial responsibility. The Honourable David Seymour.
Oh, well, I was just going to say, if the Leader of the Labor Party would like to put his questions to the Minister responsible, I'm right here, but I don't see any questions.
Yeah, good. That's a very kind offer.
Mr Speaker, I wonder whether you could allow me to reword the question, seeing as the Prime Minister refused to answer it.
I will.
Thank you, Mr Speaker. When the Cabinet agreed to the introduction of a bill that states that the rights of Māori differ from the rights that everyone else has a reasonable expectation to enjoy when they are specified, only when they are specified in legislation, treaty settlements or other agreements with the Crown, end quote, was it the government's intention that the treaty itself fall within the definition of other agreement with the Crown?
And as I said in my earlier answers, the first position I'll make is that it is government policy to support this bill to first reading. It is also government policy that parties are free to vote at the second reading. The National Party will not be supporting it, and it won't become law unless the opposition parties do so.
Point of order, Mr Speaker.
I think I can anticipate the point of order, but make it.
I didn't ask him any question about the bill as potentially introduced. I asked him a question about a decision that the Cabinet has taken, the minute of which has now been publicly released, and I asked him about the Cabinet's intention in making that decision.
Does the Prime Minister want to respond to that?
I said it is government policy to support this bill to first reading.
Mr Speaker, I'm happy to repeat the question again.
No, you're not accepting the answer, which is probably a reasonable answer, given that Cabinet would have known at the time that it was supporting the bill that it was not going to get sufficient support to pass. It's not unreasonable. You're asking another question, I think, about whether or not that has implications for the treaty itself.
I'm asking a question about the interpretation of the decision that the Cabinet has just made and agreed to. That decision has been made. There is a Cabinet minute that confirms that decision. Asking the Prime Minister to explain a decision that the Cabinet has already made, that the decision has been, where that is publicly minuted and recorded, is not unreasonable to expect that he will answer that more than just simply saying that it's the government policy to support it.
Well, but that is an answer. And we could go around forever and ever if that is the same question asked and the same answer given.
Well, point of order, Mr Speaker, it cannot be the case that the government can make decisions and then not be willing to answer questions on the impact of the decisions that they have taken. It is their number one accountability to this House to explain the decisions that they have taken as a government. They have taken a decision around particular definitional issues, around what rights of Māori are or aren't under the Treaty Principles Bill that they're going to introduce. And I'm asking him a question specifically about that decision that they have already taken. I didn't ask him about the passage of the bill, didn't ask him about their intentions further down the track. I asked him about the implications of a decision they have already taken.
Ask your question again.
When the Cabinet decided to support in the introduction of a bill that states, quote, that the rights of Māori differ from the rights that everyone else has a reasonable expectation to enjoy only when they are specified in legislation, treaty settlements or other agreements with the Crown, end quote, was it the government's intention that the treaty itself fall within the definition of other agreement with the Crown.
A point of order, the Honourable David Seymour.
Mr. Speaker, in the spirit of being helpful to the House, the member is...
No, sorry. Points of order are heard in silence.
It's not that novel concept. The member is quoting the body text of a cabinet paper. Not a recommendation, not a piece of legal drafting, the body text of a cabinet paper. He's actually incorrect to say that that's what the legislation does. And when it is tabled tomorrow, I'm sure he will see that.
Well, that's very interesting. I mean, I think the point is the question has been addressed. Prime Minister might like to say something further. Doesn't want to.
Point of order, Mr. Speaker. The Prime Minister cannot possibly have answered the question. This is quite a significant issue. This is a government piece of legislation. The Prime Minister is the Prime Minister for all government legislation, not just the things that are inconvenient or convenient to him. And he has to be able to answer questions on all decisions the Cabinet has taken. To simply say, oh, well, it's not a decision of Cabinet that we're going to subsequently agree with further down the track, isn't a legitimate answer. This is a decision that's been taken. Asking the Prime Minister to explain it, that is his job.
But it's a simultaneous decision. And look, I don't want to reach for the books and start getting out a number of Speaker's rulings from Speaker Wilson. But the fact of the matter is the question has been addressed, not satisfactorily, and that's acknowledged inside Speaker's rulings, that questions may not always be answered satisfactorily to the satisfaction of the questioner, but that doesn't mean that we go on forever on a particular question line.
Supplementary question. Does he stand by his statement, quote, "We want to work with Māori, we want to be able to partner," end quote? If so, how does that align with the Waitangi Tribunal's view that the bill the government is intending to introduce is, quote, "poorly designed, not informed by consultation with Māori, not justified by robust policy analysis, and risks destroying the very foundation of the constitutional arrangements of this country"?
Well, I would say to that member, we are wanting to work with Māori on some of the biggest challenges and opportunities this country has. You see us doing that with respect to how we're driving immunisation rates for under 2-year-olds, partnering with Māori health organisations to do so. And think about the way that we're working around emergency housing projects, for example. We want to improve outcomes for Māori and non-Māori, and we're going to continue to do that.
Point of order, Mr. Speaker. The Prime Minister appears to have...
Just wait for the House to settle down.
The Prime Minister appears to have selectively ignored the substance of the question, which was a direct quote from the findings of the Waitangi Tribunal, which were released yesterday.
That's right, but there were multiple legs to the question. He's answered one of those which meets the criteria required. The Honourable Shane Jones, point of order.
So we're at the point of the House being brought into disrepute.
Oh.
That question was addressed. It was a comment taken from a recommendatory body. The Prime Minister addressed the question. You just articulated that's the threshold. To continue to relitigate that is to invite us all to break that rule. That can't possibly uphold the standards of the House.
Thank you for your commentary. The Honourable Chris Hipkins.
Mr. Speaker, what message does it send to Māori and non-Māori alike that in the same week the government proposes to bring forward the introduction of a divisive bill that threatens our shared understanding of the nation's founding document, his government is also sacking 40% of the staff working in the agency responsible for supporting Crown Māori relationships?
The member is conflating two separate issues that make no sense. We are making sure that we are delivering outcomes, and we're making sure we get a right-sized public service to do that. What we're not prepared to do is have an 84% increase in spending that drove up inflation, drove up interest rates, put the economy in recession, and then lays off people from work. So we are making sure we deal with the spending. It's not wasteful. We make sure that we're driving down inflation, interest rates, we're running the economy.
Question 3, Tim Costley.
Thank you, sir. To the Minister of Transport, what recent announcements has he made on the State Highway 1 Wellington Improvements Road of National Significance?
Mr. Speaker, yesterday I welcomed the NZTA board confirming the next steps on the State Highway 1 Wellington Improvements Road of National Significance. which our government campaigned on to enable Wellingtonians to get where they need to go quickly and safely. The expanded package includes a second Mount Victoria tunnel, upgrades to the Basin Reserve, and the addition of a duplicate terrace tunnel that will further boost productivity, reduce travel times for those travelling in their cars and on public transport.
Why is the government prioritising this project as a road of national significance?
Well, Mr. Speaker, Wellingtonians face significant congestion at peak times, and forecast population growth across the region is expected to significantly increase travel demand across the network. Without our government's road of national significance, the Wellington region could be looking at travel times increasing by up to 50% between Nauranga and the airport within 10 years. That's why we are prioritising this project for Wellington.
What does this road of national significance mean?
Just wait. The rule of being quiet applies to everyone when a question is being answered. Tim Costley.
Thank you, sir. What does this road of national significance mean for people and freight travelling through the Wellington region?
Well, Mr. Speaker, our government is continuing to move at pace to deliver infrastructure that will unlock economic growth, reduce travel times and improve safety. This expanded package in Wellington will result in significant travel time savings during peak times, reducing travel times from the northern suburbs to the CBD, hospital and airport by around 10 minutes to boost productivity and enable Wellingtonians to get where they need to go quickly and safely.
Supplementary, the Honourable Nicola Willis.
What impact does the Minister think these new developments will have for the constituents of the Wellington Central, Rongotai and Ohareau electorates, and has he received messages of congratulations from the representatives for those electorates?
Mr. Speaker, this project will have significant benefits, both for those driving their vehicles or on public transport in and around Wellington. As I said, up to 10 minutes of travel time savings for those moving between the northern suburbs and the airport. I've heard silence from the other side, but I must say, I did see some welcoming statements from Nicola Willis making very positive remarks about this project.
Supplementary. Can the Minister tell us how this road of national significance will benefit public transport users?
Well, Mr. Speaker, members in this House will be pleased to hear that by grade separating the Basin Reserve, those travelling on the number 1 bus between Island Bay and the railway station are forecast to save 9 minutes during morning peak times on their way to work and school. Additionally, those travelling on the number 2 bus between Minima and the CBD will notice a saving of 11 minutes on their journeys. Our government is committed to delivering the infrastructure we need to reduce congestion and support economic growth.
Question 4, Tiana Tuiono.
Thank you, Mr. Speaker. My question is to the Prime Minister and reads, does he stand by his statement that the treaty is our past, present and future? It has shaped the country we have become, and the obligation it imposes on both sides will always be with us. And if so, why is he supporting a bill that the Waitangi Tribunal findings state if the bill remained on the statute book for a considerable time, it was never repealed, it would mean the end of the treaty?
Yes, in answer to the first part of the question, and as I've said before, we will support the bill at first reading and then we'll vote against it at second reading. And the only reason that bill will remain on the statute book for a considerable time is if the opposition votes for it, because National won't be doing so.
Supplementary. How does he justify his support for the introduction of the Treaty Principles Bill in light of the Waitangi Tribunal's finding that, and I quote, if the bill were to be enacted, it would be the worst, most comprehensive breach of the treaty in modern times?
Well, as I said in my answer, it's not going to be enacted.
Supplementary. Is it not more important for the Prime Minister of Aotearoa, New Zealand, to honour the founding agreement of our nation than to honour a one-term coalition government?
Well, as I've said before, the reality is we are in an MMP environment with a coalition government. That is the reality of it. I'm sure the ACT Party didn't get everything they wanted. The National Party didn't get everything they wanted. We came to a compromise. This is the way that we're handling it. We will support it at first reading, but we're free to support it, not to support it at second reading, and that's what we'll do.
Supplementary.
Just that sort of general barracking just got to stop.
Supplementary. How does he respond to the finding of the Waitangi Tribunal that, and I quote, the Treaty Principles Bill would end the treaty partnership and any formal relationship between the Crown and Māori, and could have the impact of undoing everything that has been achieved for Māori in the past 40 years, end quote?
Well, if the opposition parties at second reading vote against it like the National Party will, it won't become law.
Point of order. Point of order.
Point of order, the Right Honourable Chris Hipkins.
Mr Speaker, the Prime Minister has no responsibility whatsoever for how the opposition parties vote, and yet has continued to refer to that in his answers today. He does, as Prime Minister, have responsibility for the decisions that his government has taken. This is another example of a member asking a question of the Prime Minister about decisions that his government has taken, which he has chosen to refer to decisions the opposition might take in his answer. He should answer for the government.
And he has done. He said in a number of times that it is the policy of the government. And the fact that the policy might be to vote for a first reading and not for any more, nonetheless, that is the policy. And the other question that is being asked is covered off, I think, by the problem you've got with the structures we have under MMP, where you form a government for parties that will have different views, make concessions to one another, which mean that there'll be some bills supported some way through the House that may not be supported through the rest. Now, if you want to turn around and say, hang on, you want to turn around and say that somehow I should rule that the provisions of the MMP electoral system do not apply inside this House, that would be an utter nonsense.
No, point of order, Mr Speaker, I'm not arguing that at all. I'm asking you to enforce the rules that say that the government needs to answer questions about decisions it's taken. The Prime Minister's repeatedly said the government has taken a decision to support the bill at first reading. Therefore, asking him to answer questions about the implications of that decision, about a bill that they have indicated they are supporting at first reading, is not asking him in any way to abrogate or to bypass the MMP party system. It's asking him to explain the implications of a decision that they have taken to support.
He did answer in a way that is a speculation about what might happen. He has previously said quite clearly supporting it for the first reading, not any further. That can't be clearer when you're asking about a Waitangi Tribunal position that what would happen if this was on the statute books for a longer time. For the Prime Minister to speculate, the only way that could happen would be if other parties in this House beyond his own and those who've declared a second reading against it voted for it. I don't think it's an unreasonable answer.
Supplementary. How does he respond to the finding of the Waitangi Tribunal that at present the progressing of the bill is having serious impacts on the relationship, but the bill, if enacted, would kill that relationship?
As I said, the bill will not be enacted if parties in the opposition vote against it.
Supplementary. Is having a 6-month-long process that risks dividing our nation with the possibility of misinformation thriving a price worth having to maintain his coalition?
Again, we are following process. We are making sure the government policies bill will be supported at first reading. There will be a 6-month select committee process. That is a chance for the public to engage with the process. Then it will come back to this House for a second reading, at which point it will be voted down.
Will the government support a shortened select committee process to save the significant expense that the House will go to in having the bill at select committee for 6 months, given the government has already determined it's going to fail at second reading?
No, but I think it is a bit rich from that member to raise expense when he and that member spent $1.2 billion on Three Waters and it went nowhere.
Question 5, the Honourable Barbara Edmonds.
Tēnā koe te mana whakawā.
To the Minister of Finance, does she stand by her statement that, quote, it is a priority to support New Zealanders into work, unquote? If so, how many additional people have become unemployed since she took office?
Mr. Speaker,
Nicola Willis.
I stand by my full statement from August, which was an answer to a question from the member. Quote, yes, it is a priority to support New Zealanders into work, and today's unemployment statistic is yet another reminder of how letting inflation get a grip on the economy was so damaging. And that, Mr. Speaker, is equally true today, as I said in reply to question 1. To the second point, the number of people unemployed in New Zealand has been rising steadily since 2021. Rising unemployment is not a new phenomenon. Up until the December quarter of 2023, that is the final 2 years of the last government, the number of people unemployed rose by 30,000. Since then, the number has risen by 25,000.
Supplementary. Does her heart go out to the 25,000 additional people since she took office who are now unemployed and where her personal income tax changes will have no effect as they have no job?
Mr. Speaker, to the first part of the question, yes. To the second part of the answer, the member is operating under a misapprehension that those unemployed today would stay in unemployment for the rest of the year. In fact, anyone with knowledge of the labour market would tell you that people come in and out of unemployment, and I expect that a large number of New Zealanders who do lose their jobs will then get jobs in which they will be paying lower taxes, so they will have more money in their bank accounts, and that will be a good thing.
Supplementary. Does her heart go out to the agriculture, forestry and fishing sector that is down 12,000 jobs, the manufacturing sector that is down 9,000 jobs, and the construction sector that is down 12,000 jobs since the election?
Yes, Mr. Speaker, it absolutely does. And my heart also goes out to every farmer who in these past 6 years had a government that was actively working against them, tying them up in red tape and blaming them for the environmental challenges of our country, rather than thanking them for putting food on the tables, bringing in export receipts and growing this economy.
Ruben Davidson.
Thank you, Mr. Speaker. How is she supporting TVNZ workers who have been informed today that their jobs are on the line, the latest local media casualties, in light of zero action by this government to support the local media sector?
Well, Mr. Speaker, I reject many of the characterisations in that question. Of course, the employment decisions of TVNZ are operational decisions that are necessarily arm's length from Minister, and I know that members opposite have a bit of a fraught history when it comes to inappropriate interventions in what should be independent matters, but if he wants to rewrite the rule book on that, I invite him to give us his ideas, because they sound like they might be quite silly.
Does her heart go out to Pacific people who face a 9.9% unemployment rate, and in particular Pacific youth aged 15 to 24, where 1 in 4 are now unemployed?
Yes, Mr. Speaker, it does, and that is why every day we are working to rebuild this economy, to bring inflation down so interest rates can drop, so businesses can have the confidence to invest and create new jobs, so that we are driving higher education standards, so we can have a more productive economy where more Pacific people have access to good future employment and education, and why, for example, Mr. Speaker, we are doing things like introducing fast-track consenting so that we can create more jobs on new developments faster rather than tying up projects in the Environment Court.
Supplementary.
I know it's a Wednesday. Everyone's very excited about all sorts of events happening in other parts of the world. Calm it.
Supplementary. Does her heart go out to the thousands of public servants and government service providers that have lost their jobs as a result of her public service cuts that have been described by one commentator as worse than Ruth Richardson?
Well, Mr. Speaker, here's what I'd say to that commentator. In the year of 2024 to 2024, the number of public servants increased by 421. And it is true that the number of public servants has reduced from its peak in December 2023. But, Mr. Speaker, I would say this: no government, no country can live beyond its means indefinitely. And if the position of that member remains that the way to restore the strength of this economy is to hire more public servants in the back office, then she should go out and tell New Zealand that, because I tell you this, New Zealanders know better. They want frontline services, they want investment in productive growth, they want services that deliver, and that is demonstrably was not delivered by a government that lived beyond its means, increased the number of public servants, but didn't increase the results they delivered.
Supplementary, Mr. Speaker.
Supplementary, the Honourable David Seymour.
Can the Finance Minister relate to Ruth Richardson, who also inherited a set of books from a spendthrift Labor government, along with inflexible Labor law initiatives that she had to reform?
Well, there's only one part of that.
Well,
there's only one part of that question was in order. But go back, say something.
Mr. Speaker, if I could make a couple of remarks. There's two reflections.
One would be enough, I think.
There is a reflection that I have often had recourse to, which is how difficult it is when people complain about the state of the House after the massive party that they had, the extent of the hangover, and complain about how quickly we're cleaning up the mess.
Point of order. The Right Honourable Winston, Right Honourable... I'm missing him. Right Honourable...
You should withdraw and apologise for that, Mr. Speaker.
I do, immediately.
Mr. Speaker, how is it possibly in order for that question to be in order and for the Minister of Finance to take a patsy question from a government minister to basically attack the opposition, but the government isn't willing to answer questions for the decision it itself has taken? The government has no responsibility for the previous government, has no responsibility actually for Ruth Richardson, but it does have a responsibility to answer questions about its own decisions, which so far today seems to be refusing to do.
Yeah, except that the question initially asked for a comparison, or what was there a comparison between the former Finance Minister and the current Finance Minister, with suggestion that one was bad and the other was worse. So some response is obviously going to come from that. The question that was asked by David Seymour was, does she relate to the former minister? I said at the time that I thought there was only a very small part of that was in order, and I think we will now move on. Question number 6, Dr. Vanessa Winner.
Thank you, Mr. Speaker. My question is for the Minister of Education and asks, what further update can she provide about her Make It Count action plan?
The Honourable Erica Stanton.
Mr. Speaker, as part of our action plan, last week I announced a $2.5 million plan to support secondary school students working towards the NCEA literacy and numeracy co-requisite requirements. And I'm pleased to share that from this term, 160 schools from across the country will be involved with up to 10,000 students. And on Monday, I announced our targeted maths program for Year 7 and 8 students. And I'm pleased to share that as of today, 374,521 primary and intermediate school students will benefit from maths workbooks and teacher guides, an increase of almost 5,000 students from yesterday. Mr. Speaker, this is so much more than just a stationary update. These high-quality, curriculum-aligned resources will help teachers and lift student achievement.
Supplementary. So I realise that the Ministry of Education people who may have given advice on the structure of the question are pretty keen on very long answers, but they're not particularly helpful for the House. Vanessa Winner.
What feedback has she heard from principals on her Make It Count action plan?
Mr. Speaker, feedback from schools has been positive. I'm delighted that school principals already want to get involved. One wrote, I would welcome the opportunity to be part of this trial and further develop the knowledge and skills to make a better difference to this cohort of learners. We strongly desire this cohort to enter secondary school with confidence in themselves as learners and set a positive trajectory for future learning.
Supplementary. What feedback has she received from the sector about other elements of the maths action plan?
Mr Speaker, last week I was delighted to release the new maths curriculum, which is a knowledge-rich curriculum and sets out a structured, evidence-informed approach based on the science of learning. And in response, the Education Hub founder, Dr Nina Hood, said, "I think the Minister's identified a number of key challenges that we have in the system and is putting in place steps to address those. It's just making sure that you're taught in the way that builds up knowledge sequentially. This government is ensuring that our teachers are supported to deliver lessons that cover what students need to learn and when they need to learn it."
What feedback has she received from education experts?
Mr Speaker, Massey University distinguished Professor Gavin Martin described our newly released math curriculum as a world-class document. He gave a big shout out to this government for all of the hard work, and in particular to our maths curriculum writers, including Audrey Tan. Mr Speaker, this government has an unrelenting focus on lifting student achievement and closing the equity gap in our education system so all children are equipped with what they need to succeed.
Question number 7, the Honourable Dr Aotearoa.
Thank you, Mr Speaker. My question is to the Associate Minister of Health and asks, does he agree with Dr Shane Retty when he said, "We are sending out a signal to people with myeloma and the people with leukemia that we understand and we haven't forgotten you"? And if so, what actions has he taken to deliver on that following receipt of the Cancer Control Agency's report titled Understanding Blood Cancer Medicine Availability in Aotearoa, New Zealand?
Mr Speaker.
The Honourable David Seymour.
In answer to the first part of the question, yes, absolutely. I happen to have known Dr Reddy for over 10 years. We're both from Whangarei, where in fact he worked with my mum, and he's one of the kindest and smartest people I know in politics. So I don't doubt for a moment his sincerity when he says that he is there to help people with cancer, as we all should be. In answer to the second part of the question, while the report's publication is relatively recent, this government has initially increased the budget for Pharmac over 4 years by $1.774 billion to fill in a fiscal hole left by the previous government when the member asking the question was the minister responsible. Subsequent to that, we've increased funding by a further $604 million. Now, it's not Dr Reddy's responsibility to choose which drugs to buy, or any politician for that matter, but what has happened, and I can tell you, when you go down to Pharmac and you hear from the people there, people work for Pharmac because they love buying medicines for Kiwis, and they are so busy funding new medicines for people with all manner of cancers, and I hope that soon they will fund more medicines for people with blood cancers.
Supplementary. Will he assure blood cancer patients that all 9 medicines identified in the report as offering significant clinical benefits but currently unfunded, or their equivalent, can be funded from the extra investment in Pharmac that he just cited?
Mr Speaker, the member knows very well, because she's had this job, that if a minister is able to ensure that a particular medicine will be funded, then Pharmac is not actually independent. Therefore, I can't stand here and say that Pharmac will fund a particular medicine, but what I can say is that they have never had more money to fund medicines in the history of this country. The amount of money that's going into it is exceptional, and it's already having its effects felt by people battling cancer up and down this country.
Cancer. Supplementary. Why didn't the government run a process that would have given these patients with blood cancer an equal shot at the funding to patients with solid tumours when, after all, Dr Shane Retty knew about this issue before the election?
Mr Speaker, that is precisely what the government has done. Pharmac do not discriminate. Their goal is to secure for eligible persons maximum medical benefit from the available funding that has been dramatically increased under this government. And let me just say it one more time for that member in case she's forgotten anything or didn't know when she was the Minister of Health herself. the biggest difference that a Minister of Health or a government or a Minister of Finance or a minister responsible for Pharmac can do is provide more money for the people at Pharmac to buy more medicines for Kiwis. And on that simple measure, it is not just 1-0, it's 1,000,000-0.
The Honourable Shane Reedy.
Thank you.
Hang on,
Can the member confirm that up to 4 blood cancer medicines have recently been funded by Pharmac?
Mr. Speaker, yes, I most certainly can, and that is an example of the decisions that Pharmac is making in order to ensure the money is put to the best possible use. It benefits people with solid tumours, it benefits people with blood cancers, but it also benefits people, for example, with type 1 diabetes who now have continuous glucose monitors funded by the taxpayer through Pharmac. Right across the board, this government is improving the access to medicines at a level never before seen in this country.
Supplementary. In light of his previous answers, am I to take it that people with blood cancers do not have an assurance that their cancer medicines will be funded, but solid tumour patients do? Or do solid tumours also have no assurance that they will be funded under this initiative?
Mr. Speaker, I think it's fairly straightforward. This government is very clear that Pharmac makes the decisions about which medicines to fund. We make the decisions about how much funding they receive. And the member knows this. What the government has done is ensure, in line with...
Just stop there. We'll hear the rest of this in absolute silence.
Thank you, Mr. Speaker. This is a very serious matter for a lot of New Zealanders, as I'm sure every member of this House who's known someone with cancer will know. As I was saying, what the government has done in line with pre-election commitments is provide funding that will allow a list of drugs or their equivalents to be funded. That commitment has been undertaken. From now on, we do everything we can to increase the amount of funding for Pharmac in order that more medicines can be bought. And for example, I'm happy to tell the House that I have asked Pharmac to be active and aggressive in showing how they, by funding more medicines, can save money right across all of society to boost the Pharmac budget even further than the current record levels, in order that more people with all types of ailments, including blood cancer, will have more chance of seeing their medicine funded sooner.
Supplementary, the Honourable Nicola Willis.
Can the Minister confirm that Pharmac's ability to deliver more cancer drugs to New Zealand cancer patients would have been made even harder if this government had allowed the time-limited shortfall in Pharmac funding, the fiscal cliff left by the previous government, to endure?
Mr. Speaker, I remember very well meeting with that minister, our Minister of Finance, and our meeting was scheduled to be about that shortfall. We knew that if we did nothing and carried on with the previous government's funding track, we would go from around $1.5 billion per year to about $1.1 billion per year. The advice I'd received from Pharmac was that Pharmac would first decide
everyone
that...
seems to have forgotten we're listening to the rest of this question in silence.
Some medicines and some indications, they would have to stop new patients getting those medicines. If that didn't save enough money to make up for the previous government's forecast budgeted shortfall, then they would have to actually take people off medications. You know, someone thinks it's funny to heckle. I can tell that young member that actually medications for people and people losing their medications when they are often terminally ill is a very serious matter. If you wouldn't mind listening, that'd be helpful. Mr. Speaker, we recognised that Pharmac would actually stop people receiving medicines they were already prescribed. That was the advice. So Nicola Willis and I, our Finance Minister, looked at each other at the start of the meeting and we said, we've just got to do it. And that was basically the end of the meeting.
Supplementary.
Just wait for the silence that is going to be across the House to the duration of this question.
Has Shane Retty broken his promise to blood cancer patients that they will not be forgotten, when it is actually true that they are an afterthought in this policy?
Mr Speaker, all I'm going to say to that is that there is a line in opposition politics between advocating and exploiting somebody, and I think what that member just did crossed that line.
Question number 8, Rauri Waititi.
Tēnā koe te pika o tira tēnā tātou I te whare. Ko taku pātai ki te Pirimia, my question is to the Prime Minister.
Rauri, just Mr Waititi, we'll just wait for the House to gather itself a minute. Okay, now you're right.
Tēnā koe e te pika. Ko taku pātai ki te Pirimia. My question is to the Prime Minister. Does he stand by all his government's statements and actions?
Yes.
Does he believe his coalition agreement with ACT has more mana and integrity than Te Tiriti or Waitangi?
As I've explained, we are in a coalition government. We are supporting as a government this bill to first reading, and beyond that it'll be up to each individual party as to whether it ultimately goes through and becomes law.
Point of order. The question was, does he believe his agreement with ACT has more mana and integrity than Te Tiriti or Waitangi? I didn't hear him address or even answer remotely close to that question.
Well, you could also argue that he's got no particular responsibility for asserting mana to one document or the other. The Prime Minister might like to make another comment on it.
I'm very clear that the Treaty of Waitangi has obligations on both Crown and iwi, and we will continue to uphold those under law.
How can tangata whenua and tangata tiriti voters have confidence in a Prime Minister who is willing to sponsor a select committee process which will become a platform for racism and misinformation, given the findings of the Waitangi Tribunal? The Māori-Crown relationship has already been damaged and would be further damaged, including by the select committee process, which we fear could become a platform for racism and misinformation that would prejudice Māori.
They can have confidence because they've got a government that's here to advance outcomes for Māori and non-Māori. And what I'd say to you is that when we have 12% of Māori students at year 8, thank you Labor government, we have a plan to deal with that. When we can move 1,500 children, many of them Māori, out of emergency housing accommodation in motels into permanent, proper homes, that's great. That's a fantastic outcome. It's better than what that government did for 6 years with an absolute majority for the last 3 and did so very little. It's fantastic that we are working incredibly well with Māori health organisations to improve immunisation rates for under 2-year-olds. That's about outcomes and getting things done for Māori and non-Māori.
Just make the comment that personal reflections aren't provided for. In fact, they're specifically provided against in standing orders, whether they are by way of interjection or in debate. Members need to remember that.
Supplementary. How can he sleep at night knowing that the violence of the Treaty Principles Bill is going to have a discriminatory intergenerational impact on our mokopuna?
I disagree with the characterisation of that question.
How many apologies is the state willing to make while they continue to inflict violence and abuse on our people whilst continuously breaching Te Tiriti or Waitangi?
Again, I disagree with the characterisation of that statement. This is a government that is here to advance and improve outcomes for Māori. And the sad reality is that under the previous administration, despite a much vaunted Māori caucus, very little was achieved for Māori.
That's true. How can he stand in this House and support a bill which the Waitangi Tribunal has described as, quote, the worst, let me emphasise, the worst, most comprehensive breach of the treaty, Te Tiriti, in modern time, end quote?
We're not supporting the bill in second reading.
Question number 9, Todd Stevenson.
Thank you, Mr Speaker. My question is to the Associate Minister of Health and asks, what recent announcements
has he seen about new funding for medicines in New Zealand?
Mr. Speaker, thank you very much for the question. A great many. In particular, the $1.774 billion boosts in the budget this year, followed by a further $600 million over the next 4 years to expand access. That means that the total budget over 4 years is $6.294 billion, or nearly $1.6 billion a year, averaged over the 4 years. This is far more than has been spent by Pharmac on medicines in history. In fact, it's about 60% more than the billion or so that it was only a few short years ago. At present, there are 11 cancer medicines being funded, 9 that are having feedback considered, for a total of 20. 21 non-cancer medicines in total, either funded, being considered or consulted on, for a total of 41 medicines that are now being either funded, considered feedback or consulted on as a result of that funding uplift.
Yeah, I just point out the question did ask about recent announcements. It's fair enough, but perhaps don't need to recite the entire announcement in the answer. Todd Stevenson.
Supplementary. Has he seen any specific announcements to respond to the shortages of asteroids?
Mr. Speaker, I just thought it was my duty to be candid to the House, but I can be briefer if you'd like. In terms of estradiol, this has been a major pain point for women up and down New Zealand. Due to recent developments in research around the relationships between hormone replacement therapy and breast cancer, global demand has nearly tripled for hormone replacement therapies. This has led to a worldwide shortage, and one that has affected New Zealand women as well. However, I'm proud to say that Pharmac has been agile and really quite active in getting out and finding supply, as well as getting new medicines funded in order to alleviate the shortage. As of the 1st of November, estradiol gel, a topical hormone treatment, is now funded, and it's estimated that 18,000 women will benefit from it in the first year. I'm well aware of the stress that this has caused from the correspondence I've received. However, I'm pleased to say that this problem has at least some way to being resolved thanks to the actions of Pharmac.
Supplementary. Has he seen any announcements that will support cancer patients?
Mr. Speaker, yes, I most certainly have, and I referred to them earlier. What I would say is that right across the world, the rate of progress in creating new treatments for cancer is truly astonishing. As someone who believes soundly in science, I am hesitant to describe it as a miracle, but what is presently happening and the number of cancer treatments coming online could be described as that if anything was to be. And this government's commitment is to keep finding ways to fund more and more of them to increase New Zealanders' survivability.
Question number 10, the Honourable Ginny Anderson.
Thank you, Mr. Speaker. My question is to the Minister of Police. Does he stand by the statement in his 20 September 2024 letter to the Chair of the Regulations Review Committee regarding the Arms Shooting Club's content of annual reports, Amendment Regulations 2024? Quote, I am comfortable that this technical change would not have negatively impacted public safety. And does he heed police advice on public safety?
Mr. Speaker.
The Honourable Mark Mitchell.
Yes, as I said in the letter, the purpose of the amendment regulations was to remove unnecessary administrative requirements for non-pistol clubs, which are largely run by volunteers. When clubs struggle to adhere to overly burdensome requirements, they run the risk of closure. Because the safe use and education about firearms in controlled environments like ranges is beneficial to public safety, it is important that regulations are workable for volunteer organisations so that this resource can remain available to the community. I would note that the government has only made 2 changes to firearms law and regulations in New Zealand. This regulation change, which is one of those, the other being strengthening the firearms prohibition orders regime to keep guns out of the hands of gang members. Police did not provide me public safety advice specifically in relation to this administrative regulation change, but did provide advice that the firearms prohibition orders being strengthened would have significant public safety benefits.
Why did he disregard police advice provided to him on the 6th of June on the proposed changes to shooting clubs that made numerous references to the public safety risks associated with reducing the reporting obligations on shooting clubs?
Well, Mr. Speaker, I made a decision to make a small technical change that Cabinet supported. That meant that ranges, the requirements for reporting was not duplicated, that removed some of the burden to these voluntary organisations, because we want these ranges to remain open, because we want people to have safe spaces where they learn firearms safety, and that is done at ranges.
Supplementary. Why did he tell Parliament on 19 September that gang members were not using gun ranges to practice their shooting skills when police advised him twice on the 30th of April and again on the 22nd of July, specifically of that risk?
Because gang members have not been getting access to gun ranges to practice with firearms.
His answer to oral question 9 on 19 September, or the two briefings released under the Official Information Act in April and July from police. If it is the latter, will he correct his answer in Parliament?
What is accurate is that I have had no advice from police to say that gang members are using gang ranges to practice with firearms.
Point of order, Mr. Speaker.
Point of order, Jenny Anderson.
I seek leave to table a document received under the Official Information Act that is not publicly available, that stipulates police advising the Minister of Police that there is a risk and that gang members are using gun ranges to practice their shooting skills.
Okay, why is that not publicly available?
It was received under the Official Information Act and provided to me.
It hasn't been released anywhere else?
No.
Leaver's thoughts for any objection? Can I just say, last question seemed a long way from the primary. But anyway.
Supplementary. Why did he support proposals to weaken police inspection powers over gun ranges when police had clearly advised him of the risks of unlicensed shooters, such as gang members, being allowed on gun ranges by licensed firearm owners?
Mr. Speaker, I'll reiterate again that the change that was made in the regulation was minor in nature, it was technical, and it was to remove some of the burden on our volunteers that are actually running these ranges. And the reason why we did it quickly is because they were coming up to AGM season, and we wanted to have confidence that these ranges remained open, because there is a big public safety issue around making sure that they do have access, people do have access to these ranges. Otherwise, what happens is you run the risk of whether it be that people start looking for alternative locations that aren't registered ranges, and that actually increases the risk to the public.
Supplementary question, the Honourable Nicole McKee.
Is the Minister confident that by supporting clubs and ranges, we are supporting safer communities?
Absolutely. I mean, the reality of it is, and many of the members' colleagues use ranges, is that they are the safe place to use firearms. That is where firearms safety is delivered. It is where firearms use is monitored. And the best thing that we can do around public safety is ensuring that these ranges, which are largely run by volunteers, they're given the support they need to keep those open.
Why is he risking public safety and the safety of frontline police officers by enabling a gun lobbyist to weaken our firearms regulations when he has been specifically advised by police that gang members are using gun ranges?
Well, I find it a bit rich for a previous police minister who oversaw some of the worst violence and growth in violence that we've seen in our country. And I will stand by our reputation any day in terms of prioritising public safety and doing everything that we can to continue to make sure that we increase public safety.
We've got it, Mark.
A point of order, the Honourable Shane Jones.
I'd ask that you reflect in the context of Speaker's rulings 190, 191 and 192 about the tenor of a host of the questions today. It is permissible in supplementary questions for people to draw on reports or take quotes, but we've had a plethora today of quotes taken grossly out of context in terms of the Treaty of Waitangi, quite apart from the inflammatory language that comes from that report. That's a matter for the authors of that Waitangi Tribunal report, but there are standards and there are parameters, sir, around how quotes and how statements and how reports are to be treated in the House. To avoid that brings the House into disrepute, and we are bordering perilously close to that today.
Speaking of the point of order, the Right Honourable Chris Hipkins.
Can I congratulate Shane Jones on reading one page of the standing orders and encourage him to read the entirety of the standing orders, because then he would find that that point of order itself violated a number of them.
No, I don't think that's a fair comment. I think if members of the House look at Speaker's Rulings 1913 and 1921, they'll get a fairly good guide on how quotations should be used. In the end, these are matters for the House and they have not been ruled out. Question 11, Ricardo Mendes-March.
Thank you, Mr. Speaker. My question is to the Minister of Health. Is he concerned about the impacts of poor access to dental care as outlined in this week's report from Dental for All? If so, what steps, if any, is he taking to reduce the cost of dental care?
Mr. Speaker.
The Honourable Shane Reti.
Yes, we know that good oral health is important for the wider health of New Zealanders. Currently, free dental care is provided to children and adolescents until the age of 18. There is also funding in place to support adults on low incomes. It's a long-standing issue that needs very careful consideration. However, as outlined in the Government policy statement, the importance of ensuring primary and community healthcare services, including oral health services, are responsive to need remains a priority.
What does he say to almost half of New Zealanders who put off going to the dentist because of cost, when he was unable to name a single initiative he has taken to reduce the cost of dental treatment?
Mr. Speaker, this government has spent $250 million approximately on oral health as a proportion of Vote Health. We're also committed to increasing community fluoridation, which will provide community benefits. We also provide support for the toothpaste to toothbrush program, which provides care to vulnerable populations and also to whānau of those vulnerable populations.
Will he take any actions to lower the cost of dental care, or will he allow families to go without being able to afford getting basic health care as a result of cost?
Mr. Speaker, vulnerable families have access to low-cost access dental care, including recent increases 2022, as I recall, to the emergency dental grant, which I believe is now called the Special Needs Dental Grant, for immediate and essential treatment.
Does he think low-income communities should go into debt to access dental care, or should dental care actually be part of the public healthcare system and be made free?
Mr. Speaker, I've already expressed that low-income and vulnerable families have access to dental care, but of course we'd like to do more.
Does he think the current for-profit private model that prevents people from accessing dental care when they need it is fit for purpose in Aotearoa?
What I think is that if we improve the economy, we'll then have the ability to provide a wider range of health services.
Question number 12, Joseph Mooney.
Thank you, Mr. Speaker. My question is to the Minister for Building and Construction. What recent announcements has the government made about building and construction?
The Honourable Chris Pink.
Thank you, sir. Among other things, we've recently announced the basis of a self-certification regime. The context is that we're also looking to crack down on incompetent, careless and unethical builders. But we know, sir, that in order to reform the building construction sector to support more affordable homes and a stronger economy, we know that at the same time we need to provide more streamlined processes for those who are worthy of that trust.
Supplementary. Why does the current system need reform?
Mr. Speaker, it currently takes on average 569 days for a home to be built and consented. Amid a housing shortage that has persisted for some time, that is simply too long to wait. Currently, a single-storey home of standard dimensions might feature some 10 to 15 separate inspections. The resources of the building control system would be better spent mitigating more significant risk elsewhere.
Supplementary. Who will be eligible to self-certify their own building work?
Mr. Speaker, the scheme will undergo a robust consultation process, but there are two key pillars that will feature. The first is at the individual tradesperson level. such that plumbers and drain layers will be able to self-certify their own work in the same way that electricians and gas fitters already currently can. The industry has been calling for this for years. And the second pillar is that businesses with a proven track record, which I admit, sir, we do need to define carefully. For example, home builders who build hundreds of similar homes every year will be able to enjoy a more streamlined consent process.
Supplementary. What feedback has he received on these proposals?
Mr. Speaker, the feedback from the sector has largely been very positive. I do actually also want to acknowledge a constructive approach across the political aisle. We've enjoyed cautious support in principle, and I do want to acknowledge that, and also a willingness to engage on the details, so we will be doing that. So within the sector, Greg Wallace of Master Plumbers has been advocating for self-certification for his members for 4 years, and Kit Sharma of Master Builders, the CEO, points out that this will enable his organisation's members to build more affordably and efficiently. And Aidan Jerry from Jenny and Homes highlights the time factor as being critical to build, including as to cost. So we're determined to make these changes for the benefit of all Kiwi consumers.
Great, Minister.
That's, well, one more.
Supplementary.
Oh, sorry. You might have guessed I'm in a hurry to leave.
Thank you, Mr. Speaker.
Arena Williams.
How many tens of thousands of builders need to lose their jobs before he announces that the building sector is in crisis, given today's confirmation that 12,000 jobs are gone under his watch, but according to him, things are fine?
Mr. Speaker, I've never pretended that the situation we inherited from that side of the House when they were in government was anything like fine. We did inherit a crisis. We are moving quickly to address that in a way that will reflect great safety, affordability and sustainability of our housing.
That does conclude oral questions. We'll take about 30 seconds for those who have to leave the House to do so quietly without conversations on the way.
Thank you. That's cool. Okay, I think that's given everyone time enough to move past. Would some honourable member care to move that the House take note of miscellaneous business?
I so move, Madam Speaker.
Right Honourable Chris Hipkins.
Madam Speaker, every day New Zealanders see more and more examples of this government taking New Zealand backwards. Whether it's our health system descending further into chaos, today's news that unemployment is continuing to increase, race relations deteriorating to the worst point it has been in over 40 years, record numbers of New Zealanders leaving the country. New Zealanders need no further proof that we have a government with no vision and no hope for the future of this country. This is a government constantly making bad choices and bad decisions that is leading New Zealand backwards. When everyday working Kiwis look at this government, they do not see a government that reflects their hopes and aspirations. They see a government content to run down our health system, to cut investment in public service, to put tens of thousands of New Zealanders out of work during a very tough part of the economic cycle so that they can, among other things, fund $2.9 billion worth of tax cuts for landlords, give over $200 million in tax cuts to Philip Morris, the country's largest supplier of cigarettes, and they're doing that to fund what, Madam Speaker? They're funding $1.5 billion worth of cuts to state house spending. That includes building and maintenance. They've cut things like the upgrade of the Inter-Islander. Watch this space, though, for Nicola Willis to come back to the House and say she got it wrong and maybe actually the ferry deal that she said was so bad wasn't such a bad deal after all. They cut spending on school and hospital upgrades up and down the country. They cut free prescriptions. They were helping to keep people healthy and keep them out of emergency departments. They increased costs to our younger New Zealanders who use public transport every day. And I think some of the worst things they did were the cuts to the disability sector. I think picking on some of our most vulnerable Kiwis at a time of an economic crisis was particularly mean-spirited, and the way they defamed and degraded the carers of those people with disabilities was particularly reprehensible. Then we've seen cuts to the support services that our most vulnerable families rely on, funded by Oranga Tamariki. Many of those providers working some of it with our most vulnerable families didn't find out they were having their funding cut until after the funding had already stopped. I think that's a terrible way for the government to operate, and it shows absolute contempt for some of our most vulnerable children. They've cut almost all positive action on climate change. At a time when New Zealanders need no further convincing that climate change is here and it's real, this government have wound back the clock and are burying their heads in the sand once again. And then when it comes to the cost of living, the only thing they can point to is a fall in inflation and a fall in interest rates, which is almost exclusively because of the actions of the Reserve Bank and nothing to do with this government. But they've taken what could have been a soft economic landing for the economy and turned it into a crash landing and left some of the most vulnerable New Zealanders absolutely exposed to the sharpest edges of the recession. Madam Speaker, it gets worse than that, because if you look at the areas of pain for households, increasing rates, the government have made it worse. Increasing insurance, they have done nothing. Increasing rents, they have made that problem worse. The electricity market failure, despite all of the hot air from people like Shane Jones, absolutely no action has been taken on the fact that we have seen electricity prices skyrocketing. And as for the hollow rhetoric about the situation they inherited, let's remember this government has borrowed more money in this year's budget than in any of the budgets that we delivered, except for one, which was in 2020 when we were at the height of the global pandemic. Despite their tough on crime rhetoric, we haven't seen any real solutions there. All we've seen is the promise of weaker firearms regulations, making it easier for gang members to get access to guns. This is a government making it harder for New Zealanders. They are making it harder for New Zealanders who go out and work every day for a living. Madam Speaker, it is a government that is taking New Zealand backwards.
Scott Willis.
Thank you, Madam Speaker. And when the Prime Minister visited Dunedin a fortnight ago, he clearly didn't want to front up to residents. The Prime Minister was spotted sneaking in through the back door of the Dunedin Public Art Gallery to avoid Dunedin people. Today, there's no back door for the PM to duck out of, and it's time to front up for some real answers on the issues that matter to our people here in the House. And I want to tautoko our southern leaders here who have turned up today because they have travelled up with Cliff the ambulance to be heard by this government. We hear you. This government seems to want to close their ears. But we say to this government, don't park an ambulance named Cliff at the bottom of one. Fulfil your promises to our people and stop letting people fall. And don't patronise us with the false ideas of overblown costs and bluster. If you don't invest in people's health, the evidence shows us that the costs we will pay are multiple times that. And what will it take for this government to do the basics of putting the health of people first? This demolition government is well known for its shiftiness. Perhaps the PM thought that protesters and their message didn't fit with the narrative he was trying to sell when he snuck into Ōtepoti. But here's the thing. We in the South aren't interested in another empty sales pitch from a government that fails to deliver. The very least the people of the South deserve is to be told straight, we don't like weasel words. If this government is prioritising tax cuts for landlords, tax cuts for the big tobacco over the health of people in the South, at least have the guts to tell us straight. Today, Cliff, the ambulance, arrived at Parliament and a petition delivered. Cliff has been travelling the length of the South Island with massive support throughout the South. So is the Prime Minister going to have the courage to face up to our Deep South community here today about his broken promise? When will this government acknowledge the critical infrastructure deficit that they are creating, from refusing to fund hospitals in the regions to canning the Inter-Islander ferry replacement? It doesn't stop. We know this government is wasting even more money by its mismanagement. 110,000 each and every day it refuses to take action on our southern hospital. The government has also announced 2 new tunnels for Wellington to make traffic and pollution worse. So how many more minutes will those new tunnels, costing somewhere between 3 or more billion, save us? About 10 minutes, we're told. And how many lives will be lost if the Dunedin Hospital is reduced to a state where patients are left waiting in corridors, sterilisation of surgical equipment continues to be compromised, and floor space is cut back to a point where patients aren't able to be moved between wards and theatres? How many lives lost if the facilities are not funded to deliver all the publicised cancer drugs, and the accident victims, the stroke and heart attack victims, are waiting in ambulances outside an inefficient and overcrowded hospital? Madam Speaker, the piles are in the ground. They are waiting for an inpatient building, and yet this government dithers and claims now that the delivery of the hospital is too costly. What is costly is every delay. Cutting 1 floor off the inpatient building will also mean cutting the psychogeriatric beds. And as Grey Power Otago President Joe Miller said, this is a hospital that services the whole of the southern region. And as Aged Care Association Chief Executive Tracy Martin said, it's the stupidest idea she's heard. The government is happy to blow money on breaking a ferry contract, something like $500 million, with nothing in return, and there may be further costs. Now it's refusing to get the Southern Hospital built. We won't be played off against each other. We want to see the hospital built now. We want to see other health institutions being supported. We don't see ourselves competing.
Members' time has expired. Honourable Simon Watts.
Well, thank you very much, Madam Speaker. It has been 12 months since this government has been first elected, and we have been very busy delivering on the core things that will make life better for New Zealanders: rebuilding our economy, restoring law and order, and delivering better public services. As the Minister of Climate Change, I am responsible for delivering on our climate budgets and targets on behalf of the government. But recently, Madam Speaker, I have become very concerned about the climate impacts of the amount of hot air coming from the other side of the House. Madam Speaker, I am proud to work with the Minister of Finance, Nicola Willis, and I am pleased to be working alongside her to ensure that we get more money into the back pockets of hard-working Kiwi families. We know high housing costs, we know high food costs, childcare costs are making it tough for families out there across New Zealand. And that is why we as a government are easing the cost of living impact for those families, which was a pre-election commitment. To date, Madam Speaker, over 30,000 households have received their first payment under the Family Boost Childcare Payment Scheme, with Inland Revenue estimating that from the 1st of October 2024 to the 1st of October 2025, 100,000 families will be eligible. Recently, the opposition spokesperson for finance, Barbara Edmonds, appears to have done a complete 180 on Family Boost. She's now saying there aren't enough families getting it. Of course, this completely contrasts, Madam Speaker, to her vote on Family Boost, which legislated when she voted for 0 families in this country to receive it. I would like to express my gratitude and thanks to Barbara Edmonds and the Labour Party for bringing more air to Family Boost. Your efforts mean that more families can hear about the great things that this government is doing to support them getting more money into their back pockets and to support them with childcare costs. And of course, to those people at home watching this who may have tuned in maybe to this instead of the US election, well, go to the IRD website and see if you are eligible to make a claim. Moving on to energy, Madam Speaker, this year our country has seen heightened risks in regards to energy security because of the reckless decisions made by that last government. Electrifying New Zealand, the economy, is a key part of our plan to improve energy security, grow our economy, and to ensure we reduce emissions to meet our climate change targets. Our goal, Madam Speaker, is to double New Zealand's renewable energy by 2050, as we want to see more clean energy that is abundant and affordable, so households can heat their homes with energy coming from renewable sources. People can charge their electric vehicles across New Zealand, and businesses have the confidence, Madam Speaker, to ensure that energy security will allow them to grow their operations. And recently we've listed 22 energy projects with a combined capacity of 3 gigawatts to be fast-tracked under legislation. This will help, Madam Speaker, to ensure clean, reliable energy that is affordable to supply New Zealanders, and that will increase generation capacity by nearly 30%. I spoke earlier about the hot air coming from the other side, and there is plenty coming from the members at the moment, as you can hear, about their opposition to fast track. My advice to those members who oppose that legislation is, if you really want more renewable energy, you want it to be abundant and affordable, well, you need to get behind this bill and vote it and put your money where your mouth is. In all seriousness, New Zealanders are struggling at the moment. They know it's tough. They're dealing with the hangover from hell from the last government. The good news is this government is getting this country back on track. We're rebuilding our economy, restoring law and order, and delivering better public services. Madam Speaker, it is an absolute pleasure to be part of a government who truly understands what New Zealanders want and need and knows how to deliver them.
Laura Trask, I'm just going to remind people that interjections are fine, but the House has been getting quite loud, although I must say when a speaker is speaking at the top of their voice, it is much more necessary to be loud over the top of them. Thank you. Laura Trask.
Thank you, Madam Speaker, and I also want to thank the previous member for that great hype boy energy for my speech. So this week marks the start of the NCA exams across the country. And first off, I want to say a huge congratulations to all the students for reaching this point. It's no small feat to get here, especially with exams as challenging as NCA. All your hard work, late nights and perseverance are about to pay off, and we're all backing you. I remember sitting my exams, was called School Certificate 25 odd years ago. I don't want to show my age. And I think it went on to sixth form certificate and, correct me if I'm wrong, but seventh form, which I think was bursary, which is now year 13. I actually enjoyed exam time. I enjoyed cramming everything in. We used to stay up late on Diet Coke because we didn't have the same amount of energy drinks that we have nowadays. But I knew that summer was just around the corner. Like, I could smell that beach vibe. Anyone from Canterbury will know that we're heading off to the Kaiterere beach, most of us, to spend that time with our friends. So know that you're at the end of the line, you're about to have summer, you can go off, you can enjoy that break with your relatives, with your friends, and not worry about your results till at least January. But back to the present. Let's talk about NCA itself.
it's fair to say that while the system aims to assess a range of skills and knowledge, it isn't perfect. Ideally, NCA should empower students to chart their own paths, but many find it more challenging than supportive. I regularly hear from teachers struggling to adapt to curriculum changes, especially those introduced in 2020 without the support that they felt they needed. One area that stands out is digital technology NCA Level 1. I want to share an email I received from a teacher regarding this new curriculum. The teacher, a Christian, expressed concern about being required to incorporate Māori spirituality into computer science topic focused on usability heuristics. Usability heuristics. Don't even know what that is. Hope someone else knows what this is. While they appreciate New Zealand culture, they felt it was inappropriate to assert Māori principles into the specific subject area, especially as it crosses secular professional line for them. Originally, teachers could choose to teach either computer interaction or they could teach Matapona Māori, the Māori principles. But after receiving feedback, it was decided without further consultation by the ministry that both would now be mandatory. And we're hearing that teachers are struggling to deliver this. So I ask, how does this curriculum equip our students for professional careers? How does it serve them if even the teachers feel unheard? We've also seen a steady drop in NCA achievements over the past 6 years. For instance, Level 1 pass rates have declined from 75% in 2017 to just 61.7% in 2023. This brings up critical questions. Does NCA allow students to show their strengths? Does it provide the skills for further studies or jobs and trades? But there is some good news. This government is focused on improving achievement. The Honourable Erica Stanford has announced the Make It Count for high school kids and also an intensive catch-up program for years 7 and 8 in mathematics, preparing them for access in high school. I'm actually really excited for this because I have a child going into year 7 next year, and so this is really important. As a parent, we want to make sure that our kids do well and they're ready and prepared for year 9. Quite a few year 9 teachers are telling us that the kids are just not ready and prepared, especially with numeracy skills. We know that low attendance is a significant issue, and I'm proud of Honourable David Seymour and this government for tackling to get kids back into the classroom. But we also need an education system that motivates students to want to show up, that engages them, and that offers them a reason to stay. Unfortunately, some students fall through the cracks, especially those from lower socioeconomic backgrounds, where the challenges feel more like canyons. That's just not acceptable. That's why the ACT Party is advocating for a more flexible education system that opens doors for everyone. We believe success shouldn't hinge on a one-size-fits-all model. And whilst fixing our state school is essential, we also have charter schools available. Now, I know charter schools have been misrepresented, so let's just clarify. Charter schools are publicly funded like traditional schools, but they have the flexibility to innovate and meet students' unique needs. They can focus on practical skills, smaller classes, tailored teachers and learners, and I'm really excited for those students who feel unseen, unsupported in the current system. So, as you go off today, as you go off this week into your exams, remember these exams don't define you. They don't measure your full potential or everything you've learned. They're just one step on your journey, and regardless of the outcome, they are pathways for you to achieve amazing things.
Madam Speaker.
Honourable Melissa Lee.
Madam Speaker, New Zealand's SMEs are often called the backbone of our economy. And yesterday, they would have felt this government heard their voices. That's right. Yesterday, we announced some new rules for government agencies. And when I say government agency rules have actually changed, and why would businesses celebrate? That is because these changes will make them pay their suppliers, meaning the businesses, faster, improving cash flow for businesses. Right. And cash flow is the lifeblood. It's the lifeline for many, many companies who have been struggling under the previous government. Having invoices paid on time can make a huge difference. It could make a difference between them continuing with their business or folding, and cash flow is king. Government agencies should lead by example. That is why I've changed the government procurement rules to put these requirements in place. And from 1 January next year, 2025, 135 central government agencies must pay 90% of invoices within 10 business days. This increases to 95% from their start in 2026. But wait for it. From January 1, 2026, agencies that send or receive more than 2,000 invoices, e-invoicing, these agencies will need to pay e-invoices within 5 working days, and that will make a humongous differences to businesses. Government procurement is worth $51.5 billion, not million, $1 billion every year, and that is nearly the fifth of New Zealand's GDP, Madam Speaker. I want government procurement to play a big part in growing our economy, making sure that we deliver for New Zealanders who have been asking to get New Zealand back on track. That's right, getting New Zealand back on track. Right now, I'm reviewing the government procurement rules so it can do just that, getting New Zealand back on track. And you can watch this space for more announcements soon, Madam Speaker. I'd like to now talk about the, ethnic communities portfolio, because as I'm very passionate about the ethnic communities, obviously, but because I also have the portfolio of economic development portfolio, I am looking at the synergies that these two portfolios can actually produce. And a couple of weeks ago, I hosted an ethnic exchange symposium, which was actually completely sold out. More than 300 businesses got together to discuss how they can contribute better. And the reason why I actually mentioned that is that in 2021, the ethnic communities contributed $64 billion to New Zealand's economy. And our population, our ethnic communities' population is growing. They are numbering bigger, and in Auckland, 1 in 3 Aucklanders come from Asia. And it is a huge diversity that we actually have. And I'd like to thank my ministerial colleagues, Nicola Willis, David Seymour, and Judith Collins, who actually participated in the forum at the Ethnic Exchange Symposium. And I also like to thank the Trade Minister, Honourable Todd McClay, given global trade was one of the key themes that was actually discussed at the Ethnic Exchange Symposium. And he's been, as my colleague says, he's been travelling around the world. He's been, globe-trotting, signing trade agreements left, right, and centre. That's right. And I am particularly proud of what he actually did and actually secure for the Gulf region, and securing a high-quality trade deal for our exporters to make sure that they can contribute to New Zealand's economy as well. And Diwali has been celebrated up and down the country. We held a Diwali celebration on Monday in Parliament, and yesterday I was actually in central Wellington celebrating another Diwali event. And I just want to say thanks to all of my colleagues right across the House who have attended Diwali celebration. Isn't it fantastic that most of us, in fact, own saris and salwar kameez and actually know how to say Shubh Diwali as well. And the fact that our ethnic cultures and celebrations are becoming part and parcel of New Zealand's everyday life, and we actually celebrate and honour our ethnic community celebrations, whether it's actually New Year or a religious event, that we actually honour them and celebrate, and they contribute hugely to New Zealand. And on that occasion, I'd like to say Shubh Diwali to all our Indian community.
Honourable Willow Jean Prime.
Thank you, Madam Speaker. Madam Speaker, I am back here in the House once again in the general debate to speak to some very concerning developments in the children's portfolio. This government has got its priorities wrong. It is taking us backwards. They are treating our most vulnerable children and families wrong. Madam Speaker, yesterday we learnt that the government has made decisions to introduce the use of force through third-party providers in their boot camps. Now, Madam Speaker, this is a concern for a number of reasons. The only reason the government has made this decision and is considering extending something which is only currently available to enforcement officers who are properly trained is because they are hell-bent on introducing and continuing to run their military-style academy boot camps. If those experiments did not exist, this decision, this dangerous decision, would not have to have been made. But they have decided that the boot camp is their answer to youth justice issues, and in order to be able to deliver their boot camp, they are extending the powers to use force on children to third-party providers who could be running their boot camp. Now, it is dangerous and it is concerning that the Prime Minister did not recall having any conversation about this matter, yet it was a cabinet decision approved in June, and he chairs cabinet. And then we have a Minister for Children absolutely defending this decision and the giving of this power to third parties, even though the advice from her officials is very clear that there is a risk that abuse could occur, that harm could be done to young people. Now, the Prime Minister yesterday said how important having safeguards would be. Well, if the Prime Minister had read the Cabinet paper and paid attention in the conversation and discussion they were having in Cabinet, the Prime Minister would know that the Minister for Children noted that there were frames that they would not be able to complete those in time for the introduction of the bill, and that it would be relegated to power to third parties, even though the advice from her officials is very clear that there is a risk that abuse could occur, that harm could be done to young people. Now, the Prime Minister yesterday said how important having safeguards would be. Well, if the Prime Minister had read the Cabinet paper and paid attention in the conversation and discussion they were having in Cabinet, the Prime Minister would know that the Minister for Children noted that there would be no safeguards in primary legislation, and that because of the timeframes that they would not be able to complete those in time for the introduction of the bill, and that it would be relegated to regulations to be worked out after the introduction of this bill to the House. Now, Madam Speaker, this is deeply concerning because we have a report from the Royal Commission of Inquiry into the Abuse in State Care that finds very clearly that abuse was able to happen in boot camps and other care and protection facilities because of the lack of safeguards. So how can this government make a decision at Cabinet to extend the use of force to third parties without any safeguards? No safeguards in place, no safeguards in the primary legislation to be worked out through a regulation process after the fact. And I will note that the regulatory impact statement says there have been constrained timeframes. So this is being rushed for political expediency, not what is in the best interests of children and young people. And it concerns me, Madam Speaker, that the Minister for Children did not consult the Chief Children's Commissioner, the main advocate for our young people, did not even bother to consult, even when the Children's Commissioner has made it very clear on any policy to do with youth justice, she would like to be consulted. So the Minister for Children absolutely ignoring the chief advocate for our children. Madam Speaker, I am deeply concerned this government has got its priorities wrong and is taking us backwards.
Speaker.
Timothy Paul.
Kia ora, Madam Speaker. Thank you for the opportunity to speak. And following my colleague Willow Jean Prime, I'm glad we're on the topic of boot camps because this has been a major focus of attention this week because of the document that I received from somebody who was so deeply concerned about what these boot camps are going to look like when they're set up. And that's what I want to talk about today. I want to talk about some of the lines that the Minister of Children has talked about this week, justifying why the boot camp experiment that she's trialling right now is any different to the boot camps of the past. So the Minister of Children was asked about this at question time yesterday, and this was her response. She said, quote, "The boot camps of the past I was referring to were around decades ago with untrained staff, no proper oversight, and in an isolated setting of appalling conditions." Now that might be true, but if you look at this document and the Cabinet minute around these boot camps being set up, you can see how the conditions that the Minister of Children talked about yesterday are very close to being met. So let's start with the first one, untrained staff. This government is setting up a structure whereby third-party providers, whoever that is, that could literally be anybody, you could start a business or a company and be a third-party provider, are going to provide these boot camps. How are we supposed to know what level of training they're going to get? Well, we don't know that at all. So there, number one, untrained staff, check. Next one, no proper oversight. There has been no safeguarding of the rights of children in this legislation. First, the government has decided that they will allow for the use of force without even an afterthought around those safeguards. And the Prime Minister got on TV and talked about the safeguarding and children's rights safeguarding is so important. Yet I would ask him to name one single safeguard in that legislation. And that's because it wasn't there, because there are no safeguarding, because they chose force first and then those safeguards are an afterthought. This was the exact thing that was highlighted in the Royal Commission inquiry into abuse and state care report, where it said that the conditions of abuse were created when there wasn't sufficient oversight and safeguards for those children. So there we go. Second box, checked. Third thing that the Minister talked about is an isolated setting. And that the boot camps of the past, you know, the major example is the Te Whakapākari one that was on Great Barrier Island, which was an isolated setting. But the kids that are in that boot camp right now are also in an isolated setting because they're not from Palmerston North, they're from South Auckland. A majority of them are from South Auckland, so they have been moved out of their communities and taken to the other side of the country where they're expected to undergo this military boot camp. So the three conditions that the Minister uses to justify why her boot camps are any different from the ones of the past have all failed. So what does that tell us? That the boot camps that are happening right now are no different to the ones that happened in the past. And what happened in the boot camps of the past? Well, at best, they failed. So the boot camps that the John Key National Government started were a failure because a significant majority of those young people went on to reoffend later in life. So at best, they were a complete failure, but at worst, you look at the 1970s boot camps that were on Great Barrier Island where children endured horrendous abuse at the hands of people who were supposed to be protecting them. So I don't want to hear this nonsense that the boot camps now are any different to the boot camps of the past, because the public can see it for what it is, and that's what caused the flurry yesterday, is that every little straw that the minister tries to grasp at to say that these are different are slowly slipping away. And so that is why we are calling this government to end their boot camp experiment. Put an end to it, because what we can clearly see is that the environments of abuse are being set up. The potential risks for abuse of children are being set up and are right in front of us. So that's why yesterday we launched our petition calling on the government to end their boot camp experiment. And I invite anybody who shares this concern to sign our petition and join the voice of the people to tell this government, stop experimenting with our tamariki, put their rights and their protection and their safety first. Kia ora.
Katie Newman.
What's the most important thing for our future?
Getting us back on track.
Well, that's absolutely, Tim Costley. Education. Thank you very much. I have 62 schools in my electorate. And I always take the opportunity to say that the Napier electorate is not just Napier City, goes all the way up to Gisborne. Some of the fine young children in schools like Matawai School in Wairingakuri, Wairoa schools, we've got multiple of them. And those children all deserve a bright future. It does not matter where you go to school, it is what you are learning, it's the opportunities you have. And so that is why I am so proud of what our government is doing to streamline what kids are learning, to give them equal opportunity no matter where they go to school. And so the structured literacy and the structured numeracy approach that we are providing is something that is going to level the playing field, and boy, I am excited. Now, I get out and about and I go and visit a lot of schools, and some of the schools that I've visited recently have told me that they've actually already been using structured literacy, they've already been using structured numeracy. Not only are they looking forward to the different providers that they can utilise, and they're excited by that opportunity, they're also really excited to see other schools get on board because they have seen results. Some of them doing this for 3 years and seeing such remarkable growth in every single student. My niece is one of them. Reading at 3 years above the age that she is, which is incredible. And so I just want to say that it's not just what we are doing now, it is how we are going to make sure that every single school gets this. And I think it's really important to draw the public's attention to this. While we had structured literacy and structured numeracy available to teach in schools, it was not mandated, it was not funded, and schools had to fund it out of their own operating budget. Schools had to make that decision as to whether they could afford that or do all the rest of the stuff that they needed to do, and not every school has that same opportunity. Now, just last week I went up to 2 country schools, Koutou Māori School, who is a fine school that has just had their 2 classrooms rebuilt by this government after mould and dampness and holes in the ceiling that have prevented these kids from being able to go to school. They actually had to move to Putarino School, which I also went to visit, and both schools are thriving now that they're back in their place, because of course their sense of place is really important to them. Those 2 communities are not the same. But both of these schools are very excited. One has already been doing structured numeracy for a while, and one is about to start, and they are learning from each other. And they are doing such great things. Now, one of these schools, there's 14 kids there, and what I was so inspired by is the aspiration of these children. Now, this is a very interesting school demographic-wise. 50-50 split, Fijian and Māori. And that is because of the country makeup of some farmers, some forestry, and the children and whānau that live there. Now, out of these 14 kids, we had a future doctor, a future vet, a future police officer, 2 rugby players, we had a professional netballer, we had one kid that wanted to be a politician, actually, Cameron Brewer. And these children believed that the sky was the limit for them and nothing was going to hold them back because of the government and the education system and the minister believing in them. And the feedback I have got from the principals and the teachers at these schools is that they are so happy with the direction the government is going in, the scaffolding that is being provided for them to be able to deliver what it is that they are there to do. And so I just want to say, country and urban schools, no matter where you are, the opportunities are the same. Single cell or open plan. An example between Onikawa School and between Port Ahuriri School. 2 different schools, very different styles, equal opportunity. And in fact, actually, the changes that were made by the last government to make Port Ahuriri an open plan school, the school is working to try and bring some flexibility back into the way that they divide their classrooms up because they want to own that. So look, I'm really excited about how they're taking the lead. And one thing that I thought was really brilliant, some feedback that I got from these schools, was that those that are already out there using structured literacy, and not necessarily all of the same programs that we're providing, because there are 4, and let me tell you, Maths No Problem, Prime, Numicon and the Oxford University Press, great options for different ways of providing that information for children. These schools are supporting each other. And that is what is so fantastic to see. Those that have been out there and trialled different types, whether it's Prime, whether it's Numicon, they're able to provide that context to each other and say these ones are fantastic, or this is really good if you've got children with this learning style, or if you've already been learning this or teaching this way, this one's going to be very good for you. So to principals and schools out in New Zealand at the moment, if you haven't made your order for your structured numeracy workbooks, now is the time. And if you want to get out there and ask your comrades, your counterparts, your friends, what they're doing, please do that now. Thank you.
Honourable Dr Duncan Webb.
Kia ora. Thank you, Madam Chair. And I want to talk about something that's, actually quite sad. And it's the Treaty Principles Bill. And I want to speak particularly to the National Party, who actually have a long and honourable tradition in upholding the principles of the treaty and making really good progress. And I think back to the work that Jim Bolger and Doug Graham did, and I think to the work that Christopher Finlayson did, and I think how sad it must be for them to see the National Party undermining decades and in fact hundreds of years of work in mending treaty breaches. The Treaty of Waitangi is our founding constitutional document. And the National Party is standing by while one of its coalition partners brings a wrecking ball to that relationship, sends it back 100 years or more. And as we see the bill introduced tomorrow snuck in while many will be distracted by international events, snuck in so that the hikoi so carefully planned won't be there when it's introduced. It undermines our very democratic process. And I've heard David Seymour criticising again the Waitangi Tribunal, which is doing a fantastic job. Because what they say hits home, it's accurate, and I can imagine it's hard to hear. Because they've said, for example, just yesterday, the Crown, in bringing this bill to this House, has breached the principle of good government in its pursuit of a policy that's not evidence-based, has not been adequately tested, has not been consulted upon, and fails regulatory standards. That's not even talking about the harm, the violence that it's doing to our Constitution. The Waitangi Tribunal went on to say this bill proposes to destroy all of the promises and guarantees that the Crown gave to Māori in 1840, or suspend them for the lifetime of this bill if enacted. It's not surprising, they said, that Māori people are angry, and I'm angry too, because I'm a partner to that contract, and that party is standing by whilst its principles are utterly undermined. The suggestion that it's some kind of trivial contract that can be revisited at a whim is wrong. It's a partnership. It was a solemn partnership, a sacred partnership that 2 people entered into. And one of those people, the Crown, promised to protect and promote the rights of Māori, and they didn't. And what we need to do now is to honour that promise and to recognise that since 1840 we have worked on what that relationship is and what that treaty means. And out of that has come some scholarship, some thinking, some philosophy and some principles. And one of those is the duty to protect. And this government is doing the opposite. It is actively harming, not only with this bill, but we've heard about boot camps. We've heard about oranga tamariki and much, much more. The environment, the Resource Management Act being gutted, not consulting iwi partners on what we do with our environment, and to suggest that the treaty is frozen in time, that it's not a living document that develops, that we can build upon, that like any document of treaty between two people evolves with that relationship, is an absolute flaw. And probably the real flaw is that in some way the treaty means unequal treatment. There has been unequal treatment for 180 years, and what we need is to address that. And in addressing that, we need to recognise the rights of Māori, both at customary law, which is being gutted by the Coastal and Marine and Coastal Areas Act, both at customary law, but also under the treaty. And my National Party colleagues, you don't even believe the bill that you're putting before the House. Your Prime Minister has said that. And why can't you stand up, make a choice for New Zealand that isn't harmful to our relationships, that takes us forwards, not backwards. Do what's right, do what's good.
Carlos Chung. Madam Speaker, this government is working hard to get New Zealand economy back on track. Families across New Zealand are benefiting from tax relief, falling interest rate, childcare tax rebate thanks to our family boost policy. I would also like to recognise the significant effort our trade team, led by Minister Honourable Todd McClay, have been delivering for New Zealanders internationally. This means more demand for the best of our export, including high-quality beef and lamb, dairy product, kiwi food, apple, etc. Where 1 in 4 Kiwi jobs are tied to trade. Signing international trade agreement, including with the EU, UAE, and the Six Nations GCC, will mean more opportunities and more money in the back pockets of hard-working New Zealanders. But we believe that there is more to do. Yesterday was a great day for all the New Zealanders, especially all the musicians and music lovers.
Oh, tell us why.
Yesterday, I'm thrilled to launch my members bill to guarantee major stadium, those actually capable of holding at least 25,000 fans, including Eden Park, the ability to hold at least 15 concerts per year. To my colleagues across the House, I will use this opportunity to ask for your support to this bill. Hosting more concerts will make a massive contribution to our economic growth by increasing consumer spending. It also makes a massive difference to other key industries, including tourism and hospitality. This creates more job opportunities and drive us closer to get our country back on track. Let me give you some example. Pink recent concert in Dunedin alone, 37,000 friends generate $16 million in Dunedin economies. And pay smash like hit, get just like a pew, raise your glass, try. And you know, one of my favorite during my uni time, get the party started. But unfortunately, not every single time we have our love story in a good ending. Early this year, New Zealand missed out on Taylor Swift, who I've been told by my staff, who also go by the name Tay. For one reason, the resource consent for Eden Park only limited 6 concerts per year. By no means what? Missing out on Tay was a lay for our economies. And the estimated $70 million of economic activities we lost. It is time for us to shake it off, the red tape. Besides the economic benefits, local musicians and bands benefit directly from live performance. They gain exposure and experience, build their fan base, and earn income. Last week, we have some major event in Eden Park, and I have checked to a few Uber drivers. They are telling me that whenever there is a concert in Eden Park, their business are doing well. They got more rides. That has made a huge difference for some of our hard-working people in Auckland and in New Zealanders. I want to spend some time to acknowledge all the Uber drivers, many of whom call New Zealand homes. My bills will mean more international artists coming both to New Zealand, but also to the stadium near you and your electorate. In Auckland, this means Eden Park and Mansmark. In Wellington, it means Sky Stadium. In Christchurch, it means One New Zealand Stadium. And in Dunedin, it means Flossing Bra Stadium. So this is why I'm asking the support of this House to fast-track more artists to the major stadium near you, because it brings economic benefit to your own electorate. Because nothing say we are back on track, like Taylor Swift dropping some tracks. Madam Speaker, the people of New Zealand deserve more. We deserve more international artists playing in New Zealand. We deserve the economic revenues. And most of all, we deserve the memories. The memories is priceless. I'm looking forward to bring my daughter to have more concert and share more moments with her. Thank you.
Raui Waititi.
What I just heard was the title of an album, Blank Space, by Taylor Swift herself. And that's all I heard was blank space. Well, Madam Speaker. Well. We have a government that is fearful. We have a government that is afraid as our people activate and consolidate and unite. And as we prepare for the biggest hikoi that this country will ever see, bigger than any other hikoi in history, this is what this government is fearful. They are fearful of that. And I want to go back to a national MP, and a Māori MP at that, Sir Apira Nangata. He talked about the price of citizenship. He talked about the price of citizenship, and that our participation, Māori participation in the Great Wars, will earn the respect of Pākehā. I want to take an interview by the last surviving member of the Māori Battalion, Sir Bob Gillies. And he said, had I known as much as I know now, I would have stayed home. Moana Maniapoto, the interviewer, said, is that because of what you went through over there? Tā Bob Gillies said, no. Not only that, it's the way they keep treating us. We lost those fellas for nothing. We're no better off. We are still fighting for a place in our country, and this is the situation we have right now with the Treaty Principles Bill. E te iwi, we have marched for our reo. We have marched for our whenua. We have marched for our moana. And now you have made us march for our very existence. How long do our people have to march for? How many more marches will it take? How many more tangata whenua, tangata tiriti, tangata moana need to rise up to make sure we have the Aotearoa our mokopuna deserve to inherit? Because I'm telling you now, we are rising like a good rewana bread. And I know the heat is too much for you, but the more heat you put on a rewana bread, the more it rises. Because for every 100-day plan this government makes, they forget we are people with hundreds of years of resistance, and we will rise. Because if history has taught this government anything, is that colonisation has never broken us, and we have never backed down from a fight. To our people, this Toitū Te Tiriti movement is tipuna inspired, Tiriti led, mana motu hake driven, and mokopuna focused. We are a movement that does not bend the knee to any colonial sovereign. Never have, never will. Our kaupapa is bigger than us. Ka haere tonu te mahi, ka haere tonu te hikoi mo te tiriti. We need you. We need all of you to hikoi. This isn't just our fight. This fight belongs to all of us. It is a fight for Aotearoa. Our mokopuna deserve to inherit all of our mokopuna. Our memoir to our tamariki mokopuna. We will continue to fight. Te tiriti o Waitangi was signed by our tipuna. Te tiriti holds our rights as tangata whenua. It's nobody else's right to debate. Our tipuna marched long before us. We are fighting for you to one day not have a fight for your existence on your whenua that you walk on. You are good enough because our tipuna made it so. Ignorance is the oppressor. Vigilance is the liberator. Know the scent of your enemy. Know the scent of your vision so that you may achieve liberation. Ka whawhai tonu mātou. Ake, ake, ake. Ka whawhai tonu mātou. Ake, ake, ake. We don't have the luxury of fighting on one front. We have to fight on all fronts. And this hikoi wasn't built on one catalyst event like the Treaty Principles Bill. It is a whole lot of events and violent offences that this government continues to inflict onto iwi Māori, and we will not stand for it. E te iwi, we will continue to prepare ourselves. Then this House needs to prepare itself as our people organise, as our people unite, as our people prepare to march on these streets of Wellington and to the doorstep of the very House that continues to inflict violence. If this is the price of citizenship, you should hang your heads in shame. Toitu te tiriti.
Honourable Rachel Brooking.
Thank you. Now, talking of hikoi and marches and a 35,000 person one in Dunedin, build it once, build it right, build it now. Now that, Madam Speaker, is what the people of Dunedin have been saying over and over and over again. And the it I'm referring to is, of course, the Dunedin Hospital, the tertiary hospital for the regions of Otago and Southland. Now, I want to acknowledge that there are a lot of members of different councils, there's been mayors who made a petition to Parliament today, and we were outside saying, build it once, build it right, build it now. And the Nurses Union presented me with a petition of 34,000 signatures, Madam Speaker. And the person who's organised this petition is Linda Smiley, and she's a strong advocate for the building of this new hospital in Dunedin. And there's 4 components to that I want to talk about, this it and the build it once, build it right, build it now. And that's that it's an inpatient building, that it's a tertiary hospital, that it's a teaching hospital, and that there's a number of beds and theatres that were promised by National during the election campaign. So I'm going to step through those issues, Madam Speaker. And before I do, as I've noted, we had mayors and councillors out the front today on the steps of Parliament, and those mayors were from a range of councils. We had Dunedin, Invercargill and Waitaki, and we had many councillors from the Dunedin City Council. And Madam Speaker, during the election campaign there was a lot of talk of localism and the importance of councils and the local voice. And this is a great demonstration of local voice in action, Madam Speaker, because many of those councillors, and some of them are here, and I'm sure they won't mind me saying, they don't always agree with each other, Madam Speaker. And they will vote for very different political parties, Madam Speaker. But on this matter, they are aligned and in full agreement about building this new hospital, this tertiary hospital, this inpatient hospital, this teaching hospital. Now, Madam Speaker, the first issue I want to talk about is that it's the inpatient building, and I have here a photo. I was recently in the Mayor's office and he has a similar view. I think this was probably taken from the next door ODT building. And you can see here is the outpatients building. This is a new building, it's not open yet, it's under construction. You can see there very clearly a very large building that has had a lot of construction work on it. The old hospital, you can't see, is just behind it. There's some university buildings around here and over here. But here, Madam Speaker, you'll see there's a large piece of land and it's got piles on it. And this is ready for the inpatients building that, of course, will work together with the outpatients building. And this, you'll see, it's a big piece of flat land in the middle of the city. And that land has been acquired. The consents are there for the inpatients building. The land has been remediated, it has been strengthened, and there are piles in the ground ready for the building. But instead, we've got estimates that about $10 million a quarter is being wasted while this project is suddenly paused. Despite all election promises, it's paused. And it needs to be a tertiary hospital, Madam Speaker. That is, that it does all the tricky stuff for people throughout Otago and Southland. Needs to be a teaching hospital, Madam Speaker. We have a wonderful university, the University of Otago, that teaches not only doctors, and it can teach more doctors. That's an easy thing for it to do, much cheaper than Waikato. Teaches nurses, it teaches physios, it teaches dentists, and they use this hospital as well as using the units in Wellington and Christchurch. And we had the National Party campaign on delivering this hospital, but now they've come and said, oh, maybe we'll go back into the old building that is leaky. When we have floods, it leaks, Madam Speaker. So all that is happening is this government is taking us backwards, and they need to build it once, right and now.
The time for this debate has expired. I call on members' order of the day. Number 1.
Citizenship, Western Samoa Restoration Amendment Bill, committee stage.
I declare the House in committee for consideration of the Citizenship, Western Samoa Restoration Amendment Bill.
Members, the House is in committee on the Citizenship Western Samoa Restoration Amendment Bill. We come first to Part 1. This is the debate on clauses 7 to 10, amendments to Citizenship Western Samoa Act 1982. The question is that Part 1 stand part.
Mr. Chair.
Members, the House is in committee on the Citizenship Western Samoa Restoration Amendment Bill. We come first to Part 1. Part 1, this is the debate on clauses 7 to 10, amendments to Citizenship Western Samoa Act 1982. The question is that Part 1 stand part. Point of order, Ricardo Menendez-March.
In the language right, I move that the bill be taken as one part.
Leave is sought. Is there any objection? There is no objection.
Mr. Speaker.
I'll just re-go. Okay. There we go. The question is that parts 1 and 2 and clauses 1 and 2 stand part. Tiana Tuiano.
Mr. Chair. Thank you, Mr. Chair. And I'm about to experience what it's like to be on this side of the microphone, of this side of the bench. Let me begin by acknowledging everybody at home. Talofa lava, kia rana koutou katoa, tēnā koutou katoa. I know that this has been a journey for the community, an important journey, a journey of which my part in that journey has been a small part, and this Parliament has been a small part of that journey as well, but nonetheless a significant part as well. Let me also acknowledge the members, former members of Parliament of Samoan descent who have come out to support, and I note that Anai Arthur Anai is with us once again, and may I extend a kia orana and a talofa to him Mr. Chair, as well, and also noting we've had Lua Manuvao Winnie-Laban with us, the Honourable Lua Manuvao Winnie-Laban with us at the last time, Teresa Ngobi Opito Williams-Seal as well. And so being the Samoan adjacent Pacific Islander supporting my Samoan ainga, it has been incredibly humbling and a privilege to support those communities. Mr. Chair, in the second reading we had unanimous support for the bill. And for me, Mr. Chair, that points to an acknowledgement from the House that we are dealing with a legacy issue, that this is a legacy issue that we are dealing with, an acknowledgement from the House that this is a right that we want, this is a wrong that we want to right. And for many years, the Samoan community have been trying to push this Parliament to do the right thing. And so I want to put on record my thanks to all of the parties who have gotten us to this far, and noting this is as far as we've ever got as a Parliament into getting some form of restitution, some form of restoration for our Samoan ainga. The emotion was palpable in amongst many of the speeches, and I want to acknowledge that. But I also want to acknowledge that, of course, with the communities, they want us to go further. And so just to clarify for the communities that are listening, there are a couple of stages that we go through. There's the first reading, the select committee process, and so grateful of the large number of submissions from both here and in Samoa and abroad that brought their concerns to the select committee. And then we had the second reading, which received unanimous support, and now we are at the committee of the whole House. In the select committee, we didn't agree on everything, but we did agree to locks and braces and belts on the legislation. I think that's what the language was used, to move the legislation forward as well. And so I do have a couple of amendment papers on the table, just to highlight and just to test, actually, to see if there has been movement for different political parties. I note and acknowledge, first of all, as a first-term MP that put this bill into the biscuit tin, I was unaware of the complexities of what that might mean as well, but more aware as a second-term backbench MP in the opposition that it requires a conversation across the House, and a conversation for those that who, if I can put it this way, are closer to the levers of government in order for us to actually get some movement. And so there are opportunities before us in order to actually see if we can go further. And I also note within the select committee there were many perspectives, many other issues which are actually outside of the scope of the bill that the community brought up as well. And I think it would be interesting for the community for us to touch on that, but of course I will defer to Mr. Chair to make sure that the House doesn't wander off the garden path and get lost in the taro patch. But I think in the wider context of what we are trying to achieve, it's important to touch on some of that. So, for example, clarity on how this might impact access to superannuation. Those were some of the concerns, issues that were brought to the select committee. Frustrations, absolute frustration with the visa conditions, with the quota system as well. Mr. Chair, frustration with the visa system, visa processing times, and that as well was also expressed. And I recall one submitter who talked about how he fell into the cohort that we have identified within this current form of the bill, but he lives in America. And he had to travel through New Zealand in order to get home to Samoa, and he's got to jump through all these visa hoops as well, which is, of course, I feel unacceptable. So that stuff falls out of the scope of the bill, but I think if the opportunities that we are presenting, that I'm bringing back from the select committee, don't have enough support around the House, There is other opportunities, and I would encourage parties to look at that, particularly government parties to think about what we can do to make that legacy more meaningful, what we can do to make that legacy impactful and important. And as has been expressed to me on a number of occasions, members' bills are limited, government bills are more expensive, but also because of that, it does require for us to have a conversation as well. So my amendment papers that I have on the table, one of them is around the discussion that we had around access to fees. And I note that usually with this type of bill, you wouldn't actually specify application fees within primary legislation. The point, and I expect that other members, particularly who are in the Select Committee, will possibly articulate a view, and that is the reason why. One of the reasons why it ended up there was that it could delay the commencement date. And I note that justice delayed is justice denied, and the original cohort that we are trying to support here are not getting any younger. So it's important to note. However, I reflect on the convincing arguments of Le Maunga Lydia Sorseni. She's actually swayed me. She did, I think, some powerful convincing around certain issues with that type of approach. And if I can summarise that, and others will, I expect, to possibly a better job, it's that if you have been denied citizenship, if you had something taken away from you, why should you have to pay for it? Why should you have to pay for it as well? I get the balance on the other side of that is that operations cost money, delaying of the commencement date, and so on and so forth. So, but on the balance of that, I sided with Le Maunga Lydia Sorseni, and that's what one of the amendment papers features as well. One of the other very strong submissions, number of submissions, it featured in a number of submissions, was around widening the scope to direct descendants, particularly those born before 1962. This was a very strong view that was expressed, so I have another amendment paper to that effect on the table. So it would be interesting to canvass different perspectives from different political parties as well. This is, as I said, there are some opportunities which could exist outside of the scope of this bill, but before us we have a couple of opportunities within the scope of the bill that I'm hoping that we can explore today.
Mr. Chair.
Rachel Boyack.
Yeah, appreciate the opportunity to take a call. I may need to take two calls on this bill because I do have some questions for the member in charge relating to his amendments, and there are two separate pieces of the legislation and two separate clauses to talk through. So I just do want to talk through the amendments that are on the table and ask some questions of the member. So, Mr. Chair, I'll start with amendment paper number 139 in the name of Te Aotearoa, the member in charge of the bill, which is specifically amends clause 10. Now, can I just note on the record that the Labour Party will be supporting this amendment in the House today, and so I thank the member for putting forward this amendment. During the Select Committee process, we heard from members of the community who wanted to see the scope of the bill in terms of who it applied to extended so that essentially the first group of descendants who were born before 1962 would be covered. Now, Mr. Chair, members who were part of the committee process would also note that there were also submissions made wanting to extend it further. During the Select Committee process, Labour and the Greens both voted in favour of legislation that would have allowed for that first group of descendants who were born before 1st of January 1962 to be eligible. And so I just note that what the member's amendment paper does is it adds a new, there's already a new section 7A in clause 10, and it replaces subsection 1 so that it clearly refers back to the original original Act that we are amending to include another section in there which would apply to people born before 1 January 1962. I've got two questions for the member about this, and it's my hope that listening to arguments in the Committee of the Whole that perhaps at least one other political party will consider supporting this. I'm interested to know if the member is aware of how many people this may affect, and secondly, why he has specifically put in place that date of 1st of January 1962 and why not dates later. So interested in hearing from the member on that. Now, the slightly more complicated matter is two amendments that we have on the table related to fees that essentially lead to those who are successful not having to pay a fee but using different mechanisms. And so just to again note on the record, looking at amendment paper number 140, that the Labour Party will be supporting this amendment. We heard very clearly from members of the community that given citizenship had been taken away from them, they felt a huge amount of hurt about that, and for some a significant amount of trauma, and felt very clearly that one of the ways the government can honour that is by not requiring a fee to be paid. And it's a small fee. It's not a huge impact on government revenue at all. But symbolically it would say to these people, yes, we acknowledge that the decisions made back in 1982 have caused you harm, and we don't expect you to have to pay a fee in order to apply for citizenship by grant. I note that member from New Zealand First, Andy Foster, has an amendment on the table that would achieve the same outcome, but my reluctance on this matter is that people would still have to put the cost up front. They'd still have to come forward with the cash in order to apply. But it would require the fee to be fully refunded if the application was successful. And so the Labour Party's position is that we support Tiano Tuiono's amendment, and happy to have continued discussions around the amendment proposed by Andy Foster. I do note that regardless of what is in the bill, that Cabinet always has the opportunity through regulations to put fees in place. And so one of the objectives we were looking for, Mr Chair, I'd quite like to finish my short contribution just quickly in the next call if I can, Mr Chair. One of the things that we noted during the Select Committee process was that there'll be, to start with, Mr Chair, there'll be quite a number we expect to apply immediately who should be eligible and should be successful. And during that time frame, having no fee would be fantastic. At some point in the future, Cabinet makes regulations around all fees for citizenship, the cost of applying for citizenship. So it wouldn't rule out Cabinet in the future saying, right, you've had your window to apply with no fee. Now it will become standardised like any other application after 3 or 6 months or something of that nature, that yes, just like any other application, there'd be a fee. And that was essentially what we were trying to achieve through the Select Committee process. So interested to explore some of these conversations throughout the Committee of the Whole, and thank the member for his work so far on the bill and also his amendments put forward today.
Andy Foster.
Thank you, Mr Chair. I just wanted to, before speaking about the amendment which I've got on the table, just to talk a little bit about the context of it, because that's really, really important. And just to first of all say congratulations to Tiano for getting the bill through the process. It's not just getting it drawn, but getting it through the process. It's been a much more complicated bill than I think any of us anticipated. But also Rachel Boyack for chairing us, and to all of my colleagues on the Governance Administration Select Committee. I think it was a very, very collegial process, and I thought we worked really, really well together to try and nut out these issues. And also just want to place on record also my thanks to all the submitters, 25,000 people. So if you think this was a sizable issue for our Samoan community, you betcha it was. It's a very big issue because people felt about these issues very, very deeply. And that's why it's important to reflect a little bit on that background. Mr Chair, I just wanted to reflect on why we're here. So why we're here is New Zealand held Samoa, or Western Samoa originally as it was, as a protectorate under the League of Nations after the German occupation was removed essentially during the First World War. And essentially New Zealand held a role looking after Samoa for good or bad, and often, sadly, it wasn't done well, right the way through till Samoan independence in 1961. There was a change in 1948 with the adoption of a New Zealand Citizenship Act, when effectively New Zealanders became New Zealand citizens, not British citizens, and that's a key point in time. But in 1982, and obviously we had a backdrop there of Samoans in particular, but Pacific Islanders generally, but Samoans in particular, being targeted by New Zealand government. You had all the issues around dawn raids and so on. So there's not a great history there. And we had the situation where Whalemai Lesa was told, you're an overstay. And she took that all the way to the Privy Council, saying, actually, no, I'm not. How can I be an overstayer? Because I was born in Samoa, Western Samoa as it was then, during that period of time, 1924 through to 1948, when we were British citizens. And therefore, if we were British citizens and New Zealand was looking after it, we were New Zealand citizens. And the Privy Council actually overrode all the New Zealand courts and said, actually, we agree. And then, of course, what happened is that the New Zealand government, and it was the Muldoon government, but also supported by the other parties who were then in Parliament, so both Labour and Social Credit, and said, no, we're going to overrule that. And Parliament is sovereign. And so they had the right to do that. But it has left a long-standing grievance from the Samoan community, and that is what this bill is about addressing. And that's what's really, really important that we do that. Now, to my amendment, Mr. Chair, basically is saying at the moment you have to apply, and we had a long discussion as a select committee. You've got to apply for citizenship. It doesn't just get granted. So you've got to apply, and you've got to pay a fee. It's a lower fee than if you started the process from scratch and you were applying from anywhere in the world, because basically it's about confirmation of citizenship, not application for. But we still have a lot of people saying to us, hey, that's not fair, because these people already had citizenship. The Privy Council said they were entitled to citizenship, and the government of New Zealand of the day in 1982 took that away. And so there's a feeling of injustice. I've heard the argument that does this set up a precedent for anyone else? Well, I don't think the government of New Zealand has done this in any other place at any other time to a whole nation, effectively. So I don't think it's going to cause a precedent in that way. And also, we're talking about people who are between 76 and 100 years old. 76 and 100 years old. So I don't think it's going to cause a precedent there. And so what the amendment that I have on the table, the other thing I should say about immigration, and Tiano has got the amendment on the table about saying, well, let's just waive all the fees altogether. We had very, very strong advice from immigration, DIA, etc., saying, please don't do that, because what we know will happen is that people will have a go. And you could end up with thousands and thousands and thousands of people having a go. That will put a significant burden on the administration system. And also what it would mean is that there are other people who are legitimately applying for citizenship or residency from around the world will get clogged up in the process, and that would disadvantage them. Not a good idea. So what my amendment is to say is you pay the fee, but when you're successful, and it can only be those 3,500 odd people who are aged 76 to 100, who were born between 1924 and 1948. Mr. Chair, can I just finish off?
Foster.
Yep, thank you. Who were born within that period of time, they are the only ones who will be able to be successful. If they are successful, then they will be entitled, not a judgment, but entitled to that fee being refunded. And that effectively is a way of saying, we understand you were citizens, the Privy Council ruled that you were citizens. We understand the long-standing grievance that is here. We are not going to penalise you for that, and we're going to give you the money back. And look, if I might just finish off with a couple of other things, Mr. Speaker, which I think were outside of the scope, but we did touch on because, Tiana, you've mentioned this. One was the very, very strong aspiration that people are able to come and go, that people from Samoa are able to come and go more easily. for family reasons, for special events, all those kind of things. And so while it's outside the scope of the bill, we have said to the executive, please, in the report from the Select Committee, please can you consider the visa situation? Because there is no Pacific country which is visa-free. There are lots of other countries, most of them are in Europe or South America or North America or Asia, but there are none in the Pacific. Can you ever think about that and whether that's a good thing to do? And that was passed through the Select Committee. And the other thing which specifically wanted to focus on, because it has come up from a number of sources, is the issue of superannuation. Of course, to gain New Zealand superannuation, merely being a citizen is not enough. And there's a sliding scale there depending on how old you are. But for people who are born before 1959, you have to be in New Zealand for 10 years. Obviously, that's something which you might want to consider in this context, but that is not something that is for now, and that is not something that is within the scope of the bill. So, Mr Speaker, I would like to commend my amendment to the House.
Tom Rutherford.
Firstly, congratulations to the member again, and 25,000 submitters, 24,500 submitters really reiterates how well the community turned out, made their views clear on this piece of legislation. We sat and spoke in this House just 2 weeks ago in what was an emotive but also a really moving opportunity for the House to give perspectives on the submissions that we had heard through the Select Committee process. And you heard during that time how the National Party at the first reading didn't support the legislation for a variety of a couple of key reasons. But then through the Select Committee process, myself, my colleagues Cameron Brewer and Tim Costley, we were able to work with the other members of the Select Committee to refine the bill to a place that we thought as a political party we could support it. Hence why you saw us at the second reading change our position on the legislation and vote in support of it to bring it to broad cross-party support from every political party in the House. And one of the key reasons why we as the National Party voted in support of it at the second reading was because we had got a change in the first place during the Select Committee phase around, rather than a repealing piece of legislation, it was an amendment to the number one legislation of the Western Samoa Act of 1982. And for us that was a big deal because it focused on what the implications would have been for the Treaty of Friendship and what that would have meant for New Zealand's relationship with Samoa, and whether repealing the full legislation would have actually breached that Treaty of Friendship and what the implications of that may have been. The other component that we in particular were pleased to secure on the Select Committee stage as well was around refining and defining who were eligible through this piece of legislation and getting it to that cohort of the 1924 to 1948-49 and roughly around 3,500 people was really important to us as a political party to support the legislation. And I note that the member himself and members of the Labour Party as well have said that they will be supporting the amendment bill that's on the table at the moment, the amendment paper that's on the table at the moment around broadening the scope of the legislation so that descendants are included as well. We here in the National Party won't be supporting that amendment paper because we made it pretty clear through the Select Committee process that we needed to get the bill refined to a place that we could support it. And it was to that initial original cohort and not the descendants of them for a variety of different reasons. And the other part on the amendment paper, one of the other amendment papers also put up by the member in charge, particularly focuses on around the fee for application. And as my colleague Andy Foster from New Zealand First stated, the advice we received from officials during the Select Committee process was clear. Please don't do this. Please don't do it because of the burden it will put on those processing the applications as soon as the legislation is enabled and passed. But also, please don't do it because you just think that it's at the power of the executive to decide, or through regulations, to decide what the fee should be. Because what that may have done is created this no man's land between the legislation passing and no fee being set. And so you may have a cohort who had applied and got it for free, and then 3, 6, 12 months down the track, you had people then having to pay for their application. And so it created an in-between phase, a no man's land, which would have been, I think, detrimental to the impact of what this bill is actually trying to legislate and change. So we won't be supporting the amendment in the name of Te Anau Toiono around removing the fee for application. But we have considered the amendment paper put up by my colleague Andy Foster around clarifying that the fee may be refunded if their application is approved. And we've considered it long and hard. I look at my colleagues Tim Costley and Cameron Brewer and our wider team here on the National Party. We've considered that, and we think that is a pretty reasonable place to hit. We think that's a pretty reasonable place to stand on this, and so we will be supporting that piece of legislation, that amendment paper on the table, just to make it clear to our colleagues across the House. We won't be supporting the two in the member's name, but we will be supporting Andy Foster's around refunding the application fee to those that are successful in applying for it and receiving citizenships through the Western Samoa Bill. Mr Speaker, I do have a number of other points I'd like to talk to. I wanted to talk to those, but I'm happy to allow my colleagues to go first, but I will be seeking the call, so if you're happy to be gracious and to give it to me like you have to other colleagues. Mr Speaker,
Rutherford.
Thank you very much, Mr Speaker. And no, he's given me the call, thank you. The couple of points in particular that were also really important were around the changing of the title for the legislation. And we had many considerations that we talked about through that, and we'll have title and commencement come up further down the track. But it was particularly important to make sure that the title was reflective of what the legislation was aiming to achieve. And we made some amendments at the committee, through the select committee stage, and I'll talk about that a little bit later on as we go through. But I did think it was really important also, Mr Speaker, that we were very, very specific, and you'll see it in the report back from the Select Committee, so that if this were to be brought before the courts in the future, you could see what was quite clearly defined around who was eligible through the legislation and who wasn't. We needed to be really clear that who the applications through the citizenship were applying to, because if it didn't quite, if the wording wasn't specific through the legislation, then I suspect there would have been a myriad of future court cases that would have been dealing with this legislation, and I don't think that really would have served in anyone's interest. So I just want to acknowledge why we have been very, very specific through the Select Committee stage to make sure the legislation is fit for purpose and intending to receive and focus on those that we think deserve it. And it is that initial cohort from the 13th of May 1924 to the 1st of January 1949. And as rightly pointed out by a number of colleagues already, those people, you know, they could be up to 100 years old. And so there are unfortunately, sadly, many who have probably passed on. But there are many families, and as we talked about, many grandchildren, watching this to be passed to see what it would have meant for their whānau and for their elders. And even though it's not applicable to them now because they've passed, it's actually really important that the legislation still gets across the line. And we're really supportive of it now for that initial cohort of 3,500, but we won't be supporting to broaden it because we just think we'll be opening up a lot more ramifications around the descendants aspects and talking about what superannuation looks like, as my colleague Mr Foster talked about too, around how what that may be for around, we've got specific criteria already to be eligible for superannuation, and then if you start to blur the lines a little bit, where do you draw the line for other people who may be relevant to receive it too? And I just want to finish on a couple of key points. Let's not forget the relative importance of the Treaty of Friendship. Let's not forget how vital that has been throughout this process. The real relationship that New Zealand holds with Samoa and the relationship we've held through the Select Committee process. We heard from the former Prime Minister of Samoa during the Select Committee process, and we heard from the Samoan government, though they didn't want to present necessarily to the Select Committee. We knew what they were trying to say to us through the Select Committee process around what this bill may have meant for the Samoan community. And so I think it's important in the sense that we have found a really good balance with this bill. We've found a really good balance in the sense that we've refined it to the 3,500, we've kept it down, not through the descendants, and the National Party will only be supporting it if the legislation fits in that mould. And so I just want to put that to the member and the chair. I do have a question I would like to ask as well around the advice that the Select Committee received to the member around the application fee, and whether the advice was either in favour or against it, and what the advice had to say about it, and I'd welcome the member to respond.
Parmjit Palmer.
Mr. Chair, for this opportunity. Mr. Chair, I would also like to start by congratulating member in charge of the bill, Tiano Tuno. It's actually quite exciting to have a member's bill come to the stage, and that too a very special member's bill, I would say, because this bill is going to make a difference not only in the lives of people, those who will get a citizenship through this bill, but the families and friends and the entire Samoan and the Pacific community that is here in New Zealand. So really want to acknowledge that, Mr. Chair. Mr. Chair, in the second reading, it was also really good to see that the community in large numbers was here, and the member in charge hosted a beautiful event after that, where we had a really good opportunity to interact and to talk about other issues that were there in their minds. And based on that, I can see, Mr. Chair, that we have the amendment papers put forward by the member in charge and also New Zealand First member Andy Foster. And I am taking this call to support the amendment paper put forward by New Zealand First member Andy Foster on behalf of the ACT Party, which is to amend Clause 15 to insert new subclause 3 in Regulation 17A, which says the fee must be refunded to the applicant if their application is approved. And I want to acknowledge member in charge's amendment, which is actually to make a change that there is no fee for an application for grant of citizenship under new section 7A. We believe that this amendment that is to refund the fee to applications that are approved is quite a balanced approach, and that's why we want to support this. I also want to highlight that when the bill came through for the first reading, ACT Party was the first government party to stand up and support this bill, because we really thought that we assessed the bill and we thought that this bill must go to the Select Committee process, and then very soon we were joined by New Zealand First. In the Select Committee, we heard from around 25,000 submitters, and I would say that the Select Committee process is a much more powerful process than the committee of the whole House, because there this wider community is involved, whereas in this process, committee of the whole House is us members of Parliament that are involved in deciding what other changes should be made to the legislation. So in the second reading, we supported the bill that was reported back. And now going forward, we believe, as I said in my first reading speech, that the ACT Party believes in fairness, we believe in equality, we believe in justice. We also believe that when we talk about fairness, when we talk about justice, it cannot be delivered partially. There needs to be a comprehensive approach towards that. And these people, those who would have had their citizenship anyway, if it wasn't taken away, then for them now to apply, that's one step. Yes, they have to do that. But then to pay if their application is approved, we believe is something that we really need to seriously consider. And that is why, Mr. Chair, we have decided to support this amendment going forward. It is also important that we address the issue that is in front of us in a fulsome manner, to the extent that we can, while we are fair to everybody else as well. Because when we look at the process of granting citizenship, that fee is actually a cost recovery system. So we want to make sure that it's fair, but going with this approach of a refunding fee for applications that are approved is going to be, I think, is going to be a practical approach, because this will also put some personal responsibility on people to really consider and see that they will qualify, they do qualify before they apply. So we don't want to see that rush that just comes in only because they think that they might be able to get citizenship because of this bill going through. Mr. Chair, I also want to say that going forward, it is going to make a huge difference in our local Samoan community, because I'm an immigrant myself, and I fully understand that when the community comes from their birthplace to another country, makes another country their home country, which is New Zealand, they not only think about themselves, they also think about family members, those who are back home. And this is what the community here is doing. They are advocating for the families there. And this is not the first time that this issue has been advocated. There was a petition before that had a huge number of signatures, and this now has come in the form of a member's bill, which we are having the opportunity to debate, and it's really great to see that, Mr. Chair, that it has come to the stage where us in the Committee of the Whole House are able to analyse this bill and see if there was any other opportunity for us to improve, any other opportunity for us to make it fairer, and any other opportunity for us to ensure that this fairness and justice that we want to deliver, that wrongs of the past that we want to fix, we do that in a comprehensive manner. So we will be supporting this amendment, Mr. Chair. Thank you.
Mr. Chair. Mr. Chair, let me first of all thank all members for their very considered contributions. I thought I'd better get up and start giving some answers before I run out of pages. Just to the questions from Rachel Boyack, who made a very strong contribution in navigating us through the select committee process, and I want to again acknowledge her skill in guiding us through a complex process as well. Her question was around what are the numbers for the people born before 1962 that this amendment that I've got on the table would apply to. It's around about, the age range is 62 to 100, and it will be around about 19,434 people. And that estimated figures was put in the table in the departmental report. It was put together by MFAT officials using data from the 2021 Samoan National Census. They did some extrapolation with the numbers and calculated against a number of variables. So it is an estimate and it is a guesstimate. And so from our perspective, it's not in terms of having a pool of people that could actually apply for a particular citizenship path. It doesn't seem, at least from the Green Party's perspective, to be an exorbitant number. But I do take the points made by members. The other question was around why 1962. Well, that's the establishment of the Samoan state. And if members haven't had an opportunity to have a read of the Select Committee report, I would encourage members to do that. I've been on a number of Select Committees, and this one was particularly thorough. There's a really important historical part in that Select Committee report, along with the legislative bits and pieces as well. And the important thing here is, it is Samoan history, but it is New Zealand history as well. It is the history of New Zealand citizens who had their citizenship denied. And so, just to underscore the importance of knowing that history and being familiar with that history, and the importance of that relationship with Samoa. It's the only country that we have a treaty of friendship with. So making sure that we do everything that we can to make that relationship as strong as possible is important. And noting, as I think all members on the Select Committee noted, the comprehensive and rich contribution of Samoan communities to the fabric of Aotearoa. Just to respond to my particular amendment and the reason and the rationale for proposing it, and I do take the member's point, Mr. Chair, Tom Rutherford as well. And if you do go through there is some rationale why people voted a particular way, and I did mention that a bit earlier around not delaying the commencement date, certainty in operations, and so on and so forth. But as a backbench MP in an opposition party, if you don't ask, you don't get. And so I'm pretty certain the community wanted me to ask, so I'm asking. And the rationale for change was I was proposing to amend the bill to reduce the application fee for citizenship under this bill to $0. Currently it's set at $177, because we don't believe that it is appropriate to impose an application fee on people who had a right taken away from them. And just to note, it is extremely unusual for a bill to address a historical wrong to require those who've been wronged to pay for an act of restoration. And as we said in the committee's report, the bill does not provide redress for the history of injustice, but it is a concrete response. And so I guess the amendment paper is asking the House to take that one step closer to acknowledging that injustice and to making that path to restoration that much more solid. And just to respond by the very good, strong contribution by Andy Foster, member for New Zealand First, who made, I think, very considered contributions during the select committee process as well. And the very considered amendment paper that he has on the table as well. So people don't want to, and I guess, Mr. Chair, if I could put it this way, people don't want to support my amendment paper. Andy Foster's one is just as it will be something we'll be thinking about supporting as well, because it at least is on that path towards restoration. Yeah, thank you, Mr. Chair.
Ricardo Menendez-March.
And can I begin by acknowledging my friend and colleague Te Aotearoa for the amazing work that he has done shepherding this bill, and I want to acknowledge the broader Samoan community here in Aotearoa and throughout the world and their homeland for their amazing contributions to the committee, the select committee stage, which I think has delivered a really, really big mandate for justice to be delivered. And so with that in mind, I wanted to present the Green Party's view in support of my colleagues' amendment, particularly around, I wanted to touch on the one around broadening the scope of who would be eligible for citizenship, including descendants. And I think the member and the chair already made a really important contribution that I wanted to echo, and that this bill is not for redress, but it is a response. And to me, I think if members across the chamber are going to acknowledge that there was an injustice being done in the past, I think the least we can do is actually genuinely commit to go all the way to, as far as we can and within the scope of the bill, to deliver just some sort of adequate response and justice. And I want to acknowledge that if we were to go with the bill as it is and without the amendment, we are subjecting some of those descendants from having to go through strenuous and often costly immigration processes to remain connected with those people who could be granted citizenship. And so this is why it's critical that we look at how justice can be delivered fulsomely, and I think submitters at the select committee stage presented really compelling arguments for this to be the case. So the Green Party is backing our colleagues with some amendments in full, and I wanted to also touch on Tiano's amendment in relationship to ensuring that there is no fee for an application for grant of citizenship under the new Section 7A. There's two reasons why I think, despite the advice in the Select Committee report, that this amendment still stands. Because in the Select Committee report and in contributions from National Party members, we have heard arguments against it relating to the fact that the Department of Internal Affairs recovers its costs for processing citizenship applications. At the same time, and then they also talked about the burden that all these applications would place on the public service. I would argue that actually the government parties have a choice around whether they commit to adequately resourcing those departments to accommodate justice being delivered. And I think, to me, if there is a commitment, then those resources should go in place to allow this amendment to go through. And this can include things like even temporarily bolstering the workforce and having a task force that it is very specifically in charge of processing these applications. And so I think there can be accommodations that can be made that I don't believe would be costly and either way would be relatively temporary to allow the bill to work in a way that doesn't create further financial duress for families who, through intergenerational injustices, many were dispossessed from their homes, their workplaces, and in this case, the citizenship they had a right to. And so this is why we think that Tiano's amendment in relationship to scrapping or not having a fee makes a lot of sense. In saying that, the Green Party understands and hears the member Andy Foster's arguments for his own amendment, and we want to deliver what best we can for the community under the circumstances that we're working within. And so we acknowledge Andy Foster's contributions and rationale for his own amendment, and saying that our preference is for justice to be delivered in full within the means that we have. And so I want to commend Tiana Tuiono for lifting the voices of submitters and presenting amendments that I think genuinely honour the voices of Samoan community members who have asked Parliament to genuinely be committed to justice. Finally, on the point of broader immigration settings, I wanted to ask the member whether he had received any feedback around the additional stress that family members would experience in relationship to those immigration settings being in place should, for example, one of his amendments not be accepted, and whether he's received feedback around, for example, the cost or the delay in visa processing times that could mean that people be split apart. So I'm interested to hear from the member if he's received any feedback around the immigration settings that we're working within that make a case for his own amendment.
Tim Costley.
Thank you, Mr. Chair. This bill, as it's worked its way through the various stages so far, has often been high in emotion. There's been a moderate amount of history, but very little in the technical, and I would like to just delve into some of the details and pick up some of the comments that the member in charge made earlier on, and particularly around both Clause 10 in the bill as it stands today, but also the amendment paper we've just heard a view in favour of from the Green Party. And this is about the provisions as to whom this bill applies, who can ultimately gain citizenship or a pathway to citizenship because of this. And it is actually very technical, and as we heard from the member himself, maybe more technical than many realised at the outset. But this stems in its very title as it stood when the bill was introduced from the 1982 legislation in response to the Privy Council, who identified two very distinct dates, one the 13th of May 24 and the other the 1st of January 1949. And there are questions now as whether or not we should extend these to different dates. And I do want to drill into this. Firstly, at a very technical level, if the amendment paper, number 139, went through as written, it doesn't just award the path to citizenship to those that were born in this period and their descendants born in this period up to 49. And the reason it's important to include the descendants is, as we know, the case that perhaps someone was born in Samoa in 1924, qualifies for this, maybe moved to Australia, for example, after World War II, and had children there in 1948. And those children are also now able to, they may have never lived in New Zealand, they may have never lived in Samoa, but as a result of the bill, as it stands, can apply for New Zealand citizenship. That may be surprising to some, but it was a very considered point in the Select Committee, and it was very specific that was awarded. There was a discussion around that. But as this amendment paper stands, it would then also award citizenship to any other descendants of that group out into 1962, which conceivably, in the extreme case, could be the grandchildren of the original people that actually lived in Samoa or New Zealand, and may award rights of citizenship where no other class of citizenship would award it in that category. So I would just ask the member, has this been considered? Is there any advice about any precedent that would set for other grandchildren around the world, and whether or not that is out of kilter with our extant citizenship laws? Secondly, and more broadly, it is they are very specific dates that were chosen, and they were chosen based entirely on the Privy Council decision that this all hangs off with Whalema Elisa back in 82. And it is no mistake they were chosen, and we know that the 1924 date actually stems from 1914, 1921 and 1923 legislation. It is not just a date that was plucked as an arbitrary marker. And the 1949 date comes from legislation started obviously in 1946 under Fraser and Savage. And if we were to now say, well, actually, those dates don't matter, let's consider other dates, whether it's 62 or there's another one in the Select Committee report for descendants of that period, but they could be born either side of 62. If we were to say, actually, the dates from the original Privy Council ruling are not important, What does that mean to the fundamental premise by which this bill comes? That is to say that this is a group of people who had specifically their citizenship removed by the 1982 legislation. And in fact, the member in charge in his initial comment said this was about justice for those who were impacted by the 1982 bill. But that bill is very specific, cutting off at the end of 1948. And so I just wonder as to what the thinking is there, and specifically if I was to, as I read the Select Committee report, I'm on page 10, it talks about two specific things. Firstly, it says that options were considered which looked at all descendants of Samoans. This is under concerns about citizenship rights, both giving citizenship to all Samoans. Now we heard one view that that could be 100,000, but of course it would ultimately be almost all 200,000 odd Samoan citizens. But equally, another one was talking about just the descendants. And the overwhelming feedback we heard in submissions was about all descendants. It was never really cut off to 1962. It was all descendants that so many people argued for that stemmed from that original group. But it was always framed on descendants of the original group, bound, Mr. Chair.
Tim Costley.
Thank you, sir. Bound at that 1948 and the 1924 date. And the Select Committee said that I'm quoting from paragraph 2 of that section, we consider that either of these options go beyond the intent of the bill. The updated policy intent of the bill, as provided to us by the member in charge, was very clear that it would not create new rights to citizenship for descendants of those whose citizenship were removed. In other words, it was very tightly bound around these specific dates. And I understand the emotive argument of why some might like to look to other dates. But I would just ask, what does that mean to those from 1914 to 1924? I know that's a very small marginal group, but why would we not acknowledge them? What about other descendants? Why would we cut it off at one place? And I believe that the correct thing to do is to adhere to the member in charge's original intent, very clearly articulated, to bound it to those who were directly impacted by that 1982 legislation, which hangs off that Privy Council ruling, and very specific dates grounded in 4 or 5 key pieces of legislation that span half a century. So my question to the member in charge is really about clause 10 in the bill and in the para, the implication to grandchildren of descendants that may have no connection to Samoa and New Zealand in a legal sense, and secondly about the broader intent and what this divergence could mean. The other point I guess I would make, just to get this done in one go as other people have, I hear the contributions from across the House on the application of fees. It hasn't been pointed out, but again on page 12 of the Select Committee report, one of the drivers for setting that fee was to set the lowest one possible so that it wouldn't be the $470 that it could have been otherwise. And I do support the amendment from New Zealand First in that it adheres to this lower setting and it provides a mechanism to get a refund, but it avoids delaying justice for others by swamping the system. And again, the quoting from page 11 of the Select Committee report, the financial sustainability of that application process being so important. The last aspect I guess I'd like to ask the member about is really about the change from a repeal bill. In some ways, this bill as it sits here now looks fundamentally completely different to the one that we saw at first reading, and I think for good reasons. It's got a great name. Look, I think it is a huge step forward, but there are a couple of points I would just like to raise. Obviously, the Select Committee report sums it up, I think, very nicely, where it talks about, the repeal of the 82 Act would remove the pathway to citizenship. That was agreed in 1982, would impact the Treaty of Friendship. But the other point I wonder if the member has considered is just around Section 32 of the Legislation Act, which says that when a bill is repealed, it doesn't change or remove the impact or the operational effect of that bill from the time that it was in force. So actually repealing that bill, as I understand, but I'd like to hear the member's view, would not actually restore citizenship. That there would be no further mechanism for those people to gain citizenship because we would not be introducing what we have today. And further, it would remove the path to citizenship that the 1982 piece of legislation made for all Samoans, not just those from the target dates 24 to 48, but for all Samoans to have that fast track. If they can reside here legally, they can apply for citizenship. They don't need to pass the English language test. It's something that we offer no other country, and I think is very special. And I wonder if there has been thought that's gone into that, or that we should capture now. And the reason I ask some of these questions, although they may seem obvious to some, is that I foresee, like we heard from Mr. Rutherford earlier, a time when this ultimately may be challenged, when other descendants might say, well, what about those that were born in, I don't know, 1975? What about those born in 2024? What is the impact on them? And I think it is worth capturing now, because I don't know that we'll have time in the third debate to go into the technical details, what the intent is, the reason that we have stuck to these dates. And fundamentally, I guess my other concern is if we were to change dates and things now, the Treaty of Friendship requires that the New Zealand government consult with the Samoan government on all matters of foreign affairs citizenship. And so if we were to change it, would this create legislative issues, Mr. Chair? Very short.
Very short, Mr. Costley.
Very short, Mr. Chair. Would this create legislative issues where we would then have to pause the bill or discharge it so we could go back and renegotiate with the Samoan government? So Mr. Chair, in conclusion, I'd like to hear from the member about Clause 10, about the implication of grandchildren, about changing away from dates founded by the Privy Council, about any implication of repeal from the Legislation Act, and of course our relationship with Samoa. Thank you.
Thank you, Mr. Chair, and thank you for the very considered contribution from the member. And a point taken about the Treaty of Friendship. It is so incredibly important that we treat that with the respect that it deserves, and to note that requires the diplomacy relationship is incredibly important. I guess the way that I looked at the repeal, the hard repeal of the bill, and you will note that there is no amendments on the table reflecting that, and I think it was captured very well by Rachel Boyack in the second reading about the symbolic nature of doing a hard repeal, about saying, look, we had this and now it's gone and it's over there. And in the Select Committee, we did have a debate, and the Greens and Labor went one way, and there was an opportunity for us to move the operative clauses, which are incredibly important around the protocol and making sure that those pathways still exist into other parts of legislation that would have been, as the member has canvassed, a lot more complicated, but nevertheless the symbolism would have still been quite notable and quite noted as well. But I take the point that around, I think what all members have been saying around not trying to delay commencement, and so I think the opportunity to actually look at a hard repeal has, in this context, in this scope of this bill, has passed. Hence, that's the reason why there was no amendment paper, at least from us, on that particular perspective. And I can also agree with the member around my initial intention. As a first-term backbencher MP, when I kind of really got into the details of this, and I think we've all arrived there as a House. You find out about the history, and at that time in this House we were going through the Dawn Raids process, and I had a number of people contacting me, well, have you actually had a look at this? And when you have a look at it, it's incredibly painful history. It's incredible heavy history. You have people who's had their citizenship removed. They were New Zealand citizens and they had their citizenship removed. So as a first-term backbencher MP, I was like, well, this is terrible. This is absolutely not right. This is not fair. It is unjust. And so my motivation was, of course, to support those elders, and that's the rationale why I put that in the tin. And acknowledging all the Samoans that I grew up with, Whaanana, Fessel Collins, Te Ao Pritchard, Wiltu Fully, all of those people, I grew up with them and came from the same neighbourhoods, and it seemed to me to be something that was my job to do. However, the the beautiful thing I think about the select committee process is that you get submitters that come in, and in this case, many submitters that knew more than me, had more expertise than me, and were able to offer other perspectives, other things that I had not considered as well. Hence the move from myself to actually, let's look at what descendants look like. Let's look about what the actual number was. And so my amendment and the rationale for change, and it was through that select committee process we had varying interpretations of who is captured within the group. And so I was considering a scenario where the 1982 Act had never been passed. Those descendants born prior to Samoa declaring independence would have been eligible for New Zealand citizenship. And that's why this amendment paper at this stage is a way to get fuller restorative justice. And I want to acknowledge my colleague and friend Ricardo Mendes March, who put that succinctly for us. And I also support the reflections on the impact of the Privy Council. If you go through the history and if you go through this legislation, the Privy Council case was a reaction to what happened with the establishment of New Zealand citizenship in 1948 and all the history prior to that, post-World War I, from when Samoa became from a German colony into a New Zealand colony. And then the 1982 Act was a response to the Privy Council case. And just in the same way that this now amendment bill is a response to the 1982 Act. So I think I can agree with the member, but then also still on behalf of the community push for more. And I think that's what I'm attempting to do today. And also acknowledging the important contributions from around the House of stuff outside of the scope of the bill. In the Select Committee, which got unanimous support in those comments, I felt, was around the frustrations with the visa conditions. And I take just responding to Ricardo Mendes March's comments, the frustration with the visa conditions, processing times. You have people that will apply for the quota and then they won't get it. The rigid, sometimes rigid way of trying to actually get the forms together, so on and so forth. That is incredibly frustrating for many Samoan communities, Samoan people who we have talked with. And so I hope that is a live issue for the government, a live issue about what we can do about making it easier for people from the islands, people from Samoa to come to Aotearoa, New Zealand. Many of us have Samoan relatives, Samoan friends. It is one of the most important relationships that we have in the House. And if the opportunities presented via my amendment papers don't move forward, there are other opportunities that I would like government parties to consider outside of the scope of the bill around supporting better pathways for residency, better immigration settings, making sure that it's easier for people applying for the quota to be able to come to Aotearoa, and of course better movement for Pacific peoples to allow them to spend time with their family, friends and communities.
Debbie Narawa-Paka.
Thank you. First of all, I also want to join in te wakanui o tā tātou pire mea koe tungane ara tiano. This is indeed a really significant kaupapa, and I acknowledge and did at the first reading, or that it took to get here, a couple of bases, and I want to sort of start at history and page 3, and specifically from Te Pāti Māori, the history and the significance of wakapapa, and from the wakapapa in the perspective of moana nui a kiwa, and from, I guess, the flow of the tide to that connects us, not only in toto, but the connection to us as tangata whenua and Samoa in the moana and the whenua and the pito, and the tū hono of that, and I guess the basis of that, and the fact that even though the history starts at a moment in time which actually doesn't acknowledge our relationship as a Pacifica, one ocean, one people, multiple waka. Had we been able to start the bill in that context, I think we would probably have landed very, very differently. So I want to, I guess, put to the House that for Te Pāti Māori, while we acknowledge the history in a contemporary sense, for us as tangata whenua, there is a much longer history, thousands of years. For us, that then brings us to this point of eligibility, sorry, I've been to the dentist, and on page 7 and 8. And for us, the eligibility should and will always, in principle, be noted on the basis of our wakapapa. So while we acknowledge the bill and the restrained aspect that it has, for our perspective, the bill should have been extended for all descendants, for all connections to the Pacific, and as should every visa and everything else. He wano, that is mahi for the future. What we have in front of us is the fact of the matter is that we note that national, not this national today, in the past, don't give me those eyes over there, created this drama, and we support the whakaaro that well, Muldoon, we support this, the kōrero that the Green Party, Te Pāti Kakariki and Labour had, that the bill should have been extended to a different time zone and different year. And noting that, we also note on page 10 that there was also discussion and moemoea for the bill to be extended for the citizenship of all Samoans. A couple of things also very quickly is the superannuation had the model of us as Pacifica nations and the Wakapapa and Wanaungatanga being acknowledged. We wouldn't be discussing the visa settings, and absolutely superannuation should have been realised for all as well. So we support Tiano's amendment to scrapping the fee, acknowledging that there has since been one, and acknowledging that the comments of my colleague beside me in Te Pāti Kakariki. For our perspective, I guess what we do want to discuss and make sure is that we are acknowledging that this is a very small part of what needs to be realised for those of us in the Pacific. It does make me wonder, and you know, this is a concern, and while we acknowledge the support that our whanaunga have, that we perhaps haven't met also the aspirations of the Samoan government, which is to make sure that their citizens can go out and come in as readily and as easily. And again, had the tiriti, and I mean the tiriti o Waitangi, been respected, not the treaty of friendship, that's been quoted a lot, we perhaps would have landed at a different spot. So I also want to acknowledge that silence is perhaps because we've got a lot more to do. So on that note, I do also want to acknowledge that with the amendments that are being discussed at the moment, that we will take the vote on and support Tianu's amendments, and then see how this rests. Kia ora.
Madam Chair.
Tiano Tuiono.
Madam Chair, I just want to take this opportunity to respond to the comments from Debbie Ngāre Wapaka, co-leader of the Māori Party, and thank her for being one of the first responders, if I can put it that way, and being supportive of this bill. Madam Chair, we were in Samoa celebrating that friendship as well, and I mentioned this to the member, and she was very, very supportive right off the back. And I think she understood that really important connection between tangata whenua and tangata moana. Probably having a whole lot of Samoan mokopuna, Māori Samoan mokopuna probably would have helped as well. And noting that many Māori stopped me in the street saying that they were very, very supportive of this bill and supportive of supporting our whanaunga, our ainga in Samoa.
Honourable Jenny Salisa.
Aitele lava, talofa lava, and I do want to begin by acknowledging the author of this bill, Te Anau Tuiono, who's a friend not only for having this bill drawn, but for actually working with all of the political parties to ensure that we have the bill in its form today. Can I also acknowledge former MP Arthur Anai, because Arthur Anai has not only advocated for this bill this time round, but in 2003 there was a petition with over 90,000 Samoan people that was presented here in Parliament, and I remember reading the history of what happened at the time, seeing the many, many thousands just outside of Parliament presenting their petition and basically arguing at the time that this is something that should be addressed, that the fact that Samoans who were citizens, and the Privy Council had ruled that they were citizens of New Zealand, had their citizenship taken away from them, that it is something that the government should have considered. I do also want to acknowledge the chair of the Select Committee, Rachel Boyack. I was one of those members who was fortunate enough to sit in through some of these submissions, and I could see just how well Rachel Boyack was in ensuring that we were respectful of all the submissions. There were so many emotional submissions, so many people that came with their families, their grandchildren, their children, and they cried. They cried in front of us as they were presenting. It was really obvious that they themselves were still traumatised. Even grandchildren who were not born at the time when the 1982 Act was passed were traumatised. And can I at this time just say that I do have a conflict of interest because I am Samoan adjacent. I'm married to a Samoan, a very good Samoan man. We do have 2 Samoan daughters, and our youngest daughter, Esme Salisa, actually worked with Arthur Anai and his group, and even though she was 18, she actually had a petition. She got nearly 7,000, especially young people between the ages of 18 to 24, to sign the petition on behalf of their grandchildren. And the reason why our daughter did this is because her own grandfather, Jeremia Salisa, was one of those Samoans who lived in New Zealand at the time, and his citizenship was removed from him. And it was really quite emotional. I wasn't at the Select Committee where she presented. She presented in front of the Select Committee that Honourable Carmel Sepuloni chaired, but I do know that there were a few tears shed when she was presenting, and she presented not on her behalf, but on behalf of the close to 7,000 young people. And they were basically asking, can the New Zealand government review the Citizenship Act? Can we implement measures to offer legal pathways to those who are affected? And can we also look at engaging with the Samoan community? It is, of course, the engaging with the Samoan community, one of the things that the Select Committee did so well. And again, I want to acknowledge not just Rachel Boyack, but all the members of the Select Committee. And I do want to also acknowledge and thank every single political party in this House, because it is not often that we have a private member's bill where we have unanimous support. And this is one of those bills. Not only that we have unanimous support, but a bill that will actually give justice, actually has real meaning to a whole lot of people, to thousands and thousands of people. And on this note, I do want to reiterate the words of Rachel Boyack, who said that Labour is in support of Te Aotearoa's amendment number 140. The amendment that there should be no fee for an application for grant of citizenship under this new Act. And I say this because, inclusive of GST, $204 New Zealand may not be that much to us who live in New Zealand. Can I please remind this House of Parliament in Aotearoa, New Zealand, that we're talking, and I ask, may I please, Madam Chair?
Yes.
Thank you. We are talking about between 76 to 100-year-old Samoans, many of whom still live in Samoa. And $204 New Zealand is way more in Samoan dollars. And it will be a huge cost for them. And we are talking about a unique measure where we're trying to give redress to a wrong, and not just this wrong. Can I just refer to the Select Committee's report, where they do have some of the things that happened during that time when New Zealand administered and controlled Samoa from 1914 to 1962. And just a few things. In November of 1918, passengers from a New Zealand passenger ship carrying the Spanish flu were allowed to disembark in Apia, Samoa, with no quarantine measures. And the effect of that basically saw close to 25% of Samoa's total population at that time, over 8,500 Samoans, die. They were killed. Many of the people that were killed, that were inclusive of this number, were parliamentarians. So the leaders of the country at the time, if you can imagine that many of our parliamentarians dying from something that could have been prevented, and this was done under our administration, and it was one of our ships. Another, on 28th of December 1929, the events known as Black Saturday, when New Zealand police fired into a crowd of Mao supporters. 11 Samoans were killed on that day, and including Tupua Tamasese Lealofi III, one of the leaders of Samoa at the time. He passed away. Now, the Prime Minister at that time, the Right Honourable Helen Clark, has apologised to the Samoan people for that event. But then there was the Dawn Raids. And then there was this bill in 1982, which basically stripped citizenship that were rightfully, Samoans actually were New Zealand citizens according to the Privy Council. And we are saying in this bill, and I'm really grateful that it is unanimously supported in this House, but we are also saying, yes, we will restore the citizenship for you. You have to first of all apply, which is also a barrier for some of these 76 to 100-year-old Samoans who are not so good on the internet. They will have to get someone to write that application for them, and in addition, pay for the restoration of this justice. So my appeal to my government members, please do consider supporting Amendment Bill 140 by Te Aotearoa. Whawhataitiri lava manuia le aso.
Thank you, Madam Chair. I just wanted to quickly respond to Honourable Jenny Salesa and to thank her for her advocacy on this bill. I know that she has been quietly in her way talking with members, talking with ministers to try to get that shared understanding, and so the consensus that we achieved in the second reading was in no small part due to her work. And I actually was in the Select Committee room with a number of us when the Honourable Jenny Salesa's daughter gave a submission, and it was powerful. It was powerful. It was very emotive, and many of our young people were emotive, and it was. And I think I saw a few hardened National Party members actually shed a few tears as well, Madam Chair as well. And so I think it's important for us to acknowledge the role of young people, to not acknowledge the role of Esme and her work. And I saw that right across the country as well. And for me, it shows that our future is bright for Pasifika peoples. There are strong, capable hands and strong, capable minds that are following in our footsteps.
Cameron Brewer.
Chair, thank you. I want to start off by acknowledging the sponsor of this member's bill, Te Aotearoa, and the work that he's put in it, and the ability that he's shown to work across the aisle with all parties across this House here in support of this. However, the sponsor, Madam Chair, did make the comment when he presented these amendment papers that if you don't ask, you don't get, which is fair enough. But I also put to you on these amendment papers, be careful what you wish for. And we as a select committee, and I asked the House and the wider public to take our word across the House, as has been reinforced, that we have looked at this in an exhaustive manner. The report back from the Select Committee repeatedly and explicitly, Mr Costley, puts out that cohort from 1924 to the 1st of January 1949. And that wasn't just something that we kind of went around the room and worked out what dates should be eligible. That was something that, as Mr Costley has said, the Privy Council hung its hat on. And there was a comment earlier by Te Pāti Māori that was all about Mr Muldoon. Well, let's also remember, as we go into these amendment papers and whether we support them or not, is that this was a unanimous decision made across the House in 1982 after the Privy Council decision. For those effectively for those in New Zealand, those Samoans in New Zealand, to be able to get citizenship, and those elsewhere not. And unanimous as in Bill Rowling's Labour Party, unanimous as in Bruce Beetham's social credit. So I know, as is this, there's one man in this House, a former Prime Minister, that seems to leave a long tail in this House, but at the end of the day it was a unanimous decision. And that cohort was one that we looked at carefully. We got MFAT officials in, we got Pacific Peoples Ministry officials in, we had DIA officials in, we had academics through with the submission process, and we had a lot of submissions too that we saw both in Wellington and in Auckland too. And so we didn't arrive at these decisions quickly. It took from, I think it was about the 10th of April that we had the first reading, which the National Party didn't support, as is well known, because we had some genuine concerns. And so, as my colleague Tom Rutherford said, we worked collectively and effectively across the political aisle to see if we could come to some compromise and something workable. And frankly, 10 previous Prime Ministers couldn't, and 5 previous governments, 3 being Labor, 2 being National, didn't. And so let's not look at this any other way than it being a progressive day for New Zealand, as far as our ability to do something that no parliament in New Zealand has done, is to honour the commitment that the Privy Council gave back in 1982 that was revoked unanimously by the New Zealand Parliament. So with that in mind, Madam Chair, we cannot support expanding the cohort because of all the reasons that the Privy Council gave as to those effective dates and the report back, and how, again, our intent of this select committee and effectively this House is very, very clear. And in fact, if you look through the report back, I think it's mentioned 10 or 12 times as to who's eligible, with even a very helpful Q&A in different scenarios. And so we cannot support Tiana Aotearoa's expansion of the cohort for those reasons. As far as no fees, we cannot support that because we had DIA officials in panicking, talking about their cost recovery model, suggesting, thank you, if I can have an extension, thank you, Madam Chair, talking about their cost recovery model, suggesting I think a number was $450, and we landed at that $204 including GST. But one thing is complete. Tom Rutherford, it's 2/3. I think from memory it's $136.30. If they come in and think that they could be eligible, or their descendants think that Nana and Papa could be eligible, and they have a quick look and it's not, then they will get their money back. We're not grabbing, the DIA will not be grabbing the money off them and holding on to it tightly regardless of eligibility. Again, we have made clear on page 12 of the report back that if they withdraw, potential applicants who think they're eligible, withdraw their application before that.
I guess for me the opportunity to do a hard repeal was at the Select Committee second reading stage, and as we've noted previously that justice delayed, justice denied, so helping to move that forward I think is important, and there has been a lot of symbolism that we've had over the last few months as well. Losing the battle to win something else, I think, is probably how I'd try to phrase it. So there's definitely comfort. I think the committee itself gave it a better name as well. It was quite long. We haven't got to the title yet. There might be some other contributions, but just a suggestion. Yeah. So comfortable with the title that we've got as well. So thank you.
Tony Utakere.
Madam Chair, can I also congratulate the member again for progressing this bill. I won't intend to take a full call. My colleagues have identified our support for Amendment Papers 139 and 140. I do want to thank Dr Pamjit Palmer for her contributions this evening. And I think she's right. She's indicated that the Select Committee process is by far more important than the Committee of the Whole process, which I think is a reason why we should listen to the overwhelming request from submitters to ensure that this is accessible, that there is no fee and that there are no barriers. So I do hope that that some of the government parties will come on board with that. My question to the member is really around the importance of communications, and this was raised in second reading and through the committee, that it will be really, really important for Immigration New Zealand, for the Ministry of Pacific Peoples, for MFAT, to ensure that there are comms channels in terms of what is appropriate, what is not, who is eligible, who is not. and whether he believes that the focus in that particular space is a way in which any concerns about a huge number of ineligible applicants basically flooding the system, that won't be the case. And is that the basis upon which he believes that not just rectifying this historical wrong, but also the fact that if there are strong communications, it would make the no fee for an application that much easier as well, because we're not talking about a huge amount of cost.
Madam Chair, just to respond quickly to Mr. Tangi Utikere, I think that is exactly right. If you craft your communications in a way that people understand, in the language that they understand, and make things incredibly clear, and I would encourage all government departments to be able to do that, then that mitigates any people that are, in this case, applying for citizenship who might not meet the specific requirements. And I note also that this was something that was very strong contributions made by Lemonga Lydia Sosene, who helped to guide us in terms of Samoan communities and those perspectives as well. And I just want to put on record my support for the sentiments of Mr. Tangi Utikere and, of course, of the contributions made by Lemonga Lydia Sosene.
James Meagher.
Pleasure to make a contribution. I had the privilege of subbing in for Tim Costley on the committee when it was being ably chaired by Rachel Boyack, and I took a number of lessons in how to chair a collegial and well-functioning committee at that point. So congratulations to the work of the Select Committee in bringing the bill to this point. When I was substituting onto that committee, we were considering the issue of the fee. And I do understand the member has his amendment to remove the application fee. And I recall at the time raising the question to officials as to whether or not the fee that they had originally set would actually keep pace with the costs of processing those applications. Because as a now former member of the Regulations Review Committee, we would often get fees brought to us that had significant jumps because they hadn't changed in 10 or 15 years. And we asked the officials there when was the last time those citizenship fees had changed, and it had been a while. And I recall raising the issue of, well, given that the fees are being set in legislation this time to direct what the regulation should be, in future they will be being set by ministers. And there would be an issue if we came to a point where there were a significant number of applications to the point where the cost recovery needed to increase. And what happens with the fairness aspect of a fee being increased by a minister to take account of that? That would then disadvantage those who were unable to get an application in earlier, so perhaps those who were more distant or had to wait a while to gather the resources together. And we heard the Honourable Member Jenny Salesa talk about some of the cost impositions. And whether or not there are some safeguards to be put in place to make sure that fees aren't significantly hiked 1 or 2 years after the process comes into place, at which point some of those who had taken longer to get their application together would be disadvantaged compared to those who were able to get their application in earlier. And in essence, you'd be advantaging those with the resources and means now and disadvantaging those who may not be able to do so as quickly. And that might be those who are in slightly poorer communities or with fewer connections or who don't have the resources or capacity to put the applications in place. So I had a question to the member about whether there were reflections on that, about whether there is anything in the bill or anything that could be done or signals that could be sent to ministers who would be considering fees and requests to increase the fees for cost recovery purposes to make sure that that inequity or that unfairness wasn't played out, and to make sure that you can protect those individuals who might take longer to make these applications in the future. That was really my only question for the member. I wanted to commend him for the work done on the bill, and obviously with the support around the House you can see what can happen at a select committee when strong arguments are made and compromise can be reached.
Tom Rutherford.
Thank you very much, Madam Chair. And while we're on the topic of fees, and raised by my colleague James Meagher and raised previously by my other colleague Cameron Brewer, I do want to ask the member around, he's got a particular amendment on the table around withdrawing the application fee from the get-go. Will he be supporting the amendment paper in the name of Andy Foster if his amendment paper is not to be successful? So will he be supporting Mr Foster's amendment, which says that the clause clause clarifies that the application fee for grant of citizenship under Section 7A will be refunded to the applicant upon successful application rather than no fee being set at the get-go. I'd just like to ask the member that
Yes,
question.
Thank you for that. Thank you to the member, and thank you to both members, James Meager as well. You have sent the signal to the government ministers as well. They can read it at the secondary legislation, so well done. And to answer to Tom Rutherford, yes. And I'd like to thank again the member, Andy Foster, for a very considered amendment paper.
The question is that, sorry, too late, I've started voting. The question is that Te Anau Tuiono's amendment set out on AP number 139 be agreed to. All those in favour say aye. To the contrary, no. The ayes have it. A party vote is being called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT, New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Kai.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Te Anau Tuiono's amendment set out on AP number 140 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. A party vote is being called for. Please, Clerk, conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT, New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Whakai.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Andy Foster's tabled amendment to clause 15 be agreed to. All those in favour say aye. Aye. To the contrary, no. The motion is agreed. And then, excuse me for a minute, that's...
So we ignore that second.
Ignore that second, thank you. The question is that parts 1 and 2 and clauses 1 and 2 as amended stand part. All those in favour say aye. Aye. To the contrary, no. The motion is agreed. Congratulations, Mr. Tuiono. I will report this bill with amendment.
The House is resumed.
Mr. Speaker, the committee has considered the Citizenship Western Samoa Restoration Amendment Bill and reports it with amendment. Mr. Speaker, I move that the report be adopted.
The question is the report be adopted. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. This bill is set down for third reading next sitting day. The House is now suspended until 7:30. Congratulations, Mr. Tiano.
Live coverage from the House of Representatives will resume at 7:30 p.m. Until then, some of today's earlier proceedings will be repeated.
Mr. Speaker.
E te atua kaharawa, ka tuku whakamuimati atu mātou, mōna karakia ko waihotia mai ki runga i a mātou. Ka waihi o mātou pānga whaiaro katoa ki te taha, ka mihi mātou ki te kingi me te inoi atu, mō te arihitanga i roto i o mātou whakaaroarohanga. Kia mohio ai, kia whakaiti ai tā mātou whakahaere i ngā take o te wharenei. Mō te oranga, te maungarongo me te aroha o Aotearoa. Āmene.
Amen. Members, the Honourable Kira McAnulty asked me to rule on the criteria and processes for personal explanations. First, a personal explanation must be personal to the member making it. Standing Orders Speaker's Rulings 152/6 affirm that. Most commonly, they are used to correct misleading statements made by the member or used by a member to defend their honour or reputation. Second, a personal explanation may not be used to attack or criticise other members or persons outside the House. To do so is an abuse of the process. Speaker's Ruling 153/4. Misuse of personal explanations is particularly problematic because it makes it less likely that the House will grant leave for future personal explanations. Speaker's Ruling 152/7. Personal explanations are permitted by agreement of the House. It's my intention that from this point on, members seeking that indulgence from the House will need to give a succinct but clear explanation of why they are seeking the leave, so that the House can make a judgment on that request.
Point of order.
Point of order. The Honourable Kira McAnulty.
Thank you very much, Mr. Speaker. It's clear that that was a considered view, and I appreciate the effort and time that's gone into it. You used the term abuse of that privilege, and you've provided the House with some clear guidance as to how a member should approach seeking leave for a personal explanation in future. Can the House therefore deem from your response that the personal explanation made by the Right Honourable Winston Peters was indeed an abuse of that privilege?
What I would say is that it did not represent the intention of the Speaker's rulings in this matter, would be a better way to put it. And I think the test always has to be, if the House has given someone an opportunity to make a personal statement, and that personal statement doesn't contain anything that might not be said in general debate, then there is no further action required. But the real point is that it is the House's acquiescence that allows someone to make that personal statement, and therefore both not only me but everyone has to be fully understanding what it's about. And I think also this sets grounds for further consideration if there is ongoing abuse of that process. Petitions. A petition has been delivered to the Clerk for presentation.
Petition of New Zealand Nurses Organisation requesting that the House urge the Government to build the new Dunedin Hospital as planned.
Minister, that petition stands referred to the Petitions Committee. Ministers have delivered 3 papers for presentation.
2023-24 annual reports for the Electoral Commission and the Inspector General of Intelligence and Security, statement of performance expectations and statement of intent for Guardians of New Zealand superannuation.
Those papers are published under the authority of the House. A select committee paper has been delivered for presentation.
Report of the Business Committee on the recommended sitting program for 2025.
The report is set down for consideration. No bills have been introduced. A select committee report has been delivered for presentation. Oh, we've got that. Sorry, repeating it again. No bills have been introduced. We come now to oral questions. A point of order.
Point of order, Mr. Speaker.
Point of order. The Honourable Casey Costello.
Mr. Speaker, I seek leave to make a personal explanation to correct a statement I made during question time yesterday.
Leave is sought for that purpose. Is there any objection? There appears to be none.
Mr. Speaker, in response to supplementary questions from Dr Aisha Verrill during question number 6 on 5th of November 2024, I wish to correct the Hansard record which quotes me stating that the document in question was released unredacted.
This is not the case. I was mistaken as an unredacted version was provided to the Speaker. I'm taking the first possible opportunity to correct this and apologise for any confusion to the House.
Come now to oral questions. First, in the name of Ryan Hamilton.
Thank you, Mr. Speaker. My question is to the Minister of Finance and asks, what recent reports has she seen on the economy?
Mr. Speaker, today's Statistics New Zealand released its labour market statistics for the September quarter. This release includes information from the Household Labour Force Survey, which looks at people's labour force status, and the Quarterly Employment Survey, which captures earnings, paid hours and jobs. The Household Labour Force Survey showed that the unemployment rate increased from 4.6 to 4.8% in the quarter. And the Quarterly Employment Survey showed that average hourly earnings increased 3.9% over the previous year.
Supplementary. Why is unemployment rising?
Mr. Speaker, unemployment is rising and has been rising since 2001 because New Zealand has been in a prolonged recession with monetary tightening used to drive high inflation out of the economy. Sadly, recessions have a human cost, and my heart goes out to people who have lost their jobs or who are struggling to enter the labour market. Mr. Speaker, rising unemployment is a reminder of how letting inflation get a grip on the economy is so damaging.
Supplementary.
Just wait till the House quiets itself down. Okay.
Was the increase in the unemployment rate as much as expected?
Mr. Speaker, no. The increase from 4.6% to 4.8% was lower than forecasters had been predicting. In its August monetary policy statement, the Reserve Bank had forecast 5% unemployment, and the Treasury had forecast 5.2% in the budget update in May. To give some historical context, I would also point out to members that over the last 15 years, the average unemployment rate in New Zealand has been 5%.
Supplementary. What is the outlook for unemployment?
Mr. Speaker, today's results reflect where we are in the economic cycle. Typically, when the economy starts underperforming, the unemployment rate is slow to rise. And then when the economy starts to pick up, it can be slow to fall. In other words, unemployment is a lagging indicator. Now, there are clear indications that the economy has turned upwards. But even so, I would expect the unemployment rate to rise a bit further before beginning to fall. In the August monetary policy statement, for example, the Reserve Bank was forecasting the unemployment rate to rise to a peak of 5.4% early next year, then steadily decline.
Question number 2, the Right Honourable Chris Hipkins.
Thank you, Mr. Speaker. To the Prime Minister, does he stand by all of his government statements and actions?
The Prime Minister.
Yes, and especially our efforts to rebuild New Zealand's economy and to support Kiwis with the cost of living. In the last year, wage growth has outpaced the cost of living in the first year of our new government. Compared that to the 13 quarters in a row under Labour, where wages grew slower than inflation. That wage growth comes on top of the cost of living support our government has delivered for Kiwis through tax relief, increases to working for families and family boosts to support Kiwis with the cost of childcare. There's still a lot more to do, which is why we're focused on unleashing investment and clearing away red tape and making sure that we can rebuild the economy and lift incomes for all New Zealanders.
Supplementary. Does he stand by his statement, quote, the government has no plan and never has had plans to amend or revise the treaty or the treaty settlements we have all worked so very hard together to achieve, end quote? If so, how does he reconcile that with the introduction tomorrow of a government bill that completely rewrites the understanding of the treaty upon which those settlements have been based?
In answer to the first part of the question, yes, and as I have explained in this House before, it is government policy to support this bill to first reading. It is also government policy to give parties a free vote at the second reading. The National Party, which I lead, will not be supporting it, and the only way this bill will become law is if the opposition parties do support it.
Supplementary question, Mr. Speaker. Has the government received any advice indicating that the Treaty Principles Bill could undermine the full and final nature of treaty settlements already concluded? If so, what was the nature of that advice?
I haven't seen that advice, but what I would say is that the treaty principles, the treaty is not changing and treaty settlements are not changing.
Supplementary. Why does the government believe the principle of active protection, which places upon the Crown a positive duty to protect Māori interests and taonga, should be extinguished by an Act of Parliament?
Well, again, I think I've been very consistent on this point. Our coalition government has a policy to support this bill at first reading, but the parties are then free to support it or not support it at the second reading. The National Party won't be supporting it, and the only way this bill becomes a law is if the parties on the opposition support it.
The point of order, the Honourable Chris.
Mr. Speaker, the government is introducing a government bill. I'm asking the Prime Minister about the government's policy intention, not what the government's parties may wish to do subsequent to that. By introducing a government piece of legislation, the government, of which the member is still the Prime Minister, as far as I know, is responsible. To say that, oh, well, we're not going to support it later on down the track can't be an acceptable answer when he's being asked a question about a bill that the government is currently introducing.
There are a number of ways you can get into that. It's not for me to start making those sort of judgments. I would ask the Prime Minister to, if he wishes to have another look at it, or ask the question again, actually, so I can make a better assessment of where it's at.
Why does the government believe that the principle of active protection, which places upon the Crown a positive duty to protect Māori interests and taonga, should be extinguished by an Act of Parliament?
Well, it is government policy to support this bill to first reading. That's what we're doing. It is also government policy for the parties in the coalition government to be free to support it or not support it in the second reading.
Mr. Speaker,
point of order.
The Prime Minister has confirmed that the government are supporting the bill as introduced. I am asking him a question about the provisions in the bill, which he has indicated the government is introducing and supporting. I don't think saying that the government supporting a bill that it introduces negates the fact that he should then answer questions on what the bill actually does.
Yeah, I'm just racking my head for a minute, trying to think of previous situations. I can think of one around superannuation way back at the beginning of MMP, where exactly that position was taken and accepted by the arrangements in the House. Point of order, the Honourable Shane Jones, if something new.
Highly likely.
Well, that's yeah, but you've got to be absolutely certain.
Sir, the Prime Minister is clarifying, as other governments have done so, that policy is not static. Policy is dynamic. For the purposes of this bill, the policy will be agreed to the point of introduction. But to suggest that it represents the static form of policy is wrong, and you should have ruled accordingly.
That actually wasn't a point of order. You're giving us a lecture on how Parliament should work. Useful, but not exactly a point of order.
Mr. Speaker, the fact remains that when the government introduces a bill to the House, even if they're indicating that they don't intend to progress it all the way through the process, they still have to answer questions on that bill. The Prime Minister and the Ministers concerned still have an accountability to the House to explain to the House and to answer questions in the House about the effect of the bill if it was passed. Otherwise, why would it be introduced as a government bill? My question to the Prime Minister is about the effect of the legislation. It's not about whether the government intends to support it further or not. It's about the effect of the legislation as being introduced by the government.
Yeah, and what you're highlighting here is, in my opinion, a collision between the MMP style of government that New Zealand now has and the Westminster style of government, which is the mechanism for how government is delivered. But I will ask the Prime Minister to make a further comment on that.
The only comment I'd add is that the bill hasn't been introduced to the Parliament.
Mr. Speaker, when the Treaty Principles Bill states that the rights of Māori, quote, differ from the rights that everyone has a reasonable expectation to enjoy when they are specified in legislation, treaty settlements or other agreements, only when they are specified in legislation, treaty settlements or other agreements with the Crown, end quote, is it the government's intention that the treaty itself fall within the definition of other agreement with the Crown?
The bill has not been lodged.
Point of order, Mr Speaker. That can't be a legitimate explanation. The government has made this decision. There's a cabinet minute of it, which has been publicly released. I've quoted directly from the cabinet minute. It's therefore legitimate for the Prime Minister to be asked and therefore answer the question.
Yeah, that would assume that the bill that's going to be introduced is the same bill. The Honourable Simeon Brown.
Was when the bill says X, the bill has not yet been lodged, and therefore the question was addressed adequately by the Prime Minister.
Yeah, it doesn't fully obfuscate ministerial responsibility. The Honourable David Seymour.
Oh, well, I was just going to say, if the Leader of the Labor Party would like to put his questions to the Minister responsible, I'm right here, but I don't see any questions.
Yeah, good. That's a very kind offer.
Mr Speaker, I wonder whether you could allow me to reword the question, seeing as the Prime Minister refused to answer it.
I will.
Thank you, Mr Speaker. When the Cabinet agreed to the introduction of a bill that states that the rights of Māori differ from the rights that everyone else has a reasonable expectation to enjoy when they are specified, only when they are specified in legislation, treaty settlements or other agreements with the Crown, end quote, was it the government's intention that the treaty itself fall within the definition of other agreement with the Crown?
And as I said in my earlier answers, the first position I'll make is that it is government policy to support this bill to first reading. It is also government policy that parties are free to vote at the second reading. The National Party will not be supporting it, and it won't become law unless the opposition parties do so.
Point of order, Mr Speaker.
I think I can anticipate the point of order, but make it.
I didn't ask him any question about the bill as potentially introduced. I asked him a question about a decision that the Cabinet has taken, the minute of which has now been publicly released, and I asked him about the Cabinet's intention in making that decision.
Does the Prime Minister want to respond to that?
I said it is government policy to support this bill to first reading.
Mr Speaker, I'm happy to repeat the question again.
No, you're not accepting the answer, which is probably a reasonable answer, given that Cabinet would have known at the time that it was supporting the bill that it was not going to get sufficient support to pass. It's not unreasonable. You're asking another question, I think, about whether or not that has implications for the treaty itself.
I'm asking a question about the interpretation of the decision that the Cabinet has just made and agreed to. That decision has been made. There is a Cabinet minute that confirms that decision. Asking the Prime Minister to explain a decision that the Cabinet has already made, that the decision has been, where that is publicly minuted and recorded, is not unreasonable to expect that he will answer that more than just simply saying that it's the government policy to support it.
Well, but that is an answer. And we could go around forever and ever if that is the same question asked and the same answer given.
Well, point of order, Mr Speaker, it cannot be the case that the government can make decisions and then not be willing to answer questions on the impact of the decisions that they have taken. It is their number one accountability to this House to explain the decisions that they have taken as a government. They have taken a decision around particular definitional issues, around what rights of Māori are or aren't under the treaty principles bill that they're going to introduce. And I'm asking him a question specifically about that decision that they have already taken. I didn't ask him about the passage of the bill, didn't ask him about their intentions further down the track. I asked him about the implications of a decision they have already taken.
Ask your question again.
When the Cabinet decided to support in the introduction of a bill that states, quote, that the rights of Māori differ from the rights that everyone else has a reasonable expectation to enjoy only when they are specified in legislation, treaty settlements or other agreements with the Crown, end quote, was it the government's intention that the treaty itself fall within the definition of other agreement with the Crown?
A point of order, the Honourable David Seymour.
Mr Speaker, in the spirit of being helpful to the House, the member is...
No, sorry. Points of order are heard in silence.
It's not that novel concept. The member is quoting the body text of a Cabinet paper, not a recommendation, not a piece of legal drafting, the body text of a cabinet paper. He's actually incorrect to say that that's what the legislation does. And when it is tabled tomorrow, I'm sure he will see that.
Well, that's very interesting. I mean, I think the point is the question has been addressed. Prime Minister might like to say something further. Doesn't want to.
Point of order, Mr. Speaker. The Prime Minister cannot possibly have answered the question. This is quite a significant issue. This is a government piece of legislation. The Prime Minister is the Prime Minister for all government legislation, not just the things that are inconvenient or convenient to him. And he has to be able to answer questions on all decisions the Cabinet has taken. To simply say, oh, well, it's not a decision of Cabinet that we're going to subsequently agree with further down the track, isn't a legitimate answer. This is a decision that's been taken. Asking the Prime Minister to explain it, that is his job.
But it's a simultaneous decision. And look, I don't want to reach for the books and start getting out a number of Speaker's rulings from Speaker Wilson, but the fact of the matter is the question has been addressed, not satisfactorily, and that's acknowledged inside Speaker's rulings, that questions may not always be answered satisfactorily to the satisfaction of the questioner, but that doesn't mean that we go on forever on a particular question line.
Supplementary question. Does he stand by his statement, quote, "We want to work with Māori, we want to be able to partner," end quote? If so, how does that align with the Waitangi Tribunal's view that the bill the government is intending to introduce is, quote, "poorly designed, not informed by consultation with Māori, not justified by robust policy analysis, and risks destroying the very foundation of the constitutional arrangements of this country"?
Well, I would say to that member, we are wanting to work with Māori on some of the biggest challenges and opportunities this country has. You see us doing that with respect to how we're driving immunisation rates for under 2-year-olds, partnering with Māori health organisations to do so. And think about the way that we're working around emergency housing projects, for example. We want to improve outcomes for Māori and non-Māori, and we're going to continue to do that.
Point of order, Mr. Speaker. The Prime Minister appears to have...
Just wait for the House to settle down.
The Prime Minister appears to have selectively ignored the substance of the question, which was a direct quote from the findings of the Waitangi Tribunal, which were released yesterday.
That's right, but there were multiple legs to the question. He's answered one of those which meets the criteria required. The Honourable Shane Jones, point of order.
So we're at the point of the House being brought into disrepute.
Oh.
That question was addressed. It was a comment taken from a recommendatory body. The Prime Minister addressed the question. You just articulated that's the threshold. To continue to relitigate that is to invite us all to break that rule. That can't possibly uphold the standards of the House.
Thank you for your commentary. The Honourable Chris Hipkins.
Mr. Speaker, what message does it send to Māori and non-Māori alike that in the same week the government proposes to bring forward the introduction of a divisive bill that threatens our shared understanding of the nation's founding document, his government is also sacking 40% of the staff working in the agency responsible for supporting Crown Māori relationships?
The member is conflating two separate issues that make no sense. We are making sure that we are delivering outcomes, and we're making sure we get a right-sized public service to do that. What we're not prepared to do is have an 84% increase in spending that drove up inflation, drove up interest rates, put the economy in recession, and then lays off people from work. So we are making sure we deal with the spending. It's not wasteful. We make sure that we're driving down inflation, interest rates, we're running the economy.
Question 3, Tim Costley.
Thank you, sir. To the Minister of Transport, what recent announcements has he made on the State Highway 1 Wellington Improvements Road of National Significance?
Mr. Speaker, yesterday I welcomed the NZTA Board confirming the next steps on the State Highway 1 Wellington Improvements Road of National Significance, which our government campaigned on to enable Wellingtonians to get where they need to go quickly and safely. The expanded package includes a second Mount Victoria tunnel, upgrades to the Basin Reserve, and the addition of a duplicate terrace tunnel that will further boost productivity, reduce travel times for those travelling in their cars and on public transport.
Why is the government prioritising this project as a road of national significance?
Well, Mr Speaker, Wellingtonians face significant congestion at peak times, and forecast population growth across the region is expected to significantly increase travel demand across the network. Without our government's road of national significance, the Wellington region could be looking at travel times increasing by up to 50% between Nauranga and the airport within 10 years. That's why we are prioritising this project for Wellington.
What does this road of national significance mean?
Just wait. The rule of being quiet applies to everyone when a question is being answered. Tim Costley.
Thank you, sir. What does this road of national significance mean for people and freight travelling through the Wellington region?
Well, Mr Speaker, our government is continuing to move at pace to deliver infrastructure that will unlock economic growth, reduce travel times and improve safety. This expanded package in Wellington will result in significant travel time savings during peak times, reducing travel times from the northern suburbs to the CBD, hospital and airport by around 10 minutes to boost productivity and enable Wellingtonians to get where they need to go quickly.
I think these new developments will have for the constituents of the Wellington Central, Rongotai and Oharu electorates, and has he received messages of congratulations from the representatives for those electorates?
Mr Speaker, this project will have significant benefits, both for those driving their vehicles or on public transport in and around Wellington. As I said, up to 10 minutes of travel time savings for those moving between the northern suburbs and the airport. I've heard silence from the other side, but I must say, I did see some welcoming statements from Nicola Willis, making very positive remarks about this project.
Supplementary. Can the Minister tell us how this road of national significance will benefit public transport users?
Well, Mr Speaker, members in this House will be pleased to hear that by grade separating the Basin Reserve, those travelling on the number 1 bus between Island Bay and the railway station are forecast to save 9 minutes during morning peak times on their way to work and school. Additionally, those travelling on the number 2 bus between Miramar and the CBD will notice a saving of 11 minutes on their journeys. Our government is committed to delivering the infrastructure we need to reduce congestion and support economic growth.
Question 4, Tiana Tuiano.
Thank you, Mr Speaker. My question is to the Prime Minister and reads, does he stand by his statement that the treaty is our past, present and future? It has shaped the country we have become, and the obligation it imposes on both sides will always be with us. And if so, why is he supporting a bill that the Waitangi Tribunal findings state if the bill remained on the statute book for a considerable time, it was never repealed, it would mean the end of the treaty?
Yes, in answer to the first part of the question, and as I've said before, we will support the bill at first reading and then we'll vote against it at second reading. And the only reason that bill will remain on the statute book for a considerable time is if the opposition votes for it, because National won't be doing so.
Supplementary. How does he justify his support for the introduction of the Treaty Principles Bill in light of the Waitangi Tribunal's finding that, and I quote, if the bill were to be enacted, it would be the worst, most comprehensive breach of the treaty in modern times?
Well, as I said in my answer, it's not going to be enacted.
Supplementary. Is it not more important for the Prime Minister of Aotearoa, New Zealand, to honour the founding agreement of our nation than to honour a one-term coalition government?
Well, as I've said before, the reality is we are in an MMP environment with a coalition government. That is the reality of it. I'm sure the ACT Party didn't get everything they wanted. The National Party didn't get everything they wanted. We came to a compromise. This is the way that we're handling it. We will support it at first reading, but we're free to support it, not to support it at second reading, and that's what we'll do.
Supplementary.
Just that sort of general barracking just got to stop.
Yeah. Supplementary. How does he respond to the finding of the Waitangi Tribunal that, and I quote, the Treaty Principles Bill would end the treaty partnership and any formal relationship between the Crown and Māori, and could have the impact of undoing everything that has been achieved for Māori in the past 40 years, end quote.
Well, if the opposition parties at second reading vote against it like the National Party will, it won't become law.
Point of order. Point of order.
Point of order, the Right Honourable Chris Hipkins.
Mr Speaker, the Prime Minister has no responsibility whatsoever for how the opposition parties vote, and yet has continued to refer to that in his answers today. He does, as Prime Minister, have responsibility for the decisions that his government has taken. This is another example of a member asking a question of the Prime Minister about decisions that his government has taken, which he has chosen to refer to decisions the opposition might take in his answer. He should answer for the government.
And he has done. He said in a number of times that it is the policy of the government. And the fact that the policy might be to vote for a first reading and not for any more, nonetheless, that is the policy. And the other question that is being asked is covered off, I think, by the problem you've got with the structures we have under MMP, where you form a government for parties that will have different views, make concessions to one another, which mean that there'll be some bills supported some way through the House that may not be supported through the rest. Now, if you want to turn around and say, hang on, you want to turn around and say that somehow I should rule that the provisions of the MMP electoral system do not apply inside this House, that would be an utter nonsense.
No, point of order, Mr Speaker. I'm not arguing that at all. I'm asking you to enforce the rules that say that the government needs to answer questions about decisions it's taken. The Prime Minister's repeatedly said the government has taken a decision to support the bill at first reading. Therefore, asking him to answer questions about the implications of that decision, about a bill that they have indicated they are supporting at first reading, is not asking him in any way to abrogate or to bypass the MMP party system. It's asking him to explain the implications of a decision that they have taken to support.
He did answer in a way that is a speculation about what might happen. He has previously said quite clearly supporting it for the first reading, not any further. That can't be clearer when you're asking about a Waitangi Tribunal position that what would happen if this was on the statute books for a longer time. For the Prime Minister to speculate, the only way that could happen would be if other parties in this House beyond his own and those who've declared a second reading against it voted for it. I don't think it's an unreasonable answer.
It's not answering the question. Supplementary. How does he respond to the finding of the Waitangi Tribunal that at present the progressing of the bill is having serious impacts on the relationship, but the bill, if enacted, would kill that relationship?
As I said, the bill will not be enacted if parties in the opposition vote against it.
Supplementary. Is having a 6-month-long process that risks dividing our nation with the possibility of misinformation thriving a price worth having to maintain his coalition?
Again, we are following process. We are making sure the government policies bill will be supported at first reading. There will be a 6-month select committee process. That is a chance for the public to engage with the process. Then it will come back to this House for a second reading, at which point it will be voted down.
Will the government support a shortened select committee process to save the significant expense that the House will go to in having the bill at select committee for 6 months, given the government has already determined it's going to fail at second reading?
No, but I think it is a bit rich from that member to raise expense when he and that member spent $1.2 billion on Three Waters and it went nowhere.
Question 5, the Honourable Barbara Edmonds.
Tēnā koe te mana whakawā. To the Minister of Finance, does she stand by her statement that, quote, it is a priority to support New Zealanders into work, unquote? If so, how many additional people have become unemployed since she took office?
Mr Speaker,
Nicola Willis.
I stand by my full statement from August, which was an answer to a question from the member. Quote, yes, it is a priority to support New Zealanders into work, and today's unemployment statistic is yet another reminder of how letting inflation get a grip on the economy was so damaging. And that, Mr Speaker, is equally true today, as I said in reply to question 1. To the second point, the number of people unemployed in New Zealand has been rising steadily since 2021. Rising unemployment is not a new phenomenon. Up until the December quarter of 2023, that is the final 2 years of the last government, the number of people unemployed rose by 30,000. Since then, the number has risen by 25,000.
Supplementary. Does her heart go out to the 25,000 additional people since she took office who are now unemployed and where her personal income tax changes will have no effect as they have no job?
Mr Speaker, to the first part of the question, yes. To the second part of the answer, the member is operating under a misapprehension that those unemployed today would stay in unemployment for the rest of the year. In fact, anyone with knowledge of the labour market would tell you that people come in and out of unemployment, and I expect that a large number of New Zealanders who do lose their jobs will then get jobs in which they will be paying lower taxes, so they will have more money in their bank accounts, and that will be a good thing.
Supplementary. Does her heart go out to the agriculture, forestry and fishing sector that is down 12,000 jobs, the manufacturing sector that is down 9,000 jobs, and the construction sector that is down 12,000 jobs since the election?
Yes, Mr Speaker, it absolutely does. And my heart also goes out to every farmer who in these past 6 years had a government that was actively working against them, tying them up in red tape and blaming them for the environmental challenges of our country, rather than thanking them for putting food on the tables, bringing in export receipts and growing this economy.
Ruben Davidson.
Thank you, Mr Speaker. How is she supporting TVNZ workers who have been informed today that their jobs are on the line, the latest local media casualties, in light of zero action by this government to support the local media sector?
Well, Mr Speaker, I reject many of the characterisations in that question. Of course, the employment decisions of TVNZ are operational decisions that are necessarily arm's length from Minister, and I know that members opposite have a bit of a fraught history when it comes to inappropriate interventions in what should be independent matters, but if he wants to rewrite the rule book on that, I invite him to give us his ideas, because they sound like they might be quite silly.
Does her heart go out to Pacific people who face a 9.9% unemployment rate, and in particular Pacific youth aged 15 to 24, where 1 in 4 are now unemployed?
Yes, Mr Speaker, it does, and that is why every day we are working to rebuild this economy, to bring inflation down so interest rates can drop, so businesses can have the confidence to invest and create new jobs, so that we are driving higher education standards, so we can have a more productive economy where more Pacific people have access to good future employment and education, and why, for example, Mr Speaker, we are doing things like introducing fast-track consenting so that we can create more jobs on new developments faster rather than tying up projects in the Environment Court.
Supplementary.
I know it's a Wednesday. Everyone's very excited about all sorts of events happening in other parts of the world. Calm it.
Supplementary. Does her heart go out to the thousands of public servants and government service providers that have lost their jobs as a result of her public service cuts that have been described by one commentator as worse than Ruth Richardson?
Well, Mr Speaker, here's what I'd say to that commentator. In the year of 2024 to 2024, the number of public servants increased by 421. And it is true that the number of public servants has reduced from its peak in December 2023. But, Mr Speaker, I would say this: no government, no country can live beyond its means indefinitely. And if the position of that member remains that the way to restore the strength of this economy is to hire more public servants in the back office, then she should go out and tell New Zealand that, because I tell you this, New Zealanders know better. They want frontline services, they want investment in productive growth, they want services that deliver, and that is demonstrably was not delivered by a government that lived beyond its means, increased the number of public servants, but didn't increase the results they delivered.
Supplementary, Mr Speaker.
Supplementary, the Honourable David Seymour.
Can the Finance Minister relate to Ruth Richardson, who also inherited a set of books from a spendthrift Labor government, along with inflexible labour law initiatives that she had to reform?
Well, there's only one part of that.
Well,
There's only one part of that question was in order, but go back, say something.
Mr Speaker, if I could make a couple of remarks. There's two reflections.
One would be enough, I think.
There is a reflection that I have often had recourse to, which is how difficult it is when people complain about the state of the House after the massive party that they had, the extent of the hangover, and complain about how quickly we're cleaning up the mess.
Point of order. The Right Honourable Winston, Right Honourable... I'm missing him. Right Honourable...
You should withdraw and apologise for that, Mr Speaker.
I do, immediately.
Mr Speaker, how is it possibly in order for that question to be in order and for the Minister of Finance to take a patsy question from a government minister to basically attack the opposition, but the government isn't willing to answer questions for the decision it itself has taken? The government has no responsibility for the previous government, has no responsibility actually for Ruth Richardson, but it does have a responsibility to answer questions about its own decisions, which so far today seems to be refusing to do.
Yeah, except that the question initially asked for a comparison, or what was there a comparison between the former Finance Minister and the current Finance Minister, with suggestion that one was bad and the other was worse. So some response is obviously going to come from that. The question that was asked by David Seymour was, does she relate to the former minister? I said at the time that I thought there was only a very small part of that was in order, and I think we will now move on. Question number 6, Dr. Vanessa Winner.
Thank you, Mr Speaker. My question's for the Minister of Education and asks, what further update can she provide about her Make It Count action plan?
The Honourable Erica Stanford.
Mr Speaker, as part of our action plan, last week I announced a $2.5 million plan to support secondary school students working towards the NCEA literacy and numeracy co-requisite requirements. And I'm pleased to share that from this term, 160 schools from across the country will be involved with up to 10,000 students. And on Monday, I announced our targeted maths program for Year 7 and 8 students. And I'm pleased to share that as of today, 374,521 primary and intermediate school students will benefit from maths workbooks and teacher guides, an increase of almost 5,000 students from yesterday. Mr Speaker, this is so much more than just a stationary update. These high-quality, curriculum-aligned resources will help teachers and lift student achievement.
Supplementary. I realise that the Ministry of Education people who may have given advice on the structure of the question are pretty keen on very long answers, but they're not particularly helpful for the House. Vanessa Winner.
What feedback has she heard from principals on her Make It Count action plan?
Mr Speaker, feedback from schools has been positive. I'm delighted that school principals already want to get involved. One wrote, I would welcome the opportunity to be part of this trial and further develop the knowledge and skills to make a better difference to this cohort of learners. We strongly desire this cohort to enter secondary school with confidence in themselves as learners and set a positive trajectory for future learning.
Supplementary. What feedback has she received from the sector about other elements of the maths action plan?
Mr Speaker, last week I was delighted to release the new maths curriculum, which is a knowledge-rich curriculum and sets out a structured, evidence-informed approach based on the science of learning. And in response, the Education Hub founder, Dr Nina Hood, said, I think the Minister's identified a number of key challenges that we have in the system and is putting in place steps to address those. It's just making sure that you're taught in the way that builds up knowledge sequentially. This government is ensuring that our teachers are supported to deliver lessons that cover what students need to learn and when they need to learn it.
What feedback has she received from education experts?
Mr Speaker, Massey University distinguished Professor Gavin Martin described our newly released math curriculum as a world-class document. He gave a big shout out to this government for all of the hard work, and in particular to our maths curriculum writers, including Audrey Tan. Mr. Speaker, this government has an unrelenting focus on lifting student achievement and closing the equity gap in our education system so all children are equipped with what they need to succeed.
Question number 7, the Honourable Dr Aotearoa.
Thank you, Mr. Speaker. My question is to the Associate Minister of Health and asks, does he agree with Dr Shane Reti when he said, "We are sending out a signal to people with myeloma and the people with leukemia that we understand and we haven't forgotten you"? And if so, what actions has he taken to deliver on that following receipt of the Cancer Control Agency's report titled Understanding Blood Cancer Medicine Availability in Aotearoa, New Zealand?
Mr. Speaker.
The Honourable David Seymour.
In answer to the first part of the question, yes, absolutely. I happen to have known Dr Reti for over 10 years. We're both from Whangarei, where in fact he worked with my mum, and he's one of the kindest and smartest people I know in politics, so I don't doubt for a moment his sincerity when he says that he is there to help people with cancer, as we all should be. In answer to the second part of the question, while the report's publication is relatively recent, this government has initially increased the budget for Pharmac over 4 years by $1.774 billion to fill in a fiscal hole left by the previous government when the member asking the question was the minister responsible. Subsequent to that, we've increased funding by a further $604 million. Now, it's not Dr Reti's responsibility to choose which drugs to buy, or any politician for that matter, but what has happened, and I can tell you, when you go down to Pharmac and you hear from the people there, people work for Pharmac because they love buying medicines for Kiwis, and they are so busy funding new medicines for people with all manner of cancers, and I hope that soon they will fund more medicines for people with blood cancers.
Supplementary. Will he assure blood cancer patients that all 9 medicines identified in the report as offering significant clinical benefits but currently unfunded, or their equivalent, can be funded from the extra investment in Pharmac that he just cited?
Mr. Speaker, the member knows very well, because she's had this job, that if a minister is able to ensure that a particular medicine will be funded, then Pharmac is not actually independent. Therefore, I can't stand here and say that Pharmac will fund a particular medicine, but what I can say is that they have never had more money to fund medicines in the history of this country. The amount of money that's going into it is exceptional, and it's already having its effects felt by people battling cancer up and down this country.
Cancer. Supplementary. Why didn't the government run a process that would have given these patients with blood cancer an equal shot at the funding to patients with solid tumours when, after all, Dr Shane Reti knew about this issue before the election?
Mr. Speaker, that is precisely what the government has done. Pharmac do not discriminate. Their goal is to secure for eligible persons maximum medical benefit from the available funding that has been dramatically increased under this government. And let me just say it one more time for that member, in case she's forgotten anything or didn't know when she was the Minister of Health herself. The biggest difference that a Minister of Health or a government or a Minister of Finance or a minister responsible for Pharmac can do is provide more money for the people at Pharmac to buy more medicines for Kiwis. And on that simple measure, it is not just 1-0, it's 1,000,000-0.
The Honourable Shane Reti.
Thank you.
Hang on,
Can the member confirm that up to 4 blood cancer medicines have recently been funded by Pharmac?
Mr. Speaker, yes, I most certainly can. And that is an example of the decisions that Pharmac is making in order to ensure the money is put to the best possible use. It benefits people with solid tumours, it benefits people with blood cancers, but it also benefits people, for example, with type 1 diabetes who now have continuous glucose monitors funded by the taxpayer through Pharmac. Right across the board, this government is improving the access to medicines at a level never before seen in this country.
Supplementary. In light of his previous answers, am I to take it that people with blood cancers do not have an assurance that their cancer medicines will be funded, but solid tumour patients do? Or do solid tumours also have no assurance that they will be funded under this initiative?
Mr. Speaker, I think it's fairly straightforward. This government is very clear that Pharmac makes the decisions about which medicines to fund. We make the decisions about how much funding they receive. And the member knows this. What the government has done is ensure, in line with...
Just stop there. We hear the rest of this in absolute silence.
Thank you, Mr. Speaker. This is a very serious matter for a lot of New Zealanders, as I'm sure nearly every member of this House who's known someone with cancer will know. As I was saying, what the government has done in line with pre-election commitments is provide funding that will allow a list of drugs or their equivalents to be funded. That commitment has been undertaken. From now on, we do everything we can to increase the amount of funding for Pharmac in order that more medicines can be bought. And for example, I'm happy to tell the House that I have asked Pharmac to be active and aggressive in showing how they, by funding more medicines, can save money right across all of society to boost the Pharmac budget even further than the current record levels, in order that more people with all types of ailments, including blood cancer, will have more chance of seeing their medicine funded sooner.
Supplementary, the Honourable Nicola Willis.
Can the Minister confirm that Pharmac's ability to deliver more cancer drugs to New Zealand cancer patients would have been made even harder if this government had allowed the time-limited shortfall in Pharmac funding, the fiscal cliff left by the previous government, to endure?
Mr. Speaker, I remember very well meeting with that minister, our Minister of Finance, and our meeting was scheduled to be about that shortfall. We knew that if we did nothing and carried on with the previous government's funding track, we would go from around $1.5 billion per year to about $1.1 billion per year. The advice I'd received from Pharmac was that Pharmac would first decide
everyone
that
seems to have forgotten we're listening to the rest of this question in silence.
Some medicines and some indications, they would have to stop new patients getting those medicines. If that didn't save enough money to make up for the previous government's forecast budgeted shortfall, then they would have to actually take people off medications. Someone thinks it's funny to heckle. I can tell that young member that actually medications for people and people losing their medications when they are often terminally ill is a very serious matter. If you wouldn't mind listening, that'd be helpful. Mr. Speaker, we recognise that Pharmac would actually stop people receiving medicines they were already prescribed. That was the advice. So Nicola Willis and I, our Finance Minister, looked at each other at the start of the meeting and we said, we've just got to do it. And that was basically the end of the meeting.
Supplementary.
Just wait for the silence that is going to be across the House to the duration of this question.
Has Shane Reti broken his promise to blood cancer patients that they will not be forgotten, when it is actually true that they are an afterthought in this policy?
Mr. Speaker, all I'm going to say to that is that there is a line in opposition politics between advocating and exploiting somebody, and I think what that member just did crossed that line.
Question number 8, Rauri Waititi.
Tēnā koe te piko o tira tēnā tātou I te whare. Ko taku pātai ki te Premier, my question is to the Prime Minister.
Rauri, Mr Waititi, we'll just wait for the House to gather itself a minute. Okay, now you're right.
Tēnā koe I te pika. Ko taku pātai ki te pirimia. My question is to the Prime Minister, does he stand by all his government's statements and actions?
Yes.
Does he believe his coalition agreement with ACT has more mana and integrity than Te Tiriti or Waitangi?
As I've explained, we are in a coalition government. We are supporting as a government this bill to first reading, and beyond that, it'll be up to each individual party as to whether it ultimately goes through and becomes law.
Point of order. The question was, does he believe his agreement with ACT has more mana and integrity than Te Tiriti or Waitangi? I didn't hear him address or even answer remotely close to that question.
Well, you could also argue that he's got no particular responsibility for asserting mana to one document or the other. The Prime Minister might like to make another comment on it.
I'm very clear that the Treaty of Waitangi has obligations on both Crown and iwi, and we will continue to uphold those under law.
How can tangata whenua and tangata treaty voters have confidence in a Prime Minister who is willing to sponsor a select committee process which will become a platform for racism and misinformation, given the findings of the Waitangi Tribunal? The Māori-Crown relationship has already been damaged and would be further damaged, including by the select committee process, which we fear could become a platform for racism and misinformation that would prejudice Māori.
They can have confidence because they've got a government that's here to advance outcomes for Māori and non-Māori. And what I'd say to you is that when we have 12% of Māori students at year 8, thank you, Labor government, we have a plan to deal with that. When we can move 1,500 children, many of them Māori, out of emergency housing accommodation in motels into permanent, proper homes, that's great. That's a fantastic outcome. It's better than what that government did for 6 years with an absolute majority for the last 3 and did so very little. It's fantastic that we are working incredibly well with Māori health organisations to improve immunisation rates for under 2-year-olds. That's about outcomes and getting things done for Māori and non-Māori.
Just make the comment that personal reflections aren't provided for. In fact, they're specifically provided against in standing orders, whether they are by way of interjection or in debate. Members need to remember that.
Supplementary. How can he sleep at night knowing that the violence of the Treaty Principles Bill is going to have a discriminatory intergenerational impact on our mokopuna?
I disagree with the characterisation of that question.
How many apologies is the state willing to make while they continue to inflict violence and abuse on our people whilst continuously breaching Te Tiriti or Waitangi?
Again, I disagree with the characterisation of that statement. This is a government that is here to advance and improve outcomes for Māori. And the sad reality is that under the previous administration, despite a much vaunted Māori caucus, very little was achieved for Māori. That's true.
How can he stand in this House and support a bill which the Waitangi Tribunal has described as, quote, the worst, let me emphasise, the worst, most comprehensive breach of the treaty, Te Tiriti, in modern time, end quote?
We're not supporting the bill in second reading.
Question number 9, Todd Stevenson.
Thank you, Mr. Speaker. My question is to the Associate Minister of Health and asks, what recent announcements has he seen about new funding for medicines in New Zealand?
Mr. Speaker, thank you very much for the question. A great many. In particular, the $1.774 billion boosts in the budget this year, followed by a further $600 million over the next 4 years to expand access. That means that the total budget over 4 years is $6.294 billion, or nearly $1.6 billion a year, averaged over the 4 years. This is far more than has been spent by Pharmac on medicines in history. In fact, it's about 60% more than the billion or so that it was only a few short years ago. At present, there are 11 cancer medicines being funded, 9 that are having feedback considered, for a total of 20. 21 non-cancer medicines in total, either funded, being considered or consulted on, for a total of 41 medicines that are now being either funded, considered feedback or consulted on as a result of that funding uplift.
Yeah, I just point out the question did ask about recent announcements. It's fair enough, but perhaps don't need to recite the entire announcement in the answer. Todd Stevenson.
Supplementary. Has he seen any specific announcements to respond to the shortages of asteroids?
Mr. Speaker, I just thought it was my duty to be candid to the House, but I can be briefer if you'd like. In terms of estradiol, this has been a major pain point for women up and down New Zealand. Due to recent developments in research around the relationships between hormone replacement theory and breast cancer, global demand has nearly tripled for hormone replacement therapies. This has led to a worldwide shortage, and one that has affected New Zealand women as well. However, I'm proud to say that Pharmac has been agile and really quite active in getting out and finding supply, as well as getting new medicines funded in order to alleviate the shortage. As of the 1st of November, estradiol gel, a topical hormone treatment, is now funded, and it's estimated that 18,000 women will benefit from it in the first year. I'm well aware of the stress that this has caused from the correspondence I've received. However, I'm pleased to say that this problem is at least some way to being resolved thanks to the actions of Pharmac.
Supplementary. Has he seen any announcements that will support cancer patients?
Mr. Speaker, yes, I most certainly have, and I referred to them earlier. What I would say is that right across the world, the rate of progress in creating new treatments for cancer is truly astonishing. As someone who believes soundly in science, I am hesitant to describe it as a miracle, but what is presently happening and the number of cancer treatments coming online could be described as that if anything was to be. And this government's commitment is to keep finding ways to fund more and more of them to increase New Zealanders' survivability.
Question number 10, the Honourable Ginny Anderson.
Thank you, Mr. Speaker. My question is to the Minister of Police. Does he stand by the statement in his 20 September 2024 letter to the Chair of the Regulations Review Committee regarding the Arms Shooting Club's content of annual reports, Amendment Regulations 2024, quote, "I am comfortable that this technical change would not have negatively impacted public safety." And does he heed police advice on public safety?
Mr. Speaker.
The Honourable Mark Mitchell.
Yes, as I said in the letter, the purpose of the amendment regulations was to remove unnecessary administrative requirements for non-pistol clubs, which are largely run by volunteers. When clubs struggle to adhere to overly burdensome requirements, they run the risk of closure. Because the safe use and education about firearms in controlled environments like ranges is beneficial to public safety, it is important that regulations are workable for volunteer organisations so that this resource can remain available to the community. I would note that the government has only made 2 changes to firearms law and regulations in New Zealand. This regulation change, which is one of those, the other being strengthening the firearms prohibition orders regime to keep guns out of the hands of gang members. Police did not provide me public safety advice specifically in relation to this administrative regulation change, but did provide advice that the firearms prohibition orders being strengthened would have significant public safety benefits.
Why did he disregard police advice provided to him on the 6th of June on the proposed changes to shooting clubs that made numerous references to the public safety risks associated with reducing the reporting obligations on shooting clubs?
Well, Mr. Speaker, I made a decision to make a small technical change that Cabinet supported. That meant that ranges, the requirements for reporting was not duplicated, that it removes some of the burden to these voluntary organisations, because we want these ranges to remain open, because we want people to have safe spaces where they learn firearms safety, and that is done at ranges.
Supplementary. Why did he tell Parliament on 19 September that gang members were not using gun ranges to practice their shooting skills when police advised him twice, on the 30th of April and again on the 22nd of July, specifically of that risk?
Because gang members have not been getting access to gun ranges to practice with firearms.
His answer to oral question 9 on 19 September, or the 2 briefings released under the Official Information Act in April and July from police. If it is the latter, will he correct his answer in Parliament?
What is accurate is that I've had no advice from police to say that gang members are using gang ranges to practice with firearms.
Point of order, Mr Speaker.
Point of order to the Anderson.
I seek leave to table a document received under the Official Information Act that is not publicly available, that stipulates police advising the Minister of Police that there is a risk and that gang members are using gun ranges to practice their shooting skills.
Okay, why is that not publicly available?
It was received under the Official Information Act and provided to me.
It hasn't been released anywhere else?
No.
Leaver's thoughts or any objection? Can I just say, that last question seemed a long way from the primary. Anyway.
Supplementary. Why did he support proposals to weaken police inspection powers over gun ranges when police had clearly advised him of the risks of unlicensed shooters, such as gang members, being allowed on gun ranges by licensed firearm owners?
Mr Speaker, I'll reiterate again that the change that was made in the regulation was minor in nature, it was technical, and it was to remove some of the burden on our volunteers that are actually running these ranges. And the reason why we did it quickly is because they were coming up to AGM season, and we wanted to have confidence that these ranges remained open, because there is a big public safety issue around making sure that they do have access, people do have access to these ranges. Otherwise, what happens is you run the risk of whether it be that people start looking for alternative locations that aren't registered ranges, and that actually increases the risk to the public.
Supplementary question, the Honourable Colin McKee.
Is the Minister confident that by supporting clubs and ranges, we are supporting safer communities?
Absolutely. I mean, the reality of it is, and many of the members' colleagues use ranges, is that they are the safe place to use firearms. That is where firearms safety is delivered. It is where firearms use is monitored. And the best thing that we can do around public safety is ensuring that these ranges, which are largely run by volunteers, they're given the support they need to keep those open.
Why is he risking public safety and the safety of frontline police officers by enabling a gun lobbyist to weaken our firearms regulations when he has been specifically advised by police that gang members are using gun ranges?
Well, I find it a bit rich for a previous police minister who oversaw some of the worst violence and growth in violence that we've seen in our country. And I will stand by our reputation any day in terms of prioritising public safety and doing everything that we can to continue to make sure that we increase public safety.
We've got it, Mark.
A point of order, the Honourable Shane Jones.
I'd ask that you reflect in the context of Speaker's rulings 190, 191 and 192 about the tenor of a host of the questions today. It is permissible in supplementary questions for people to draw on reports or take quotes. But we've had a plethora today of quotes taken grossly out of context in terms of the Treaty of Waitangi, quite apart from the inflammatory language that comes from that report. That's a matter for the authors of that Waitangi Tribunal report, but there are standards and there are parameters, sir, around how quotes and how statements and how reports are to be treated in the House. To avoid that brings the House into disrepute, and we are bordering perilously close to that today.
Speaker, the point of order, the Right Honourable Chris Hipkins.
Can I congratulate Shane Jones on reading one page of the standing orders and encourage him to read the entirety of the standing orders, because then he would find that that point of order itself violated a number of them.
No, I don't think that's a fair comment. I think if members of the House look at Speaker's Rulings 1913 and 1921, they'll get a fairly good guide on how quotations should be used. In the end, these are matters for the House and they have not been ruled out. Question 11, Ricardo Mendes-March.
Thank you, Mr. Speaker. My question is to the Minister of Health. Is he concerned about the impacts of poor access to dental care as outlined in this week's report from Dental for All? If so, what steps, if any, is he taking to reduce the cost of dental care?
Mr. Speaker.
The Honourable Shane Reti.
Yes, we know that good oral health is important for the wider health of New Zealanders. Currently, free dental care is provided to children and adolescents until the age of 18. There is also funding in place to support adults on low incomes. It's a long-standing issue that needs very careful consideration. However, as outlined in the Government policy statement, the importance of ensuring primary and community healthcare services, including oral health services, are responsive to need remains a priority.
What does he say to almost half of New Zealanders who put off going to the dentist because of cost, when he was unable to name a single initiative he has taken to reduce the cost of dental treatment?
Mr. Speaker, this government has spent $250 million approximately on oral health as a proportion of Vote Health. We're also committed to increasing community fluoridation, which will provide community benefits. We also provide support for the toothpaste to toothbrush program, which provides care to vulnerable populations and also to whānau of those vulnerable populations.
Will he take any actions to lower the cost of dental care, or will he allow families to go without being able to afford getting basic health care as a result of cost?
Mr. Speaker, vulnerable families have access to low-cost access dental care, including recent increases 2022, as I recall, to the emergency dental grant, which I believe is now called the Special Needs Dental Grant, for immediate and essential treatment.
Does he think low-income communities should go into debt to access dental care, or should dental care actually be part of the public healthcare system and be made free?
Mr. Speaker, I've already expressed that low-income and vulnerable families have access to dental care, but of course we'd like to do more.
Does he think the current for-profit private model that prevents people from accessing dental care when they need it is fit for purpose in Aotearoa?
What I think is that if we improve the economy, we'll then have the ability to provide a wider range of health services.
Question number 12, Joseph Mooney.
Thank you, Mr. Speaker. My question is to the Minister for Building and Construction. What recent announcements has the government made about building and construction?
The Honourable Chris Pink.
Thank you, Sir. Among other things, we've recently announced the basis of a self-certification regime. The context is that we're also looking to crack down on incompetent, careless and unethical builders. But we know, Sir, that in order to reform the building construction sector to support more affordable homes and a stronger economy, we know that at the same time we need to provide more streamlined processes for those who are worthy of that trust.
Supplementary. Why does the current system need reform?
Mr. Speaker, it currently takes on average 569 days for a home to be built and consented. Amid a housing shortage that has persisted for some time, that is simply too long to wait. Currently, a single-storey home of standard dimensions might feature some 10 to 15 separate inspections. The resources of the building control system would be better spent mitigating more significant risk elsewhere.
Supplementary. Who will be eligible to self-certify their own building work?
Mr. Speaker, the scheme will undergo a robust consultation process, but there are two key pillars that will feature. The first is at the individual tradesperson level, such that plumbers and drain layers will be able to self-certify their own work in the same way that electricians and gas fitters already currently can. The industry has been calling for this for years. And the second pillar is that businesses with a proven track record, which I admit, Sir, we do need to define carefully. For example, home builders who build hundreds of similar homes every year will be able to enjoy a more streamlined consent process.
Supplementary. What feedback has he received on these proposals?
Mr. Speaker, the feedback from the sector has largely been very positive. I do actually also want to acknowledge a constructive approach across the political aisle. We've enjoyed cautious support in principle, and I do want to acknowledge that, and also a willingness to engage on the details, so we will be doing that. So within the sector, Greg Wallace of Master Plumbers has been advocating for self-certification for his members for 4 years, and Kit Sharma of Master Builders, the CEO, points out that this will enable his organisation's members to build more affordably and efficiently. And Aidan Jury from Jenny and Homes highlights the time factor as being critical to build, including as to costs. So we're determined to make these changes for the benefit of all Kiwi consumers.
Great, Minister. That's, well, one more.
Supplementary.
Oh, sorry. You might have guessed I'm in a hurry to leave.
Thank you, Mr. Speaker.
Arena Williams.
How many tens of thousands of builders need to lose their jobs before he announces that the building sector is in crisis, given today's confirmation that 12,000 jobs are gone under his watch, but according to him, things are fine?
Mr. Speaker, I've never pretended that the situation we inherited from that side of the House when they were in government was anything like fine. We did inherit a crisis. We are moving quickly to address that in a way that will reflect great safety, affordability and sustainability of our housing.
That does conclude oral questions.
Live coverage from the House of Representatives will resume at 7:30 p.m. An uncorrected transcript of today's oral questions is available at www.parliament.nz.
The House is resumed. Members, we're on the second reading of the Corrections Victim Protection Amendment Bill. Cameron Brewer.
Thank you, Mr. Speaker. It gives me great pleasure to be able to support the second reading of our good colleague Rima Narkle's Members' Bill here, the Corrections Victim Protection Amendment Bill. And in short, just to recap, Tom Rutherford, because it has been a week or two, this bill would amend the Corrections Act by creating an obligation on the Chief Executive and prison managers to protect victims from unwanted contact. And frankly, Mr. Speaker, this is the right sponsor for the right bill. It's one of those scenarios, because there's no stronger advocate for victims than Rima Narkle. And it might be, the Narkle family have got a great reputation in South Auckland for the support that your in-laws have given the likes of Sir Barry Curtis in building Manukau City in Takanini. And Rima and Roger live in the heart of Takanini. They've also got considerable experience with transitional and emergency housing. And so we salute you, Rima. Not only are you a West Sydney University lawyer, Sydney sider that's over here, but you've got that on-the-ground experience as well. And so it's great that you've been able to pick up this bill and develop it further. And as we've said, and I think it's a favourite term of James Meagher's. Is he here? James Meagher, can't comment, but it codifies what the Corrections Management CEO and others are expected to do in the protection of victims. As you've seen here, we looked at it as to how effective it would be and whether it was doable across those 26,000 people doing community services, doing services in the community service. 26,000. 9,500 serving custodial sentences, 26,000 in the community on community-based sentences, orders or parole. And Corrections said that will be difficult. That will be difficult to maintain, to protect those victims all the time with the correspondence and phone calls, unwanted correspondence and phone calls from prisoners. But Ms Narkle, as is reported in the report back, Mr Speaker, requested, and she made it explicit, that she requested that the relevant agencies continue to monitor the safeguards available to serve the protection of victims where offenders are serving community-based sentences, orders and parole. And so she's codified, through you, Mr Speaker, the sponsor, Rima Narkle, MP for Takanini, has codified that requirement for not just custodial sentences for chief executives and prison managers to manage the correspondence and the likes of phone calls between prisoners and their victims, but also those that are serving beyond the walls of the prison in community-based sentences, orders and parole. And so this is a big part of our government agenda, I'd like to think, Mr Speaker, where we are refocusing the justice system to being victim-centric, if you like. And as I said, there's no one more that fights harder for victims' rights and ensuring victims' rights are upheld than our colleague Rima Narkle. And in fact, I would argue, Mr Speaker, that it sits in with our public service target, the government's public service target number 4. And I know Tom Rutherford recites most nights the 9 public service targets. And I might even give my colleague from Northcote here the opportunity to recite public service target number 4. But he might miss out a word or two. So I'll give it to you. The public service target, the government target, Mr Speaker, number 4, is that we are working already, with the help of this too, to ensure 20,000 fewer victims of serious assault, robbery and sexual assault. And so that is the overall public service target when it comes to reducing the number of victims. And it's, again, part of the government's agenda on cracking down on law and order, whether that's serious assaults, youth offending, retail crime, cracking down on burglaries and robberies. And so, Mr Speaker, this bill has come a long way, and the member through the Justice Committee, and the member has been very, very compliant, if you like, with new ideas, with ideas from officials and from the opposition and from the chair and from her colleagues as to how we can make this workable. And actually, like a lot of legislation, it is about, and private members' bills in particular, it is about sometimes codifying what might arguably be in practice in part. But we legislate for the ability to ensure that it can be achieved, and that there is a responsibility on the Chief Executive of Corrections and those prison managers to protect those victims and for a process to be in place. The proposed new section 77.5a would require corrections to take into account the interests of victims, in particular being free from unwanted contact, when deciding what conditions to impose on prisoners regarding the likes of outgoing telephone calls, says the report back from the Justice Committee. The committee has also recommended amending Clause 4, a new section, to place a different obligation on the Chief Executive. They would be required, the Chief Executive would be required, Mr Speaker, to establish and maintain processes to inform visitors of prisoners and recipients of prisoner communications about measures they can take if they do not want to be contacted by a prisoner. And we think that the committee, in the end, the Justice Committee concluded in its report back, page 2, that we think this approach would support victims to control what contact they receive from prisoners and make clear the other side, control for victims, but also make clear the department's obligations to victims. And look, this is not to diminish all the good work that the corrections staff do up and down the country, the thousands of them. This is not to, they are doing their best to protect the victims of crime all the time. But this is just to put in practice, as a private member's bill, to codify the responsibilities on the Chief Executive and prison managers and the expectations that victims can have too. And so they can go back to the statute, they can seek advice and say, what are my actual rights here? Where do I stand with this unwanted communication? And it will all be explicitly written down in statute and passed through the third reading as in a matter of days, if not weeks, Mr Speaker. And so we're very happy to support this second reading. I commend the sponsor of the bill, Rima Narkley, for the work that she has done across the committee, across the political aisle, to knock this into shape, and so it's actually workable. And initially, corrections kind of said, oh, geez, this is going to be hard. But through your persistence and doggedness and just commitment to getting it through and protecting victims, we're now getting to a piece of legislation that's going to pass its second reading tonight and head towards third reading. And as I said, codifies the responsibilities on prison managers and the corrections chief of staff when it comes to protecting victims with unwanted correspondence or phone calls of the likes by prisoners. At the same time, it also identifies that massive section of those people that have offended and are serving sentences in the community. 26,000 people, the size of a small New Zealand city, are people serving community-based services, sentences, orders, or on parole. And so this protects those victims, gives some protection to those victims and expectations around extra protection around where the corrections management and chief executive can step in and for the interest of victims' interests. So I commend the bill, and I look forward to the third reading. Thank you, sir.
The 5-minute split call, Reuben Davidson.
And it's a pleasure to rise and take a call on the Corrections Victim Protection Amendment Bill. And the previous speaker referred to there being 26,000 sentences in our community. It felt like his speech went for 26,000 sentences on that matter as well. But I would like to acknowledge, as did the previous speaker, the work of Remedies on bringing this bill to the House, and I had the pleasure of a tour through Australia with Remedies, and I can say that name because that's the name we said every morning when we were about to get in the van, and we would go, "Where's Rema? Where's Remedies?" So my experience is that she's not the most punctual on the trip, but if you want poetry, Rema is the person to go to. On a more serious note,
what happens on the trip, Mr. Davison?
Victims of crime deserve to feel safe and supported. I think we all believe that. We all believe that. And I think we can be very, very proud, I am very, very proud of Labour's history in this area, of ensuring that victims of crime feel safe and feel supported. And I think also proud of Labour's work to create a justice system that serves all New Zealanders. And we do play the blame game in this House. It's a lame game, but it's a game that gets played, where we in opposition get blamed for all manner of things by this current government. So I thought I'd just give you 3 things you can add to that list. You can add to that list that you can blame us for the largest ever financial commitment for victims. We'll happily take the blame for that. To 93,000 more people being able to access legal aid, we'll happily take the blame for that. And for banning the ability to charge interest on legal aid debt, we will also happily take the blame for that. So please, feel free to blame us for that anytime you like in this House. But coming back to the central point, which is that victims of crime deserve to feel safe and supported. And victims of crime often have ongoing fears, valid ongoing fears, for their safety and for their security. And to this bill's credit, it will go some way to protect victims from further contact and from future contact, and from the unwanted contact or communication from prisoners or from people who have perpetrated those crimes against them. So if we believe that victims of crime deserve to feel safe and supported, and we do, I believe, all believe that, then we would support the actions of this bill. But that's not without some reservations and without some other points that I think we need to stop and take note of. Because whilst we support this bill, I think it's important to also put on the record the cuts that will negatively impact victims of crime. Section 27 reports, which were a pathway for victims to get their views into the courtroom, have been cut. You chose to cut that. 6.5% cut to the Crown Law Office, a choice that was made which erodes the resource available to the victims of crime. And it doesn't stop there. There are further cuts made to the Department of Corrections, to the Ministry of Justice, to police. So if we truly all believe that victims of crime deserve to feel safe and supported, if we truly all believe that, none of us would be doing that. None of us would be making those cuts, would be carving those resources, those people, those support networks out of our justice system. But that is what's happened. So whilst I can stand and speak in support of this bill, and give you some insight to what life on the road with Remanakle is like. What I can't do is say that we should lose sight of the cuts that have been made and of the very real impacts that will have across New Zealand.
Paulo Garcia.
Mr. Speaker, I stand in support of the Correction Victim Protection Amendment Bill on its second reading. I am privileged to be a part of the Justice Select Committee under a super hard-working chair, and of course our colleagues Cameron Brewer and Remanakle, who has been determined and persistent in her position of concern for victims of crime. And that is such an amazing determination and focus. Mr. Speaker, the amendment bill aims to protect victims of crime and people under protection orders from unwanted contact by prisoners. It amends the Correction Act 2004 in establishing an obligation on the Chief Executive of Corrections to implement processes to protect victims from unwanted contacts. It's Section 8 that is amended, ensuring that processes are established and maintained to inform visitors, victims of prisoners, and recipients of prisoner contact that they have the opportunity to request measures that they can use to ensure that they do not receive unwanted contact by a prisoner. In deciding what these conditions are to be imposed and ensuring that no unwanted contact is placed upon victims, the Chief Executive and also the Commissioner of Police places the victim and the interests of victim, their well-being in the forefront of these imposed conditions. Mr. Speaker, it is actually the amendment bill is actually a very simple and pragmatic way to ensure that victims are not re-victimized by a persistent intimidation through contact that they receive from prisoners. And the correction system is well aware of the many instances where prisoners have continued to intimidate and instill fear in their victims and in the victims' families through contact, repeated contact. And while one would assume that this is not happening or shouldn't be happening, it does happen quite a lot. So, Mr. Speaker, I'd like to mention the many instances where prisoners have contacted victims over 93 times, over 100 times, over 102 times. And these are prisoners who have committed grievous injury on their victims, many times physical injuries like rape. They have beaten victims intentionally with extreme brutality. It is these prisoners themselves who have sought ways around the non-contact system and through other prisoners that they may know, or through their own ways, have continued to contact the victims, intimidating them and making them want to change whatever positions they may have if there is a prosecution still ongoing. The amendment bill, Mr. Speaker, also provides for a new for a new offense for people to continue to try and breach the contact prohibition. I commend this bill to the House.
Nicely, Paulo. Well done. Well done.
The Honourable Ginny Anderson.
Thank you very much, Mr. Speaker. It's good to stand in support of this bill. What this bill does is to create an obligation on the Chief Executive, on prison managers in order to protect the rights of victims and also those who are subject to a protection order and victims of crime. So that they can't be contacted by prisoners. I think it is important to note that while we support this bill, when you are creating or when a piece of legislation is creating an obligation on the Chief Executive, as a policy analyst in a former life, you always want to ask the question whether legislation is necessary in order to do that. And so there is a little bit of a question for me as to whether we need a bill in order to create an obligation on a Chief Executive. That would be something potentially a Minister of the Crown would be able to do without a bill. Nevertheless, it's got a good intent in it, and that it initially it wanted to do quite a lot. It was going to be operationally difficult to implement because it would have also included monitoring the communications of people on community-based sentences, which is 26,000 potentially, and on parole. So that would have been a huge effort. So the committee worked quite constructively together in order to make it workable. Corrections staff were great. They worked quite closely with the committee in ways that we could practically make this work in the way of the intent of the member who has carried it forward. So the Select Committee requested that the relevant agencies continue to monitor the safeguards that are practically available and proposed a range of amendments which have been specified. So we've introduced a new offence of making unwanted conduct by amending section 128 to make it an offence against prison discipline for a prisoner to contact someone who the prisoner knows or reasonably ought to know does not want to be contacted, and the Act provides a range of punishments for prisoners who are found guilty of that offence against prison discipline. It's got good intent. It continues to make sure that victims' rights are looked after, and I commend it to the House.
Tom Rutherford.
Thank you very much, Mr. Speaker, and it gives me great pleasure to speak as the final speaker on the second reading of the Corrections Victim Protection Amendment Bill in the name of my great friend Rima Narkley, as well canvassed previously by, she represents Takanini, and as regarded to by my colleague Cameron Brewer from Upper Harbour. He sort of heaped the praise on Rima for her advocacy for those who are victims of crime, those who have experienced crime, whether firsthand or in support of family members or friends. And for me, Mr. Speaker, it's disappointing to know that we've allowed for this to happen for so long, that there's been a loophole and it's taking this piece of legislation to amend it. And I commend my colleague for picking up the baton from the Minister, Louise Upston. But I'm disappointed also that, we've had to come to this place to do it. But I'm pleased that we're doing it. But that we have allowed for something like this to happen in New Zealand. And I had a read through around some examples. One stood out to me, 2016, a man severely beat his victim for 15 minutes, breaking 5 ribs, fracturing their spine, and causing severe internal injuries. But sadly, the story didn't end there. While they were in custody awaiting trial, that offender made 102 phone calls to the victim. 102 phone calls, pressuring that person to simply not testify in court against them. Now imagine how that makes you feel as the victim of that crime. Experiencing the crime itself is bad enough, let alone being re-traumatised again and again and again by the exact person who committed that crime against you. And for many victims, going through the court process is intimidating enough as it is, let alone to have that contact from the person who committed those crimes against you is just disgusting. It's absolutely disgusting. And I think and just reading on, when the person didn't quite get through that the 102 phone calls weren't working, what did they do? Manipulated the system. They got another inmate to add the victim's number to their approved phone call list to continue the harassment. So it wasn't just bad enough for the offender to do it themselves, but they now got old mate from the cell next door to be the one to then start ringing that victim as well and harassing them. And that's not an isolated incident. It's not an isolated incident. We've seen cases of pedophiles writing to their victims from behind bars. We've seen prisoners orchestrating stalking through third parties. And each of these cases simply represents a fundamental failure of our justice system to protect those who have already suffered enough. Number one in this country, we put the victims first. They have experienced enough, yet we've created a loophole that allows them to be contacted and harassed by those that have committed the crime against them. And so I'm pleased that we are fixing this loophole, because it's simply going to mean a massive amount of change for those who most need that support they possibly can. And then I read through. Ruth Money, prominent victim advocate, said it perfectly when she stated, and I quote, that everybody was always shocked to learn that this was possible. She called it, quote, beyond belief, and that this detail hasn't been addressed before now. And then the Justice Committee, I read through the report they've prepared after considering it through the Select Committee process. I wasn't fortunate enough to listen to the submissions. My colleague Rima Narkley told me there were 12 submissions on it, probably all genuinely heartfelt. Probably some people who were first-hand victims themselves and sharing their experiences and sharing why changing this legislation is so important. But the committee carefully considered how to make the bill both effective and practical. The initial draft, and my colleague Rima and I were just talking about it before, would have initially covered about the 26,000 people under the corrections supervision, and including those beyond the corrections facilities themselves, out in the community. But based on the operational advice that the Select Committee received, they agreed to redefine the legislation. And so they brought it back from that initial 26,000 to about 9,500 who are held in correction facilities as prisoners. And that ensures that the bill can effectively be implemented with current resources. Yeah. And then I had a look through and I saw some of the recommendations and amendments that were made by the Justice Select Committee, and I thought, hey, they're making some really reasoned arguments and points here. Clause 4 of the bill, as introduced, would introduce a new Section 8.1 into the Act. This would place an obligation on the Chief Executive to establish and maintain processes that would protect victims and protect persons from unwanted contact from any person under the control or supervision. I thought, it makes sense. It's an amended aspect to the responsibility of the Chief Executive. And then I thought, Mr. Speaker, and I listened to Reuben Davidson's contribution previously where he spoke in support of the legislation, but he talked about cuts here and cuts there. And I thought back to Budget 2024. And I thought about the funding we as a government have put into the corrections space. Don't forget the $1.9 billion in new funding to deliver 810 extra beds, deliver new frontline staff, increase pay for corrections employees, and extend rehabilitation programs for prisoners. It's really disappointing to be heckled from across the House from the Honourable David Parker when this is actually a really serious moment. And he goes, let's talk about Dunedin Hospital. Let's talk about Dunedin Hospital. Well, do you know what, Mr. Parker? I actually want to talk about the victims who are affected by this legislation. I want to talk about those victims who have had first-hand experience of violent crime in New Zealand, and now we're fixing the loophole. And you want to talk about Dunedin Hospital. Well, why don't you actually remember about those victims in New Zealand who have experienced first-hand violent crime and are now being harassed by those prisoners in jail who committed the crime and are now harassing the victims every single day. 102 phone calls one victim received. 102 phone calls, and he continues to heckle. 102 phone calls that victim received, and yet he's heckling and saying, let's talk about Dunedin Hospital, let's talk about Dunedin Hospital. Do you know what, Mr. Parker? I'm talking about the 102 phone calls that victim received and were harassed by the offender who committed those crimes against them. And Mr. Speaker, it's really disappointing. It's really disappointing that has to happen. But do you know what? My colleague Cameron Brewer spoke earlier, and he talked about the 9 public service targets. And there's one in particular that I'm really focused on, and it's about our commitment to reduce 20,000 victims of violent crime. 20,000 fewer victims of violent crime by 2029. And reducing serious young offending by 15%. And I see my colleague Karen Shaw in the House, Minister, leading that work around giving those children and young people another opportunity at life. So not saying that we're just going to give up on you. We're giving you a second shot at life, and we're going to put some investment into you so we know you can turn your life around and you can make better decisions moving forward rather than putting them in the too hard basket. And so I just think that's fantastic. But Mr. Speaker, as I come to the conclusion, I really want to reiterate that all these measures around what we're doing in the law and order space, banning gang patches, young military-style academies, everything else under the front line of bringing in more frontline police officers, we can't protect victims. It means little, if we can't protect victims from offenders behind bars. It means nothing. It doesn't stand for anything if we can't protect those who have been the victims of crime. Prison should mean safety and peace of mind for our victims in New Zealand. It should mean safety and peace of mind, not continued harassment and intimidation. And this bill represents a return to common sense in our justice system. It puts victims first. It closes a loophole that should have never existed. And most importantly, it sends a really clear message. We will no longer tolerate a justice system that allows offenders to continue victimising people from behind bars, and I commend this bill to the House.
The question is that the motion be agreed to. Those of that opinion will say aye. To the contrary, no. The ayes have it.
Corrections, Victim Protection Amendment Bill, second reading.
This bill is set down for committee stage next sitting day. Call on members, order of the day number 3.
Giving evidence of family violence amendment bill, first reading.
Dr. Tracy McClellan.
I move that the giving evidence of family violence amendment bill be now read a first time. I nominate the Justice Committee to consider the bill. Mr. Speaker, the Family Court now sees a large number of parties alleging family harm and domestic violence, including sexual violence. This harm and this violence is seen, for example, in protection order hearings and in Care of Children Act hearings. So, Mr. Speaker, this bill is a straightforward yet an important means by which to achieve 2 fundamental aims. The first aim is to protect vulnerable people who appear in family court, and the second aim is to improve the quality of evidence given at family court. And it does so by adding a presumption in favour of using alternative ways of giving evidence in family court. For instance, using audio-visual link or CCTV to avoid an open courtroom, which means evidence in chief and cross-examination could be recorded beforehand, or the ability to use screens to prevent direct visual contact. I note for members that these alternative ways are automatically available for witnesses in criminal proceedings, but there is no statutory presumption in the family court. The alternative ways exist in criminal proceedings, as they should in family court, fundamentally to reduce the stress on victims and to reduce the stress on witnesses. I'd like to take a step back and provide some background to show why these measures are important, and in doing so, I'd like to acknowledge and reference Dr. Emily Henderson, who is the author of this bill, a passionate academic advocate for improvements in the justice and family court settings, and an experienced practitioner with many years' service in to the family court. When I spoke to Dr. Henderson and asked her more about the impetus of this bill, she said, as a starting point, trying to get lawyers to use alternatives in the family court isn't always easy. People don't know what they don't know, but creating a presumption should make things easier. And Mr. Speaker, this is what this bill does. We then went on to talk about how New Zealand had become one of the first countries in 1989, if I remember correctly, to enact some, or at least a couple, of the innovations from what was a large international conference the year before. But since then, the dial hadn't really moved much to protect vulnerable people. And courtrooms in the family court are typically smaller, they are less formal by design, they are often in a room with one long set of benches on the same level, and they are like that specifically to remove formality. They typically have less physical distancing between parties and between witnesses. So I think it's fair to say that family courtrooms are designed for people who are at loggerheads. And while that might be the case for some proceedings, the majority of cases that make it to family court are about interpersonal violence, not dispute resolution. In reality, it is the top tier of intractable issues being heard, often involving violence of all sorts, and parties are there because all else has failed. The civil parties, as seen in family court, are often doubly vulnerable because they not only give evidence, but they also must take the lead role in prosecuting or defending their cases and instructing their own counsel rather than having the protection of a prosecutor leading the case. So in this setting, in this physical environment, and under these circumstances, that very informality found in family court can actually be very intimidating, and protections are needed to help alleviate fear and stress and to help remove barriers to ensure that witnesses simply don't fold because they were too scared to tell their stories, to give their evidence. Mr. Speaker, this bill amends Section 107 of the Evidence Act 2006 to extend the range of possible protections for parties and witnesses giving evidence of sexual assault or family harm in the family court to mirror those available to similarly vulnerable complainants and witnesses in criminal proceedings. Existing protections in criminal proceedings include automatic entitlement for children witnesses to give evidence in alternative ways instead of more stressful normal methods. Sections 15 and Section 16 of the Sexual Violence Legislation Act 2021 will also amend the Evidence Act 2006, extending that presumption as found in criminal proceedings to sexual case complainants, sexual case propensity witnesses, and to adult family harm complainants. It should also be noted that in certain narrow circumstances, the witnesses can choose to, or the judge can order the witness to give their evidence in an ordinary way. But the presumption in favour of alternative ways of giving evidence is an important protection for this particular very vulnerable group. It prompts judges and lawyers to actually use the tools that we know work well to level the playing field, to limit the intimidation that we know happens on a daily basis, and to protect these parties while they are giving evidence. So, Mr. Speaker, in conclusion, this bill represents a simple legislative change, but an important one. I thank Dr. Emily Henderson for being so passionate about this issue and for drafting this bill. I, in her stead, will look forward, hopefully, to progressing this through the House, and I invite members across the House to support these protections and to vote for this bill.
The question is the motion be agreed. James Meagher.
Thank you, Mr. Speaker. Can I begin tonight's contribution just by acknowledging Dr. McClellan for her work and good fortune in having this bill drawn from the ballot. I know it's taken a while to get here. We've been through many members' days where the members probably sat waiting, hoping that it would pop up, and finally it's arrived. So congratulations. I know that you had a members' bill go through earlier this year and didn't quite get that one across the line, but we're hopeful for this one. Mr. Speaker, I know the member has nominated the Justice Committee for consideration of this bill. We gladly accept that nomination and look forward to considering Bill number 24 for this committee. And I understand Greg Fleming may be tempted to seek leave to rush through the rest of the bills tonight to get his bill to the Justice Committee as well, but I'm sure that there'll be objections to that across the House. Mr. Speaker, I won't leave the member hanging. The National Party will be supporting this bill through to Select Committee so that it can have some robust discussion and consideration. And while we do broadly support the policy intentions behind the bill, there are some fishhooks that we do want to carefully consider when it comes to looking at the traditional way that we uphold rights in the justice system in New Zealand and in the Westminster system of justice, and how this bill may impact them. But Mr. Speaker, this legislation does represent a potential step forward in protecting our most vulnerable New Zealanders, and we just had the passage of the second reading of a bill focused on protecting victims, and that's exactly what this bill intends on doing as well. It intends on ensuring our justice system better serves those affected by family violence. Mr. Speaker, this bill does affect the giving of evidence in the family court, and the family court, of course, deals with some of the most sensitive and challenging cases in our justice system. Every day in that court, everyday New Zealanders must stand before the court to recount traumatic experiences of family violence, and not only do they do so as witnesses, but often as parties who must take an active role in their own cases, instructing counsel and prosecuting or defending their positions. This double burden places immense stress on those who have already endured significant trauma. And currently, while the family court technically has access to these alternative ways of giving evidence, the protections we have found are very rarely used. And this bill seeks to change that by creating a presumption in favour of the alternative evidence-giving methods, mirroring those protections already available in the criminal courts and the wider justice system. Mr. Speaker, I wanted to talk about a number of reasons why we believe the bill should proceed through to Select Committee for consideration. First of all, one of those issues is the current challenges that we have in the family court. The physical environment of our family court does present some challenges. Typically, those courtrooms are smaller and less formal than criminal courts, with minimal physical distance between parties, often parties who are intimately connected with one another. And for someone who has experienced family violence, being in proximity to their alleged abuser can be quite traumatic in those settings and overwhelming. And there, of course, is a possibility that those environments can significantly impact the quality of evidence being given when you are confronted with someone so close to you. The second thing is that this legislation will hopefully align practice with what happens currently in the criminal courts as well. Under Section, I believe, 107 of the Evidence Act, child witnesses in criminal proceedings are automatically entitled to give evidence in alternative ways. So this is a logical and perhaps necessary step to extend these same protections to the family court, where those victims of family violence are often required to give evidence in even more challenging circumstances. Mr. Speaker, I understand the bill includes several procedural safeguards. Parties must give 28 days notice of their intention to use alternative ways of giving evidence. Other parties can apply for a direction that evidence be given in an ordinary way, and judges always retain the discretion to make appropriate directions based on the interests of justice. And we believe that the legislation will deliver 4 key benefits overall to the justice system. First, we believe it will improve the quality of evidence provided to the court. As I mentioned before, the stress of giving evidence before those in close proximity who you are very, very intimately related to can affect things like memory recall and how you express yourself in court. And so alternative methods can help those witnesses provide clearer, more effective evidence. Secondly, we believe it will increase access to justice. Many victims currently hesitate to seek family court intervention out of fear of facing their abuser. So these provisions providing extra protections may encourage more people to seek the court's protection and to come forward. Thirdly, we understand and believe there will be efficiency gains for the courts. Where witnesses are less traumatised, proceedings go more smoothly, there are fewer interruptions, fewer issues benefiting all court users. And fourthly, as mentioned by the previous speaker, we understand there will be better outcomes for children in this case. For all cases involving children, these provisions can help ensure their voices are heard while minimising the potential trauma. Mr. Speaker, at the top of my speech, I indicated that there were some potential negative consequences that we are aware of on this side and will be interested in looking into in this select committee. First of all, one of those is around administrative and resource requirements. This does add an additional element technology-wise into the court system. The 28-day notice requirement for alternative methods could delay proceedings. The courts will need to invest in the appropriate technical equipment and training. Additional staff may be needed, and remote testimony in smaller courthouses may struggle to provide the appropriate facilities. So those are things during the select committee process that we hope to be able to tease out and try and mitigate and minimise any impact. Secondly, there may be some additional procedural complexities as we introduce new ways of operating in the family courts. The process of applying for and contesting these alternative evidence methods could lengthen proceedings. Managing the technical equipment during hearings could disrupt the court flow. And remote testimony may complicate cross-examination and the assessment of witness credibility. Thirdly, the bill does impact the rights of respondents under our justice system. And before Duncan Webb quite rudely interrupts my speech and accuses me of reading
point of order.
Speech.
I don't mean to rudely interrupt Mr. Meagher's speech, but you seem to have mistaken the time clock, Mr. Speaker, because under Appendix A, members' bills have 5 minutes for the second speech. That's what I'm reading on Appendix A of Standing Orders.
No, the first two are 10 minutes in a...
I've got some...
Sorry. Yeah, sorry, we'll just go, we'll take the clock back a minute. We'll give the member another minute. Thanks, Mr. Clark.
I'll just regather my thoughts on where I was, Mr. Speaker. No, look, I'll start right from the top. It's a pleasure to be speaking on Tracy McClelland's members' bill. No, look, there are some important rights issues to be considered in this. The bill does change and amend some of the procedures around giving evidence, which may impact on a respondent's right to be heard and to face their accuser. And so, of course, changing the way we practice in the courts will result in a reduced ability to directly confront accusations. It could affect the defence rights. Video evidence might not capture some of those important non-verbal cues that judges and counsel pick up on. You've got technical issues which could impact the ability and the effectiveness of cross-examination of defence counsel. And of course, remote testimony might, of course, affect the respondent's ability to instruct counsel during proceedings. So those are some of the potential issues that we will be looking into in the Select Committee in terms of affecting the rights of the respondents. But of course, our focus in this bill and in supporting this bill is to maintain concentration at all times on victims of crime and on the ability for victims to access justice, not only the respondents. Finally, Mr. Speaker, in the 2 odd minutes I have remaining, unless there are further suggestions from members as to how I should deliver the speech, there are some practical implementation challenges. And as someone who comes from a rural and regional electorate, I can envisage some challenges for people giving testimony remotely, whether that's access to the technology, whether that's access to the connectivity, whether that's the need to travel somewhere that has those facilities. The ability to roll this out across the country will be something that we'll look into in the committee, and some of the resource constraints. And also, what do you do when those technical failures do exist for some of those areas? What are the backup options available for victims of crime in rural and regional New Zealand? And I know many of my colleagues will be interested in that, given how many rural and regional electorates they do take charge over. Mr. Speaker, the clock appears to be increasing in time the longer I speak, so I'm not entirely sure what happens here. Very good, okay, I've had the moment. Well, then I will go to some of the other challenges that may well exist in this bill as some of the professional practice requirements. Of course, lawyers who practice in the family court will need to adjust their practice. If you practice predominantly in the family court, you may not be as familiar with cross-examination of remote testimony and remote cross-examination. New skills may need to be required for managing client interactions. And of course, different approaches may need to be taken in order to prepare witnesses. So there are some potential challenges in that area. And then of course, you've got issues around client confidentiality and how the court can be assured that those giving testimony remotely are doing so without coercion and without undue influence in the room as well. Something that you can control when you are in person in court, but something which is a little bit harder to control when you are doing so remotely. And finally, Mr. Speaker, just in terms of our friends in the judiciary, the family court judges, there may need to be some increased training for managing the technology. There may be increased complexity in managing hearings, doing things remotely. As chair of a committee which manages a number of hearings mixed by Zoom and in person, I can imagine some of the issues that might face some judges when faced with technological issues. And of course, there is the potential for misuse of these processes by nefarious actors, in particular people who are upset about being brought before the family court and want to use some of these processes as a way to harass or as leverage against their victims. And of course, we have other legislation that has been seen to deal with litigant abuse, which may go some way to dealing with those issues too. So, Mr. Speaker, in conclusion, this side of the House, and I think all members in the House, are committed to protecting vulnerable New Zealanders. This bill acknowledges that the way we gather evidence can be improved in a way which balances the rights of victims and access to justice with those rights of the defendants, the respondents, and rights to fair trial. Family violence casts a long shadow over our society, and I'm hopeful that many members in this House will support the bill, at least through to Select Committee, so we can give it a thorough examination. I congratulate the member and I commend the bill to the House.
As such an infrequent speaker in the House, I thought you might appreciate that extra minute, Mr. Meager.
Mr. Speaker.
Ricardo Menendez-Marsh.
Thank you, Mr. Speaker. Can I begin by congratulating and acknowledging the member to my right, Tracy McClellan, for her work and for bringing this bill to the House. I think a debate on this issue is really long overdue, and I just want to acknowledge that I think everybody here will stand up and acknowledge that we want to prevent family and sexual violence from happening. But I think at the core, it's about the actions that we take to protect survivors and to work to address the drivers that lead to family and sexual violence in the first place. And I think, to me, members' bills that have practical effect and improve the ability for survivors to be able to go through the justice system in a way that honours their experiences are one of the more practical. It's a really good and practical way we can take those visions and values on board. I also want to acknowledge that what this bill aims to do is to support the use of alternative methods for presenting evidence, such as video recordings or other accommodations in the family court. And I think it's worth noting, and I know others have acknowledged, that these provisions in theory exist, but they're so infrequently used that in and of itself acts as a deterrent. And so having, by establishing this presumption, we're basically breaking down barriers for survivors to be able to have other means of presenting evidence in a way that also acknowledges their own experiences. I think in a way that also, for example, acknowledges diversity that exists in our communities. For people who, for example, English is their second language, for disabled people, having these alternative methods is a really important way of breaking down the barrier for a really fulsome participation through the family court, and in a way that decreases the risk of further harm, and in a way that doesn't deter people from participating through these proceedings. I want to acknowledge that this bill won't exist within a vacuum, and I wanted to make it to the Honourable Marama Davidson, our co-leader, for her work in establishing Te Aurere Kura, and that Te Aurere Kura in and of itself will exist as part of an ecosystem that aims to eliminate sexual and family violence and to put the means of preventing it across all government agencies. And it was highlighted by the Chief Victims Advisor that our current adversarial system often leaves victims and survivors without true justice, perpetuating a cycle of winners and losers. And I think, to me, this bill will help address some of that in terms of breaking down that adversarial nature of our justice system, and one that is actually about healing and it ends up being one about healing and ensuring that we don't perpetuate cycles of violence as our carceral system often tends to do. I also wanted to touch on some of the remarks from the National Party, particularly the concerns that they noted around the admin requirements and resource requirements that they presented as, I guess, issues of concerns and needing further evaluation. I want to remind those members that at the end of the day, they hold the power to resource those entities adequately so that those things do not actually become barriers to having this bill becoming law and it functioning it. And that resourcing the courts to ensure that we can address these potential concerns is a worthwhile investment to make. And so I don't want their own austerity politics to be barriers to actually having these alternative methods of presenting evidence from working in practice, because we should not set this bill up to fail by preempting potential resource constraints when actually we've got a government that is very much choosing to give millions and millions of dollars in tax breaks to landlords, to tobacco companies, and therefore, when they speak of these resource constraints, we've got to put it in the context of the broader government objectives. So we look forward to evaluating this bill at the Select Committee stage. No doubt our members in the Justice Select Committee will will do due diligence and receive the voices of submitters with care, and I do expect that we will be hearing from people who will have really, really delicate stories to tell, and I just want to uphold the mana of future submitters, because those voices will be critical when it comes to ensuring that we have something that works for survivors and honours those experiences in a system that so far hasn't uplifted them. So once again, I commend the member for bringing this bill to the House for us to debate, and I hope that it goes through all stages in a way that honours the voices of our broader communities.
Todd Stevenson.
Thank you, Mr. Speaker. Dr. Webb will be happy to know I only get 5 minutes, so I was hoping it would be longer, but it won't be. But again, I also rise to speak on behalf of ACT on the giving evidence of family violence amendment bill brought to the House by Dr. Tracy McClellan. And I do want to also add my congratulations on having this bill drawn, Dr. McClellan, and having it hopefully considered by the Justice Committee. Well, ACT is going to support it, so I think there's a good chance it's going to be supported by the Justice Committee. I'm going to talk about the bill in a second, but I just also, talking a lot about victims tonight, and it's actually very timely. Actually, during the dinner break, myself and my colleague, the Minister, Karen Chua, and my other colleague, Laura Truss, popped down actually to the opening of the Men in Trauma New Zealand's new office here in Wellington, and they're a specialty service that actually deal really with men who are often victims of sexual assault, and also they're dealing with suicide prevention. And it was really a timely reminder that we do need to do more to protect victims, and also address people who are victims and help them actually get on with their lives and heal. And again, I think this bill, we carefully considered at the ACT caucus, and we looked at it, and we do think it's worthy of going to a select committee and having a discussion, because it does actually put in place a presumption that does support victims. And I think, again, Dr. McClellan mentioned the actual author of the bill, Emily Henderson, and again want to just acknowledge her work, as I know Dr. McClellan would, in actually getting this bill into shape and bringing it before the House. On this side of the House, in an ACT, we actually do think about victims' rights and also how vulnerable people are going to have to give evidence within our justice system. And as has been spoken about tonight, the family court does try to be a bit more informal, but it is still a court. There are still formal processes, and it can actually still be quite intimidating. It is set up in a particular way. And so I think, again, as Dr. McClellan talked about, when things get to the family court, they are usually very difficult, indetractable issues. I know from my own short experience of practicing at the bar that family court cases I was involved in were extremely difficult ones, where the parties had been going at it for years and years. And in fact, in the case I was involved in, the mother had gone on the run and would refuse to come to court. So these are the kinds of very difficult situations we're dealing with. And I think, Dr. McClellan tonight pointed out that you are then adding in the process and the drama and the setup of a court. So I think putting in place the types of measures that this bill does around being able to give evidence in different ways through AVL, video, and changing the presumption, I think is a sensible one, definitely worthy of discussion. And I think it does align with some of the things that this government is trying to do. I want to assure Mr Mendes-Marsh that obviously we are investing in new things in the court. Again, recently the Justice Select Committee looked at audio-visual links and how we're going to use new technology. So again, while there have been some concern raised, those are things that the government is actively working on, and hopefully that new technology and new ways of doing things will be able to be utilised by the changes that Dr McClellan's talking about here in this bill. So I think there's some things that can tie together. I also want to say I think we've worked very constructively in the Justice Select Committee on members' bills. We have some tensions around some of the other many pieces of legislation that are coming through our committee, but I do think on members' bills we are a very constructive committee. We're willing to have a constructive discussion, and I think we can get this bill into a shape that will be worthy of a further discussion in this House. So I do want to thank the member for getting this in front of us, for actually thinking about victims and how we can actually accommodate their needs in the family court in these extremely difficult situations, and moving this forward. So ACT will be supporting this, and I commend it to the House. Thank you.
The Honourable Casey Costello.
Rise on behalf of New Zealand First to speak on the giving evidence of family violence amendment bill, and I would like to acknowledge Dr Tracy McLennan for her work bringing this bill to the House. New Zealand First will be also supporting this bill through the first reading, but we do so with some considerations that have already been reflected in the House today. The process of a family court is often a very sensitive and volatile situation, and we acknowledge that there is sensitivities that need to be addressed, but I think we also need to consider the basic fundamentals of a system that requires us to be able to test the veracity of information, to be able to understand the nuances of the information that's being provided. And the concern is that we rush too quickly to creating these additional steps without looking at the ways in which we can fix and modify the existing systems to afford the protections. The fact is that the family court is not always victim and offender. The fact is that we are dealing with broken families and bad situations on all sides. And so when we enter into a court process, it's very hard to say that there is cleanly and clearly one victim and one offender in those situations. Yes, there are vulnerable people, and we absolutely need to ensure there's some protections, but I still think that we need to be careful that we're not rushing down a path to put systems in place when we're just not fixing the existing environment. And we've talked a lot about the courtroom environment, particularly for the family court, being smaller, more intimate. But that is for a purpose, and there is a purpose that we have a less formal environment so that we can have very full and frank discussions, that we can open up and look each other in the eye and talk about things and hopefully come to some clear resolutions. So this is the part that New Zealand First has some considerations that we want to ensure that we're balancing protection with justice, and that we're not overruling the fact that perhaps sometimes the information exchanged needs to be tested and it needs to be challenged. And I think that there is opportunity to look at alternative solutions, and we've talked a lot about these things, that we need to ensure there's protections. But if the system is failing and not protecting people who are vulnerable, then perhaps we need to look at the way we're allowing these situations. And we've talked already that criteria to allow alternative evidence exists, but it's not being applied. And rushing to legislation sometimes seems to be a quick fix, which doesn't necessarily end up being the quick fix we hoped it would be. We've touched on the idea that when you have these 28-day notification periods, that we have these extra technologies, we've got to consider all of the courtrooms around this country, and we've got to consider the resources available in all those courtrooms. And contrary to public opinion, there isn't a magic money bucket that we can just start throwing money at every new initiative that we have. So we have to really be careful about what we're putting in place and the expectations we're creating. And that maybe sometimes we need to work with the resources we've got and make sure the courts are applying what already exists and doing it well before we rush to legislation. In no means are we saying that there isn't perhaps necessity for some further protections to be put in place, but I hope that through the Select Committee process we fully test the expectations of what we're putting in place here, that we fully test that we're not allowing a broken system to remain broken and putting in additional steps because we're not got the energy or motivation or understanding to fix a broken system. So I hope that we don't end up with an unintended consequence that we have a less fair system, that we recognise that the family court are delicate situations, that there's not always the offender and the victim, that there's not always a good guy and a bad guy, that sometimes it's just a broken family who needs to sit in a room together and work out how they're going to move forward and how they're going to put systems in place to protect everyone. So I do commend the bill to the House, and I hope that the Talented Justice Select Committee will work through all of those issues. Thank you.
Maria Mino Kapakingi.
Kia ora, Mr. Speaker. Kia ora tātou e te katoa. E tautoko ana mātou te pāti ki tēnei whakaaro in saying that, supporting this bill and this idea, the idea behind it. So mihi atu ana kia koe, Tracy. Mihi atu ana kia Emily. So mohe no tērā wahine, ka mahitahi māui ki a whāngarei, a me wana whānau katoa, so mihi atu ana ki aia. It doesn't surprise me at all, her work with you, to bring this to this point. So I'll mention that to her when I see her next. I'm taking this call on behalf of the party to speak in support. The sad reality, though, Mr. Speaker, is that 58% of wahine Māori are affected by family violence over a lifetime. So that's kind of one of me, you know. And there is a lot of there's a lot of reasons why those sorts of things happen. But I want to make that comment because as well as being the victims of harm, there is also a number growing that are the solutions of their own liberation, Mr. Speaker. So too many have been in harm's way and have been affected and find themselves in front of family courts. And unfortunately, we know that that does not work well generally for all, and particularly for wahine Māori. Wahine Māori are more likely to experience the forms of assault than anyone else in Aotearoa. We are also the least likely to seek justice. This is not just due to inherent discrimination in our justice system, but because of how difficult it can be to navigate it. Currently, people who experience family violence in Aotearoa are treated differently by our justice system, depending on where they turn for help. The same special protections that are guaranteed to victims in the criminal justice system are not guaranteed in the family court. These protections include being able to pre-record evidence and testify remotely. While the family court can apply these protections, its actual rate that they do is not so. This makes seeking justice an intimidating prospect for a lot of wahine and their families and other victims of domestic abuse, whether it is the fear of repercussion, not wanting to go through the criminal system, not wanting to see the perpetrator or the abuser sitting in front of you, how to deal with all of that emotion when you're sitting in such a place like a courtroom. We need to eliminate all barriers to justice and extend protections to everyone who needs them. It shouldn't matter which door you knock on to seek help. You should be entitled to safe and consistent support wherever you are and wherever you need it from. Whānau Ora, Madam Speaker, is one of those places where it is a for Māori, by Māori, designed with a kaupapa Māori beginnings and ends and everything in the middle of it. Unfortunately, that's not getting the support that it needs to. But that's a very, very good and evidenced so way to support Māori, wahine Māori that are in situations with having to be in court. And unfortunately, that's not going to be the case in the next 12 months. This bill is a good step towards improving the system and the problems that I've outlined. But I recognise that a lot more needs to be done to protect our whānau from violence, from whakamā, and from repercussions when seeking justice. Māori didn't sign the treaty so we could end up in this state, Madam Speaker. So there's a lot of work to do, and I look forward to the 19th when this whole place will be receiving many, many Māori, wahine Māori, children, whānau, hapu, iwi, to come and show their disappointment at what's going on in the House. But Tracy, to you in this bill, good for you. We tautoko, kia ora tātou.
Point of order, Honourable Erica Stanford.
Thank you, Madam Speaker. I seek leave to make a personal explanation to correct an answer to an oral question on the 22nd of October.
Leave is sought for that purpose. Is there any objection? There is not. Honourable Erica Stanford.
On the 22nd of October in question time, I stated that the Ministry of Education had advised me that it considered it was acting outside its appropriation for school transport assistance and that as a result the Ministry may be in breach of the Public Finance Act. What I should have said is that the Ministry had advised me that by not undertaking its planned route reviews could put it in breach of the requirements of the Public Finance Act. The Ministry has today clarified for me that because they are currently undertaking route reviews that they are acting within the appropriation.
Thank you. Honourable Ginny Anderson.
Thank you very much, Madam Chair. It's a pleasure to take a call on the giving evidence of family violence amendment bill in the name of Tracy McClellan. I'd like to commend Tracy on bringing this bill to the House, which is a good bill, and it's encouraging to see that it's receiving support from across the House. That's always good when we can agree on things. First, I would like to acknowledge the work of Dr. Emily Henderson, who was a former member of the Justice Committee in the previous 53rd Parliament. Emily, as already mentioned, was a staunch advocate for improving our justice system and an active local MP in Whangarei. It was through her that we paid a visit to the Whangarei sexual violence trial court there, which was made permanent in 2019 under the previous government, both in Whangarei and Auckland. And this is another example of where we can look at our court processes to make sure we get better outcomes, not only for victims, but for justice as well. So this is a great bill that seeks to, I guess, make our courts more receptive to families and some of the trauma they're experiencing when going through them. So existing protections in the criminal proceedings include automatic entitlement for child witnesses to give evidence in alternative ways instead of more stressful normal methods of being on the cross-examination stand. Extending that presumption as found in criminal proceedings to sexual case complaints, sexual case propensity witnesses, and to adult family harm complaints. So while the same protections that are automatically available for witnesses in criminal proceedings are technically available in the family court, that often in practice does not happen at all. And so this bill adds a presumption in favour of alternative ways of giving evidence in those cases in order to reduce the stress on victims and witnesses and to increase the quality of evidence that are given in our courts. And if we can increase the quality of evidence, then it is easier for court cases to play out. If it's a clear case then and a prosecution is able to result, then that is a quicker way of proceeding through the system without further traumatising people by being re-traumatised, re-victimised through the justice process itself. Some of the findings of the evaluation of the trial sexual violence court using different ways of cross-examining showed that victims were less traumatised at the end of the case and that better outcomes were made. I truly hope that the same outcomes can be made through this piece of legislation. We know, Madam Speaker, that courtrooms in the family court, as has been mentioned, are typically less formal and smaller, with little physical distancing between parties. They can be very close to each other. This increases the stress on victims and witnesses, and it can be really hard for children, particularly in a marriage separation where mum and dad or both their parents are in the same room and things are heated and children are present or even giving evidence in those situations. Having the ability for someone to be in a separate area to give evidence that's done through video, that's able to minimise the impact on people who are young or vulnerable, has got to be a good thing for our justice system. It is important that there is clear carriage of justice and there's a way of making sure that we do that well, but that does not have to be at the expense of victims and victims being re-traumatised. We also, I'd like to wind up, Madam Speaker, is that we've done a lot of work, as already mentioned, on making sure that family violence and also victims' rights are strengthened. We want to keep that work going by having good bills like this proceeding. I welcome it to the Justice Committee and I really look forward to the submissions we receive, particularly in this area when we get submissions from families who have been through the family court. That is a really informative way of our committee getting first-hand experience of where we can improve the system. And we know from previous bills on this area that the family court has got a lot of improvements that can be made. Hopefully this bill will be one of those things to improve experiences of people going through our family court. I commend the bill to the House.
Reminato.
Thank you very much. Madam Speaker, I too rise in support of this members' bill that we consider here today. The first reading, Madam Speaker, of the Giving Evidence of Family Violence Amendment Bill. It's a members' bill in the name of Dr. Tracy McClellan. And I feel privileged that I get to sit on the Justice Select Committee opposite Dr. Tracy, who often has quite deep and insightful additions to make to the conversations that we have when we're considering the now 24, well, this is the 24th bill that has come or will come before the Justice Select Committee. Very, very ably chaired by my friend and colleague, James Meagher. Now, this bill was introduced into the House, Madam Speaker, on the 5th of March 2024, this year. And as mentioned earlier, it was drafted by former Member of Parliament for the Labour Party, Dr. Emily Henderson. This bill seeks to amend the Principal Act of the Evidence Act 2006. That's the Principal Act in this regard, Madam Speaker. And essentially, if we were to put it in a nutshell, it aims to make it easier and safer for victims of family violence to provide evidence in court. Now, when we talk about victims and when we talk about victims' rights, it's interesting what Dr. Tracy mentioned in her speech earlier tonight on this bill. She said, we want to ensure that victims that witnesses rather don't fold. And I found that quite compelling, that comment that Dr. Tracy made, because my mind drifted back to when I was studying law in Sydney and simultaneously working in the local courts arena over there. And I recall very vividly many a time when witnesses nearly did fold because of the fear of giving evidence in the face, in the presence of the perpetrator, the alleged perpetrator of the crimes against them. And that's why, Dr. Tracy, those words that you said really struck me and resonated as to why bills like this are so important. We need to consider the witnesses who are the victims, but we're also mindful, and I feel that James made this point quite comprehensively, as he usually does, that we have to be mindful of the rights of the other party as well. And this other party is the defendant. So we're looking at how do we balance these rights, the rights of the victims vis-a-vis the rights of the defendants. And my mind went back to another situation, Madam Speaker, when I worked in the courts, where I realised that the officer in charge of a case had disappeared from court for quite some time. So I went outside to look for her to see if she's okay. And I found her telling witnesses that hadn't been in court yet what to say in light of what she had heard said in the courtroom, because the doors were closed to witnesses that hadn't come in yet. And I found that quite disturbing, and I went and informed the magistrate, and the magistrate had to shut down the court straight away, that courtroom, and indeed I was later on cross-examined by a police prosecutor as to what I saw, because that was an interference in the course of justice. And I am very honoured to hear my colleagues say that they find me to be someone that stands up for the rights of victims, but I don't forget about this right of people that have not been convicted yet. And this is the balance that I'm sure we will strike in the Justice Select Committee as this bill goes towards submissions and conversations about those situations. How do we mitigate those situations so that we ensure the balance that balance is met, Madam Speaker? For now, I look forward to perusing and conversing this as do my colleagues, and I commend this bill to the House.
Thank you. Now I'm just going to call Honourable Willow Jean Prime, but we're just resetting this clock. Mine's working and that one's working, but this one's not. So I can assure you, you have longer than 49 seconds. Honourable Willow Jean Prime.
Thank you, Madam Speaker. Thank you for the opportunity to take a brief call on the giving evidence of family violence amendment bill. Can I join with others in acknowledging and congratulating my colleague, Dr. Tracy McClellan, for shepherding through this bill, and it is wonderful to hear that there is support around the House for the bill to Select Committee, and acknowledge that the Justice Select Committee will be undertaking the submission process and doing this work on everybody's behalf. I do want to speak as Labour's spokesperson for children and add my support to the bill, because this bill is proposing to extend a range of protections for parties and witnesses giving evidence in sexual assaults or family harm in the family court to mirror those that are currently available to similarly vulnerable complainants and witnesses in criminal proceedings. And in particular, it highlights here automatic entitlement for children witnesses to give evidence in alternative ways instead of more stressful normal methods. And as others have pointed out tonight, while this is something that is already available in the family court, the court doesn't often use them. So by flipping that and the presumption being that this will be the preferred approach, I want to add my support to it. I was a neighbour and flatmate of the Dr. Emily Henderson, and we often talked about the family court and improvements that could be made in the family court. So I am pleased that this bill is here tonight and that there is support in the House for it. I'm sure she will be delighted to see this proceeding to Select Committee, and I encourage